to you all. We are honored to have in our midst today Honorable Mr. Justice H.S. Thankil, Judge in charge of the Meghalaya State Judicial Academy, Judge of the Meghalaya High Court. Thank you, sir, for taking your valuable time to spend here with us. Now, it is an honor and a pleasure to be standing here for today's workshop on the protection of children from Sexual Offences Acts 2012. The POCSO Act is a comprehensive legislation enacted to safeguard children from sexual abuse, exploitation, and to secure timely justice to victims of such abuse. May the courts, children are the living messages we send to a time we will not see, inspire us to endeavor towards ensuring a childhood which each and every child deserves to have. With these few words, may I request Ma'am Director to come and say a few words.
A very good morning to each and every one of you. Honorable Justice H.S. Thankil, a very good morning to you, sir, and to all the participants here. Just a brief idea about today's workshop. The Meghalaya High Court has extended an invitation to the Meghalaya State Judicial Academy to conduct this program, especially to focus on the POCSO Act and the other things which involves around this issue. Now, we're very happy that this whole program has got the support of the Honorable Chief Justice, Honorable Justice Sanjeev Banerjee, and Honorable Justice H.S. Thankil, who is in charge of the Academy, as well as the monitoring authority when it comes to cases pertaining to the POCSO Act, as well as cases pertaining to juvenile matters. Now, it is indeed a very great honor to have people from all sections, the police, judicial officers, BDOs, doctors, nurses, Anganwadi workers, members of the child welfare committees, members of the juvenile justice boards, counselors and other support staff, support persons, which are all enabling factors and enabling agencies, agents, in order to strengthen what is the aim behind the POCSO Act, as well as looking at what are the areas that can be addressed. We're very happy that this program also has received the support of Dr. Shaibia Saldanha, who has been a very strong activist in her own way, where initially she was an active gynecologist, but has changed her view looking at the welfare of children, where she has reached out to many sections of society, many corners of the state, as well as in other states, to look into the welfare of a child. Now, she has brought her team with her, and at the same time, we're also very happy to the police department for giving us Mr. Davis Marak, and at the same time, we have Dr. Wanswet, we have a judicial officer, and Mr. F.S. Sangma, we have a support person from the One Stop Center, Ms. Jill Marbanyang, and of course, we also have support persons as in the legal cum probation officer, and also a counselor in the institutional care support system from the social welfare department. So we have tried to get in as many as possible, the different people from different sections, believing that matters pertaining to the POCSO Act deserves extra care. It's not only looking at cases, it's not only looking at how we investigate the matter, it's not only at how much we dispose the cases, but we want to look beyond, where we are more sensitive towards this case, we are more sensitive towards our approach as a professional and as a human being. So without any further delay, I take this opportunity to welcome each and every one of you, hoping that you will take back a stronger message and a stronger motivation to work in furtherance the object of this act, and also in helping the society. Thank you.
I would like to request Iba Suchen and Lano Karmaulong, staff of the Meghalaya State Judicial Academy, to present the tokens to our Honorable Mr. Justice H.S. Thankil and our resource persons. So now, Dr. Saldanha and her team will guide us through the provisions of the POCSO Act 2012, the Medical Termination of Pregnancy Acts, by conducting a POCSO quiz and group activity. A glance at the schedule will give you an idea of the program for the whole day. So, Dr. Saldanha, I hand over the program to you.
Good morning. I'd rather stand. Thank you. Good morning. Thank you for such a wonderful audience. We will be talking, today's sessions will be primarily answering questions. I'm sure all of you have been hearing POCSO till it's coming out of your ears. So this is to look at what are the issues we are facing, because last year it was 10 years of POCSO. And while POCSO has been a boon for many reasons, it has also been a bane. And I work with Enfold, which we started in sexuality education in Bangalore in '99. And we have been working with children who have faced sexual abuse since 1999. And while POCSO has brought some sort of support and help, it has also caused a lot of problems. Before we start, I would request each one of you to think of 2 questions, doubts, queries or concerns you have with regard to the POCSO Act in your daily working life. I have sometimes, when I have worked with my colleagues at Enfold, and we have followed a child going through the system, criminal justice system, we sometimes say that if my child was sexually abused, would I step into the system? And to me, that is the fact that I, along with all of you, want to make a system such that if our children get abused, we have no hesitancy in bringing in a complaint. That is the important thing. That is the ultimate goal that we are looking at. How do we make a wonderful law sensitive? So I will give you 5 minutes before we start the quiz. So the program will be thus: we will be having a quiz on POCSO, and my 2 colleagues will be walking with the mics, and we will take answers from you. I'm not going to give you the answers, you have to give the answers yourselves. Thereafter, we will have a discussion on what is a new state which is called trauma-informed care. The medical examination, I have the kit here, we will discuss that. We will talk about newer legislations which have come in from Chief Justice Honorable Chandrachud's declaration on the MTP Act, on support for girls, minor girls who have faced rape or consensual sex, as well as some of the newer guidelines which have come up by police in Tamil Nadu, Kerala, where they have tried to make the system more efficient and easier, because the last policeman at that, police station somewhere in the block finds it very difficult to handle the POCSO requirements. So I'm giving you 5 minutes. Please think of 2 questions, and then I will invite some of you to just share the questions you have. Please think. If you can write it down, that will be great. And I hope that by the end of this day, your questions are all answered. Any 2 questions, 2 doubts, thoughts, concerns? Okay, so can I ask any of you to share 1 or 2 questions? And I would also request you to feel comfortable to speak in any language. If you would prefer to speak in Khasi or Garo, please do feel free. We have enough people. Language should never be a barrier for asking questions. So please feel free to ask in any language and we will get the translation. Yes, who would like to start the ball rolling? Anybody? If you can just raise your hand, the mic will come to you. Yes, please. Yeah. Kuni, you can take the mic.
Good morning, madam.
Good morning.
It's just something that's in my mind because we deal with this every day. So we live in the age of technology, and now everybody uses our smartphones. So I was just thinking, why don't we have an application which has, the procedures, rules, or the law relating to specific agencies? Say, supposing we're talking about an investigating officer in the field, which may be quite remote, and that person may find it very difficult, as you said, to completely comply with the provisions of POCSO, primarily because of ignorance also. So if we have an application which can work offline as well, supposing we say that, okay, investigation, you click on investigation, so all the provisions are there, and the procedures that are being followed are also there. Now, if you talk about, say, a medical officer, you click on it, and their duties and these ones are all available. The
Right.
touch of a button. Same thing with the CWC support person, etc. My question is that why don't we have this?
Let's do it. I think it's a great idea. We have already done this in Karnataka with the Karnataka High Court. We have made the SOPs for police. We have made the SOPs for medical officers and the SOPs for support persons. It is available both as a downloadable, as a document, but it is downloadable also. All we need is all of you to sit together and we can make the SOPs. I can give it to you. I think it's a wonderful idea because it's available, knowledge available at their hands, definitely. In fact, I have over here, which I'll be showing you. Tamil Nadu has given very good guidelines. The Tamil Nadu IGP of police has given guidelines over here for every police officer called Guidance on POCSO Act and POCSO Rules. As with Meghalaya, you will have your own set and also certain concerns and constraints for your state. We will do it. I think it's a great idea. Yes, thank you. Anybody else? Anybody else? Questions, doubts? Yes. Thank you, sir.
Morning, ma'am.
Good morning.
As a medical practitioner, sometimes we come across cases of underage pregnancy. In those cases, we are bound to report it to the police. But then the parents will literally beg us not to report because of the fear that they will be socially discriminated. In those cases, how do we approach?
So again, I have Justice Chandrachud's Supreme Court judgment, which has stated very clearly that if a girl comes with an underage pregnancy and she and her parents say that it is through consensual sexual activity, then while the FIR will be filed under 41B, the boy will not be arrested and due process will continue, but there will be no arrest. And if she requires antenatal care, she will continue to come for it. Or if she wishes to go for termination of pregnancy, she will be given all medical care, and there is no need for an MTP. You do not need to give even the name of the child. As long as she is under 18, she consents for a termination of pregnancy, her parents are consenting, then all you have to do is inform the police that a case has come. 16-year-old girl has come with 3 months of pregnancy for termination of pregnancy. They will put it into their diary, but nothing else has been done. I have got the judgment here, which I will show it to you. Yes, anybody else?
Good morning, madam.
Good morning.
Good morning, everyone. My question is this, ma'am. we've seen that POXO cases are very rampant, and mostly we're getting cases almost every week in our hospitals and mostly throughout India also, or maybe more than a week also. But the question is this, like besides having the doctors, the police officers, the judges, why is it so rampant that it seems that nobody cares, the community doesn't care about it? And why is it that nowadays even children at the age of 7, 6, 8 are aware of sexual activities? Where is the loophole, and what should we do about it? That's my question, ma'am. Thank you.
Thank you. I joined medicine in 1984. So I promise you I've been a long time in the system, much before JJ Act came in or the POXO Act. Child sexual abuse has always been there. It's not something new. It was just hidden away. Very often girls would commit suicide if they were pregnant because the family honor was considered a problem. But yes, after POXO Act came in, the number of cases being reported went up hugely. And I think all of you are aware, and there are certain, the Center for Social Justice in Delhi had done a study along with Tulir in Chennai, and they found that somewhere between 35 to 60% of cases of POXO were consensual sexual behaviors which were got caught into the system. We are not even talking of child marriages. So unfortunately those got slipped in, but believe me, the number of cases which have been reported are much, much more now, only because reporting has increased. However, there are two other reasons why sexual assaults have increased. One is internet, the easy availability of pornography to children. When the child is 12, 13, 14, and you would have heard 12, 13, 14-year-old boys, attacking a girl, a younger girl, a 7, 8-year-old girl. This comes from, it's not that knowledge wasn't there. If you look at our houses, and traditionally in smaller houses, the parents would be having sex in one corner and the children were all there. Everybody knew what was happening. But certain boundaries having broken, and internet stimulating the mind into creating a sexual desire which is not appropriate for the age, and they do not have sexuality education to teach them what is okay and what is not okay, how to maintain boundaries. That is one issue where we have allowed internet into our homes, allowed pornography into our homes, but have stopped the children from getting sexuality education. Second thing is drugs and alcohol. Many, many cases, particularly familial cases, father, stepfather, uncle, cousin, aunt, a lot of them have to do with alcohol. Because when you drink alcohol, there are certain levels of inhibition in your behavior which are taken away. And a lot of them give the excuse, and we will be discussing some cases where these boys said, oh, we were drunk on New Year's Eve, so this happened. I'm sorry, no matter how drunk you are, you don't rape somebody. Don't use alcohol as an excuse. But the easy availability of alcohol and drugs has increased adolescent sexual activity, definitely, and assaults. Is that clear? Yeah, okay. Any other questions? Any others? Doubts, questions, queries? Okay, then let's go ahead. We're going to start with the POXO quiz, and I would like you to answer. Can anyone tell me when was the POXO Act passed? When was it passed? Sorry, 2012. Thank you. Yes. We will start with the basics, right? Who is protected under the POXO Act? Everyone under the age of 18 years. Boys, girls, others. How does the POXO Act differ from the IPC 375, 377? Yes? Anybody? Can you use the mic so that we can hear it when you pass the mic? Yes, if you can just raise your hand.
It's a gender neutral act.
Excellent. It's a gender neutral act. What else? What do we mean by gender neutral? So in section 375, it was peno-vaginal. The penis entry in the vagina was considered rape, sexual assault. Section 377 was the penis in the anus, also called sodomy, was considered sexual assault. But here, and both times the perpetrator was male, the survivor or victim could be male or female. But POCSO says that anybody can be a perpetrator and anybody can be the survivor. So we know that it can be males, primary males because of power and authority, but females are also perpetrators. People who are transgender or consider themselves non-binary can also be perpetrators. In the victims, there are women, girls, more because they report it. But there are equal number of boys and girls who are assaulted. And specifically, children or young adults who are confused about their gender, confused about their sexuality. They may be homosexual, they may be transgender, they may be non-binary. They're like, I don't think I'm a boy, I don't think I'm a girl either. I'm not sure what I am. These children are particularly at risk because they are confused about themselves and they're not able to speak to their parents or adults in their life to ask, why do I think like this? Why am I not like my friends? So that is why the gender neutrality of POCSO Act comes in. Yes, thank you. Anything else?
Absence of consent in
Sorry?
POCSO.
Yes.
Absence of consent in POCSO.
Yes. So that means mandatory reporting. One is absence of consent. It is considered that under 18 years, there is no such thing as consensual sex. Because earlier we used to say 16 and above could say it was consensual sex, and then we used to not put a case. But now it has become that anybody under 18, and that is again a big issue last year when 10 years of POCSO came in, there is a lot of concern that can we bring down the age of consent to sex by 2 years to 16. People are still not clear, decided about it. Yes, thank you. What else? Anything else? What are the other differences between 375 and 377 and the POCSO Act? Yes, the body of proof. The burden of proof is on the accused. Unfortunately, most of our lawyers don't know that. We still have the adversarial system where we are haranguing the child and the family and the witnesses to give the burden of proof is still on the child. Actually, it is said in the POCSO Act, because the child is of tender age, 4, 5, 6, 8, 12, traumatized, and not understanding what has happened, it is very difficult for them to be able to furnish proof. The second thing is sexual assault is always a private crime. It is done hidden. So there are very, very rarely eyewitnesses. And so therefore, the burden of proof is put on the accused rather than on the child. Yes. Anything else? The one which gives us the most headaches? Sorry? Time? I'm sorry, I didn't get you. Oh, sorry. Time bound.
Yeah, it's a time bound that you have to complete within that specific time.
Is that good or bad?
It's good, madam.
Yes, it is very good. The first time I went to court for a sexual assault case, I saw the child in 1995. I was called in 1999 after 4.5 years. At that time, JJ Act had not come in, so it was, like a courtroom, sessions court. There were lots of lawyers, people all around. The accused was in the dock, and the child they refused to come because she was 9 when she was assaulted. She was 14 now. When I went to give evidence and I came out and I asked the policeman, so when is this case going to be sorted out? And she said, it won't come, madam. I said, why? She said, madam, that 14-year-old girl has refused to come to court. She says, I will not come to court. Because at that time, before POCSO Act, the defense lawyer could ask her things like, did you enjoy it? Did you like it? Why are you putting a case like this against my client? He is a father with 2 children, just like your father. How dare you talk things like this? And this sort of complete disrespectful conversations would happen before POCSO Act. Right, so that's one. So we are looking at the fact that the one I was thinking was mandatory reporting, right? Mandatory reporting has come in here. The POCSO Act also has much more than just peno-vaginal and peno-anal, because it looks like sexual offences which are non-penetrative. Because a lot of times with children, it's about groping, touching. It's not even peno-vaginal. It'll be with a finger, with a pencil. A teacher was assaulting a child using a pencil. So all these things are incorporated in POCSO, giving us much more ability to catch the accused. There are child-friendly procedures enshrined into POCSO. For example, that the child should not face the accused at any point of time. Earlier, when the police vehicle would leave the police to come to the court, the accused would be sitting on one side with his lawyer, and the other side would be the child and the family. And the terror that children have gone through during this time, and the accused is threatening them, sitting for 4 or 5 hours in the corridors of the courts, being almost assaulted by the family members and the friends of the accused. So those have changed. One very important thing is where the questions by the defense lawyer to the child are given to the judge. The judge asks them. This allows the questions to be spoken in a respectful manner without badgering the child or scaring the child. And the burden of proof, as you had mentioned, is on the accused. So these basically are the reasons why POCSO is a wonderful law, but unless we implement it, it's not going to work. Can anyone tell me why was the age 18 chosen? Anybody? Age of marriage? But that's only for girls. What about boys? 21, right? So definitely for girls. It is the age of marriage also which has gone to 18. But can you tell me why we chose 18 years? This is because India is a signatory to the UNCRC of 1989. The United Nations Convention on the Rights of the Child, which considers every human being below the age of 18 years as a child. India signed it in 1992, and once we signed it, it was important that we have to bring all our legislation in the same way. However, it doesn't always happen, right? Because we have child labor, 14, we have RT up to 14, we have other different things. For even boys and girls, we have marriage at 18 for girls and marriage at 21 for boys. So, in fact, there's often a question that if we consider boys over 18 to be an accused and to be a perpetrator, and even a 16 or 17-year-old boy to be treated as an adult accused, why do we allow them to get married only after 21? Apparently, boys are still not mature enough to get married at 18, 19 or 20, and yet we say that they are to be treated as an adult in terms of the perpetration. Now, how does this age limit help? Can anyone tell me how does it help to have 18 as an age limit as for a child? Anybody?
It removes ambiguity.
It removes ambiguity, yes. Specifically, there are 3 or 4 very important areas where having a child under as 18 years is important. They cannot be admitted into the armed forces. You are aware of child soldiers across the world. Wherever there are conflict zones, children are picked up and forced. But in this case, it becomes an international convention and an international crime if you bring children into the army below the age of 18. Children under 18 cannot work in hazardous occupations. So whether it's chemicals, gunpowder factories, ordnance factories, whether it is mining, they cannot be allowed to come in. And they cannot be used in pornography or prostitution or any other commercial sexual activity. So these are ways we can protect the children. Because earlier at 16 or 17, if a girl was pushed into prostitution, the girl would be forced or threatened or coerced into saying, actually I wanted to do it myself. It's consensual. But we are looking at 18 at least as a upper limit. How does the age limit harm? How does having 18 as an age limit for consensual sex, that means below 18 you cannot have consensual sex, it is harmful to our children? Anybody? What is the
This
biggest
is, I
headache?
think, one of the topics we'll be discussing today, because biologically, if we look at it, awareness about sex or puberty happens much before 18. And hormones, as we know, are one of the driving factors to human actions. And even in children up to the age of 16, the neurons in the brain, which is attached to consequence, and responsibility for their own actions are not yet completely fused.
At what age do we consider that the brain is fully developed to be able to make decisions like critical thinking and decision making? Anybody? At what age, where there is psychologists and doctors and lawyers have sort of agreed on an age? Anybody? 16? Yes, no? 16, yes or no? Just tell me yes or no, just shout it out. Do you think that 16 they are mature? No. 18? 18, are they mature to make decisions about their life? Still no. Some yeses. 20? Yes. So the age for maturity for the brain development to complete is 22 to 24 years. However, when I ask children, when I go to schools and talk on sexuality education, and I ask them, why do you grow up? They say, to become mature. I said, okay, what does mature mean? You know, to be like a mature adult. I said, oh, excellent. Do you know people who are 40 years, 50 years, 60 years who are not adult and not mature? And they're like, yes, ma'am. So maturity is also something which develops. You have to have the space for it. But we do know biologically it's 22 to 24 years. So even 18 is not an age where they can make effective decisions. So the age limit is basically harmful because it makes all adolescent sexual exploration as criminalized. And that is very, very sad, and that is the problem that you are all facing. There even young people sitting in a park caught kissing end up with a case. Some children have ended up having sex, have got drunk at a party, started getting necking around with each other. It becomes a case. Any adolescent pregnancy is stigmatized and liable for legal action. This is a big issue. I have worked in the last 2 years in Meghalaya. I have visited 32 households of women who died in pregnancy. From Mahendraganj, Zigzag, Bita Singh, Tikrikila, to Saipung, to Dauki, to Mawet, in most of the far off areas. And what we have found is the teenage pregnancies are very, very high. And the teenage pregnancies, when they get pregnant, they refuse to tell. The woman will say, no, no, I don't want to go anywhere. I'm not pregnant. But something must be wrong. No, when we asked the mother, she said, I kept asking her, is something okay, right? She said, no, no, I'm okay, I'm okay. Finally, when her tummy is showing at 7 months, then forcefully they call the Asha or the A&M and the child is taken for a checkup. The parents are upset. The A&Ms and all try to give her medicines. The girl is ashamed. She is embarrassed to go to the hospital, even if it's consensual. If it is sexual activity, she feels it is always her fault, and that is the problem, that our social norms blame the girl. So they don't go. I have had 5 teenage pregnancies out of those 32 women where they went, and finally she was not taking her tablets properly. She was reluctant to come for her checkups. Her hemoglobin was 7 grams, 8 grams. She had high blood pressure. She gets up in the middle of the night to go to the bathroom. Her parents hear she's fallen down. They rush out. She's throwing convulsions. They pick her up. By the time they get her transport, by the time they come to the hospital, she's frothing at the mouth and she dies because of eclampsia. Her blood pressure of 180 by 120. Eclampsia is a completely preventable death. In another case, the girl was not willing to tell anybody. Finally, the 6th, 7th month, she was persuaded to come for checkups. Nobody knew whether she was taking the tablets very well. She delivered at home. She delivered a very small, weak baby who died within 6 hours. Can you imagine the trauma of a 16, 17, and these are 17, 18. Now the new story is everybody writes 19. So now we suddenly see from last year, 2021 to 2021, 22, all the teenage pregnancies are gone. They are all writing it as 19, 20, 21 to avoid the headache of the POCSO Act. But the child is not getting the care they need and they are suffering. Worse, they're dying and the children are dying. So the denial of right to access safe abortions came up, which was the MTP Act, which we will discuss a little later. And of course, the criminalization of the partner with stigmatization and social humiliation. The boy is picked up. He is as ignorant and unknowing as the girl. And it was consensual sexual activity which neither of them were actually even aware they were going to have. When I've talked to some of them, they said, No, we were just holding hands. We went behind the, we went in the room. I don't know what happened. I said, did you have sex? She's like, I don't know. I don't know what sex is. But she's pregnant. And the boy is picked up and he's put into jail. He's put into, right now, if he's under 18, he goes to the JJB. But even observation homes are scary places. And a boy, for an act of ignorance created by a society and by parents and educationists who refuse to have sexuality education in school, we are dumping the children in the deep end of the pool. Can you tell me why is there mandatory reporting? It's such a headache for us, right? Counselors call me up saying, ma'am, my patient has come. We have no statute of limitations. So if her counselee who's 35 years old says that when I was 12 years old, I was sexually abused by my uncle, actually she's meant to report it. It has nothing to do with when POXO was passed. It has nothing to do with now her present age. The counselor says, what do I do? Do I report it? So why did mandatory reporting come in? Can anyone tell me? Why did mandatory reporting come in? Why was it put into POXO when it is not there in most of the other cases? Section 19 of the POXO Act states that any adult is aware of a case of sexual assault or even aware that it is about to happen, suspicion that there may be sexual assault which is going to happen, they are duty bound to report it. Normally this comes to counselors, doctors, police officers, teachers, school, principal, people in this authority. It doesn't entail parents and not the child either. There is no mandatory reporting for the child. But why did it come in? Can anyone tell me? Why did mandatory reporting come in? We keep complaining about it.
I think it's because of the nature of the survivor, the victim. And this exponential rise that we talk about in POXO cases is primarily because we have this. If it wasn't there, then I think we still would have a very low count of POXO cases. And this is a sort of a wake-up call to everybody, because not about the after, reporting after. It's that it may happen.
Yeah.
So when you are aware of circumstances which may lead to such a situation happening, the idea is prevention is better than cure. So this mandatory reporting, to a large extent, if we follow it diligently, it may help prevent this kind of offences from happening.
The basic reason mandatory reporting came in is because responsible adults did not act to prevent abuse. People knew, teachers and principals knew it was happening. Parents, families knew. The number of my patients have told me, I was being abused by my cousin, by my brother, by my aunt, by so-and-so, by my uncle and my grandfather. And I told my mother and she said, keep quiet about it. Don't talk about it. It's your imagination. You must have done something. So as responsible adults, we did not take action. The another thing is for doctors. Doctors did not report pregnancies arising from sexual assaults. As you know, we have seen many, many institutions where children were kept and they would get pregnant. They were used by the people in the institution, as well as people from outside would come in. In Tamil Nadu, near the Meenakshi temple, there was a NGO started with children, and there would be people coming in from abroad who were the donors. They would come in and they would give money, and everybody would, welcome them. And actually what they would do is they would get rooms over there to misuse the children and sexually assault the children. And all these would happen. So doctors did not report pregnancies. Even patients would come. And this happened with me also when I was doing my MD in 92. This girl came in, she was 13 years old. She was a child suffering from Down syndrome. She was brought by her mother. Her mother was a lady who worked in a house. And her child, because she was a Down syndrome child, she would be taken across over there. And because she would come over there, the mother didn't want to leave the child at home because she was scared the child would get assaulted at home. But when she came over here, they were brought across and they would continue. I'm sorry, that is my phone. Tina, could you just switch off my alarm, please? Thank you. So what would happen is this child was brought to the household where the parents, where the mother worked, and was kept there where the mother would work the whole day. But unfortunately, somebody in the house was molesting her, so much so that she became pregnant. And then when she became pregnant, the arrogance of that lady, because that lady also came to the hospital. I was in second year, MD. We didn't know about sexual assault in those cases. We knew this was wrong, but we didn't look at it as sexual assault. That lady comes in a fashionable car and she gets out with this poor lady and her child. They come out and they say, oops, sorry. They come out and she says, oh, you know what? I don't know what has happened with these children. These girls, from the villages, they are like that only. So, I brought money. Poor lady, she says if she goes home to her village, the husband will kill the daughter. So, I brought money for her. Let her stay in the hospital. You please do what is necessary. And she walked off. And the mother was sitting there and crying. The girl was already 7 months. At that time, we had 20 weeks was the MTP Act. So we kept the child in our hospital for 2 months. I was working in JJ Hospital in Bombay. We kept the child admitted for 2 months. The mother was with her. She was fed over there, taken care of. And the thing is, because she was eating well, the baby was very large. She was just 13 years old. So we had to do a cesarean. The baby was born, healthy baby. Then we had to arrange for, the mother didn't want the baby at all, the grandmother. So we had to wait for, the adoption process through the court for the child to be shifted to the orphanage. And the mother and the girl went home. I mean, the disrespect to that child. That is the first time I came in contact with a sexual assault case. So we as doctors did not take care. Thank you, sir. We as doctors did not take care of those young children who came to us for sexual assault. There was no reporting done. We preferred to believe the family, where the family says, it's okay, don't report it. And that way, the sexual assaults continued. In one case, this first case I was talking about, 1995, when this girl came to me, she was a 9-year-old girl who had been brought with severe pain and inability to pass urine. So her mother brought her with high fever. She went to the pediatrician at St. John's. I was working at St. John's in Bangalore at that time. The pediatrician looked at it and said, this looks like herpes zoster, it looks like a sexually transmitted disease. Refer to dermatology. They went to dermatology. Dermatology took a smear and they said, oh, this is definitely herpes simplex type 2, sexually transmitted disease. So they sent it to gynecology because we are apparently meant to be the ones who understand child sexual abuse. We didn't. I wrote out the findings and I told the mother that definitely there is some abuse. Can you talk about it? Can you tell me? Mother said, no, that's not possible. I stay at home, I'm there, my husband goes to work in the morning, comes back in the evening. This girl is 9 years old, her brother is 5 years old. I take them both to school in the morning, I bring them back. I'm in the house all day, there's no question of abuse. You're talking rubbish. And they went. Once they went off, after 5 days, the child got very high spiking fever, 103, 104, was admitted in the middle of the night to the pediatric ward. And again we spoke to the parents. And by that time the report also had come, official report. So they spoke to their family doctor who very sensibly said, yes, this definitely seems to be a problem. Can you just find out? And we found out that the girl's classmate stays next door and they would all go to school together. The classmate and her smaller sister, their father was abusing this girl. He would sexually abuse her. Whenever they would run into the house to drink water, play in that house, he would be sexually abusing this girl. So they came to me and said, we are putting in a case. I said, fair enough, you can do that. We had given the documents to them, medical legal papers were given. They filed the paper. 1995. 1999, the parents came to meet me, said the case has come in court. Can you please come? I said, yes, definitely I will come. I said, what is happening? They said, the parents, the husband said, they was immediately put into jail at that time, he was arrested. And they said that he is saying his wife came to their house begging them, saying, I have 2 young daughters, they were very small, they're same age as your daughter, please don't do this, once you take him away, who will take care of my children? So the parents said, I'm sorry, but did he think of my child when you're talking? You have children just like that and he had no problems abusing my child, I'm sorry, we're not taking the case back. So the wife came back after 15 days and she said, please take money. I'll give you 30,000, 50,000. Please take money and, please take back the case. They said, don't you get it? This is about our kid. We are not going to take the case back. They said, I'll give you 1 lakh. They said, I am not going to compromise. And then that lady said, earlier we used to live in that other area in Bangalore and similar thing had happened. But they took 30,000 rupees and they took back the case. That is the way it works. So every time a case is compromised, we allow an accused to walk out and say, I can handle a system, it's fantastic. I can abuse as many children as I want. Because you know what? Nobody's bothered. And so our social norms are considered more important than the child's physical, emotional and psychological well-being. And as you know, with the same case, when I went in 99, the girl was 14, she refused to come to court to be badgered by the defense lawyer, and ultimately the accused was released. So we do not realize how the assault affects the psyche of the child. More than that, it is not just the fact that the children have been abused, but the fact that the family refuses to support the child. That betrayal is worse than the first betrayal, because the accused is a criminal. We look at him as a criminal mindset. He is a bad person. But my parents are good. Why aren't they protecting me? Why are they letting him escape? Because they're more worried about what people will say about my family than about me personally. What are the offences under POCSO Act? Can anyone tell me? Anybody? Anybody from the back? What are the different offences? Sorry? Sexual harassment? Yeah, I'm sorry, I can't see. Yes. Can you put up your hand? I'm not sure where you are. We'll get your thing. Yeah. Thank you. Yes. Sexual harassment?
And then penetrative sexual assault.
Yes.
Then using the child for pornography.
Excellent, yes. Wonderful. So there are so many different levels of sexual assault which have been brought into POCSO, which is wonderful. So we talk of Section 3 of the POCSO Act, which is penetrative sexual offences. Section 7, which is non-penetrative sexual offences. Section 11, which is sexual harassment. Section 13, which is use in pornography. All these are part of it. So, and 16, 17, aiding and abetment and attempt. This is like a principal knows the teacher is assaulting children, principal does not know anything. That is considered aiding and abetment. Or in a very horrifying case you would have heard in the UK, a British citizen was abusing children of 13, 14 and then he would pay them money to get other children to come and get abused. Why are some offences considered aggravated sexual offences? Can anyone tell me that? We have sexual offences 3, 7, 11 and we have aggravated sexual offences, which is Section 5 and Section 9. Why are they aggravated? Yes? Nature of the crime as in? In which ways is it more heinous? Repetitive, okay. So when we consider it aggravated, the same, penetrative or non-penetrative, it is because it is committed by a person in authority or power or trust. That could be a relative, principal, teacher, head of an institution. It can be doctors, hospital staff, nurses, police, army officials, anybody who is in a position of power, authority over the child will be considered aggravated, which makes it a more heinous crime. If the child is less than 12 years, it becomes aggravated. When weapons are used, knife is used to threaten, gun is used, they are burnt with cigarettes, burns. When there is a gang assault. When the assault results in physical or mental disability, whether permanent or temporary. I think you must have heard in Rajasthan there are at least 5 cases of girls who were sexually assaulted who ultimately committed suicide. The number of children I know who have been assaulted who have gone into severe depression. They have dropped out of school. All these are considered a direct consequence of the crime, and this is considered as aggravated. When the assault results in pregnancy, in HIV infection, or in mental illness, it is also considered aggravated. So, if we look at quickly run through the offences, section 3 was penetrative sexual assault, where it has changed from just peno-vaginal, it is oral, anal or vaginal rape. In many cases of children, there was one case in Bhopal where the person was convicted. It was a doctor, and he was sexually abusing his brother's daughter's friend. So he stayed with his brother and brother's wife and this daughter, and the girl would bring her friend over, and he would force her to do oral sex. Finally, the child told her mother, the mother complained, the whole system. You know what he said in court? He said, you know, I'm very sorry, but I understand what is important in a girl, that her virginity should not be affected for her future life. So therefore I had oral sex and I did not cause any harm. So therefore I have not caused a problem. And actually, because section 375 and 377 were the only ones, it did not come in that. And the only other one is section 354, which is outraging modesty of a woman. He would have escaped, except that it went up to Supreme Court, and the parents of the girl had the money power and the determination and the commitment to their child to fight it all the way to the Supreme Court. But he actually had the guts to say something like that. There are people who said, I'm a very old age, please do not arrest me, please give me bail. And your old age didn't stop you from abusing a child. How does that work? So even penetration of any manner, with a finger or an object, as I said, pencils, anything is considered penetrative sexual assault. It's aggravated if we had said, as the earlier ones, personal authority, weapons, physical incapacity, pregnancy. Section 7, so that was section 5. Section 7 is sexual assault, non-penetrative. So fondling, groping, pinching the breast, touching the child, fondling the genitals, often happens in schools among boys. These are considered non-penetrative sexual assault. Aggravated sexual assault, as similarly as the earlier one, personal unauthority, child is below 12, it's a gang assault, all these are considered as aggravated. Section 11 is sexual harassment, there's no contact. But there are sexual gestures which are unwelcome, exhibitionism, the person may be pulling off their pants or undressing in front of the child, watching a child undress, exposing the child to pornography. There was a principal in a school called Trio School in Bangalore who would call students into his room and show them pornography on his laptop. And he would say, this is for you to understand what you should not do. Exposure to pornography, stalking, blackmail, enticement or gratification for pornography are all under sexual harassment, 11. 13 is pornography, use of a child in media. So whenever there is an accused who has done anything, what we find in India are a lot of pornography rings. So a person, adult who sexually abuses children, he wants to show people he's done this. So they have rings on the internet, on the dark web, where they will take photographs of the act or the child naked or involved in a sexual act, and they put it online. They want to show others. And that is why the moment there is a case of assault, the first thing which should be done is the phone, devices, laptop, desktop, anything of the accused has to be taken away immediately, because definitely they have found child pornography on it. Adult pornography is people's wish. Over 18 years, somebody wants to make pornography films, their choice. People want to watch it, that's their choice. But under 18 or a child in any sort of pornographic material or just photographs of a child naked are a crime. So any electronic or printed form for personal use or for distribution, if a use of a child in media, representation of sexual organs of a child, usage of a child engaged in real or simulated sexual acts, indecent or obscene representation of a child. The second biggest profession in the world right now on the dark web is getting pornography pictures of children. And people use it to load, and there are millions of photographs like this on the net. Where will the interview be conducted? Once there is a report, where should the interview be conducted? Sorry? At the residence of the child, yes. Why? Why not at the police station? Comfort. So, we say that at any place where the child is comfortable. This could be the home. There should be privacy. Because sometimes when children are at home, the parents worry that all the neighbors will come. You know how our houses are, right? One person comes in, somebody comes. Even if the policeman is meant to be in mufti and they come in, the whole village will be there. What's happening? Right? So sometimes they're not available. So that thing is very important for the investigating officer to also look at it, that maybe at home may be difficult for the family. So at a hospital or health center, and in all our hospitals, we are meant to have a one-stop center, right? We are meant to have a room which is private, which is away from the casualty and the labor room. At the Child Welfare Committee or the DCPU premises, they can have a room where you can have the interview over there. It's very, very important to give that respect. When the parents come to file the report and people say, please don't come to my house to talk to my child. Okay, where would you like to go? Okay, we can go to the hospital, we are going for the medical examination, can we have a room over there? Can we work in the CWC or the DCPU office? Can we have a room over there which is quiet, where not everybody marks out this child? It's very important. But not at the police station. No child should actually be interviewed in a police station. Now, who is going to interview the child? When the complaint comes in, who is the person who interviews the child? Anybody? Who is meant to interview the child? We are talking of the criminal justice system from the police. Who will interview the child? Child welfare officer, yes. So the child welfare officer, who is a police person, who is official, who is any police officer not less than the sub-inspector in rank. And for a female child, there must be a lady police officer. The investigating officer, IO, can be male, but the person who talks to the child should be female. This is very, very important. It does help to some extent. This is not to say that male officers are not sensitive. There are male officers who can be very sensitive, and there are female officers who can be extremely insensitive, just like doctors. You can have female doctors who are horrible and male doctors who are very kind, and vice versa. It is more on the nature of the person. And training. Training teaches me how do I ask questions in a respectful manner, irrespective of my gender. Who all will be present during the interview when the police officer is interviewing the child? Yes? Yes. There will be, the child will always be accompanied by a guardian or a person trusted by the child. This is often the parents, but in some of the cases where we saw where the child was an orphan, parents had died, so there was the grandmother, or it can be anybody else who is a guardian. So these are very, very important, that the child will always be accompanied under no circumstances. And this used to happen earlier, I know, in Bangalore, where the police officer would say, go and wait outside. I will talk to the child. This can only be done if the girl child, if she's 14, 15, 16, she's scared of her parents. The parents have put the case, and she says, I don't want my parents here. I don't want them to listen what happened. That is the only time that you will listen to the child. When is the medical examination done? So do we send all cases of POXO, the moment a POXO is thing, do we send them all to the police for the medical exam? Every child. So sexual harassment, they were showing pornography to this child. So the cases come for this principal, for example. Principal was showing pornography to these boys, class 9, 10 boys, on his laptop. Should we send them for a medical exam? Yes, no? No. So, when there is medical examination is to be done when there is any injury requiring medical care. If the boy said that the principal tried to do something or touch them, then we would send for medical examination. Or of course, if a child has come in with tears, injuries, bleeding. When there has been penetrative or non-penetrative sexual assault in the last 96 hours, according to the medical guidelines, after 96 hours, you will not get any evidence to collect in terms of swabs. You can examine for injuries, but do not collect swabs. The FSL is full of swabs collected by doctors for girls who are come pregnant at 3 months, 5 months, 6 months. Why would you collect a vaginal swab? She's pregnant. Can there be any doubt? So don't unnecessarily do it. For any of you, I promise you, for the women over here, if you have had a per vaginal examination, for men over here, if you had an examination for your prostate, believe me, it's something you don't want to have unless it's necessary. Do not put the child through that. So there is penetrative, non-penetrative sexual assault in the last 96 hours. Medical examination should be done at the earliest. When the child is possibly pregnant, requiring antenatal care or a medical termination of pregnancy, please take it earlier. Yes. Mike, please.
Yes, thank you, madam. Sorry, I'm very interactive.
I'm happy.
So, anyway, about this particular requirement of medical examination.
Yes.
One thing I noticed when I take up these cases, eventually when it comes to trial, that sometimes the medical examination of the child is not completely done, as in of the private areas, because the child says that, oh, he only touched me. So then they didn't examine. But when we take up the evidence later, we find that the child then starts disclosing other things as well. So when we talk about an allegation of penetrative or non-penetrative, my opinion is that sometimes I think we will have to examine, because the child may not disclose the entire situation or the circumstances because of many reasons. So
embarrassment, fear, shame, I understand. So I will tell you two places. One is, there was this boy who was brought to me who was 7 years old. He was playing with a ball in the, come home from school, he was playing on the road with the ball, and the ball fell into the neighboring house where there was a PG for men. When he went inside, one of the men said, "What are you doing here?" So he said, "No, my ball has come in, uncle." So he said, "Oh, you come inside." He took the boy in and he pulled down his pants and he pushed his penis into the child's mouth. The child tried to struggle, but the man was holding his hair very tight. Finally, the child managed to push himself away and run out. He came home and the mother said, "What happened? You finished playing?" He said, "Yes." He went into one corner and sat there. When they came for dinner, he came inside, he sat down, and when he started eating, he started vomiting. So the mother said, "What happened?" "Oh, there must be too much spice in the sambar." So she gave him a little light rice. Again, he vomited. So they got worried. They said, "What happened?" He says, "No, my throat is paining," and he started crying. So they said, "Okay, you wait for some time." Then after some time, the mother gave him a little milk to drink. Again, he vomited. So they took him to a nearby clinic, and the doctor said, "Oh, it must be throat infection." So he just gave him some paracetamol and sent him back. Child came home. He took the paracetamol and vomited again. But by now the child was a little calmer, and it was 10:30 at night, so the parents decided to let it be. The child slept. In the morning the child got up, the mother had made breakfast, she was getting ready for school. Again he vomited. So the parents got worried, they went back to the doctor and they said, "He's not eaten anything since yesterday afternoon." So the doctor said, "Oh, then I think we have to put a drip for him." The child started crying. He said, "I don't want an injection, please don't give me an injection." And then he told them what had happened. So immediately the parents went for the medical examination, for the police reporting, and the child was brought to me for medical examination. I asked a detailed history of the child, and I also asked, did any of your other clothes were taken off? Was your sweater, your shirt, your pant, did he touch any other part of your body? And the child absolutely said no. So I examined the child. I took swabs from the mouth. I examined the child. I found that there was tenderness on the hair where the hair had been pulled. So I noted down the injuries where there were some hairs which were torn. There was a little bit of scalp bruising. In the mouth, there was nothing inside, but I took buccal smears. We take it in oral sex. We take it from behind the last molar. He had only 2 molars because he was 7, I think. So I took the swabs, 3 sets of swabs from the buccal mucosa. But I also wrote in the report that the child has washed his mouth out many times, vomited many times. So the possibility of evidence may be less. But I have taken the smears, but you also have to give this. So whenever you do something, I also wrote very clearly the narrative of the child as to what all had happened, and nothing in what had been said made me think differently. But I wrote the reasons, that this is the narrative, this is the reason, these are which has been done, and the child did say he was barely there for 5 minutes. So I did not do the genital examination. In another case, a girl was brought to me. She had already been seen by medical officers, and the mother said that when she was walking back from school, 3 boys attacked her. They started pulling off her clothes. They tried to pinch her and hug her and all, but somehow she escaped and she ran away. When they went to the medical examination said no evidence of injuries other than some scratch marks on her face. The lawyer had a doubt, so they referred the child to me. When they came to me, I spoke to the mother and the girl was 16. And then I said, can I do a medical examination? Because I had a doubt. I said, how many hours, how long did they harass you? They said, at least a couple of hours they were going on. Finally, I managed to push them over and go. And in my mind, there was a doubt that sexual assault has occurred. So I said, can I do a complete medical examination for you? They said, yes. This was almost 2 months after the assault. So I said, I would just like to examine you completely, if that's okay with you. She said, yes. I said, do you want your mother to stay here? She said, no, I don't want my mother to be here. Asked the mother to stay out. My nurse was with me. I examined the child from top to toe, and then I examined the genitals, and I found some tears, old heel tears. I asked the girl, I said, you have mother and you have taken the trouble to give this case. Can you tell me, was there assault or not? She said, yes, there was, but my mother said, don't say that because then I won't get married. In this case, I did the entire examination. I wrote my findings of penetrative sexual assault with heel tears, and the 3 boys were convicted. So, I would love it if doctors use their ability to take a history to get a good narrative. And if there is a doubt, definitely do the full examination. But putting a child through a genital examination when they are very clear. Another girl came to me, 10-year-old girl, she was walking to school. This man came rushing out, and he came and he pinched her chest very hard and ran off. She came running back home and she was in tears, she was shaking. Mother came to the police station, they came to me. I asked her what had happened, she was still wearing her uniform. I said, did he take off your clothes? Did he touch you anywhere else? She said, no. I just examined the top of her body. I checked, there was a little bruising around the breast, little tenderness. There were no injuries because she was wearing a sweater and her clothes. I wrote down my findings, I wrote out the narrative, and I wrote in the medical examination, because when it comes to court, the defense lawyer will say, you did not do a genital examination, did not take swabs, that means it's a false case. So there, the doctor has to write exactly why you did what you did. And I wrote down, this was the narrative, this was it, and therefore genital examination is not done, clothes are not collected, no swabs are taken. And I will answer it in court. So it's very important that doctors feel confident to do it and confident to always take care of the child. The best interest of the child is the first thing. If the child is possibly pregnant, we've had so many cases now, we know with the MTP Amendment Act, it's gone up to 24 weeks. But people find out they're pregnant when they're 20, 22 weeks. By the time they come to the court, it's 24, 28 weeks, and they have crossed the limit for termination of pregnancy. This is a complete crime against a child. If there is any doubt of pregnancy, medical examination has to be started, and the child can go for the MTP immediately while the process is going on. If a girl comes to me who's 22 weeks pregnant and she says, I was assaulted, raped, and I am pregnant right now, and I do a scan and find she's 22 weeks, and I ask her, do you want to continue the pregnancy or do you want to terminate? And she says, I want to terminate. I will admit her immediately. I will do her medical tests to check that she is healthy, and I will start the MTP the next morning, because I cannot wait for her delay. I will send the police report, I will send medical legal examination, I will do all that is necessary, but the child is my patient first. She is not a case. So I will start the MTP, because an MTP is a medical emergency for this child. Imagine any of you that you are assaulted and then you have to continue to term carrying the pregnancy of a rape. It is harmful for you and traumatic to the child. If the child is psychologically traumatized, we also want a doctor to check, preferably a psychiatrist or a mental health professional needs to see them. I think one of the issues that we do face is that we have a lack of counselors. If a a child survivor of sexual assault is brought to a private hospital, what should the doctor do? Yes, from the medical people. So you're working in a private hospital, and this child is brought in. She is around 12 years old, and the parents bring her in, and she's crying, and they said, she went out to, go to the bathroom, and then we heard her crying, and we went out and found her clothes have been removed, and she's having bleeding, and we brought her here. What is a private doctor to do? Anybody? Yes, doctors? What should a doctor do? Police? If you take the child or you're told by the doctor that the child, what would you suggest? What do you think the doctor has to do? It's a private hospital. So look at the options. The doctor must immediately send the survivor to the nearest government hospital. Is that correct? Yes, no? The child is a patient. The child is traumatized. Supreme Court judgment states that any doctor, registered medical practitioner, either in a private hospital or a government hospital, has to examine the child. You cannot push the child away. The doctor cannot treat the survivor without a police requisition or a court order. Is that right? Can the doctor say, go get a police order or go get a court order? They cannot. It is a medical emergency. They have to give treatment. The doctor must give emergency medical care free of cost. Is that right? Free of cost? Doctor will lose his job in the hospital? Or the doctor should do a complete medical and forensic examination and inform the police. Which of these? Ideally, the last one. The number of times a child is repeatedly examined, you're losing evidence. It is also traumatic for the child. We have had cases where in one of the cases we'll discuss in the afternoon, where the child was brought, medical examination was quickly, just some medicines was given. Oh, she's having pain, give her paracetamol and give her some betadine wash, give her some antibiotics, you go to the government hospital. By that time the evidences got lost. The child has to go through the examination all over again. Very, very traumatic. Because please understand, when a child has been sexually assaulted, particularly genitally, the medical examination itself feels like an assault to the child. How many times do we have to have that? So all private doctors and Indian Academy of Pediatrics plus FOGSI, the Federation of OB-GYN, have stated clearly that a private doctor can do all the examinations, right? But at least the doctor must give emergency medical care, and it should be free of cost. They should not be charged. Who can conduct the medical examination? Very often, they come to the casualty officer. Casualty medical officer will call the pediatrician. The pediatrician will come, say it's a girl child with sexual assault, call the gynecologist. The gynecologist PG will come, they'll say, oh, I don't know how to write this, I will ask my lecturer. So by the end of it, some 6 doctors have passed through. So who can examine medically a child who has been sexually assaulted? Anybody? Whoever's at duty. It can be any registered medical practitioner. As per the POXO Act, any registered medical practitioner. As for now, it's still MBBS. So Ayush doctors and BAMS doctors cannot actually sign on it. It is only an MBBS doctor. But MBBS doctor is sufficient in a private or a government hospital. If there is any specialist like a pediatrician, gynecologist, surgeon, they can also, pediatric surgeons can do it if the child has come to them. They can examine the child. But there is no need to delay the examination waiting for a specialist. Frankly speaking, a trained doctor, MBBS, is better than an untrained pediatrician or gynecologist. Training is the key. For a female survivor, a female doctor should examine the child, right? Now what happens if there is no female doctor in some of the district hospitals or even in the PHCs? There is no female doctor. What should be done? Informed consent right? So here, in the absence, earlier what would happen is the child will be dragged some 100, 200 kilometers to another hospital where a female doctor would be there. Sometimes also what some of the women doctors have told me is if there's only one female doctor in a hospital, she ends up being the person who does all the sexual assault cases. So whether she's on duty or not, she's pulled in. So in the absence of a female doctor, a male doctor in the presence of a designated female health staff can examine the child, as you said, with informed consent. Consent is by, even if it's a female doctor, if the child doesn't give consent, they cannot do an examination. So here, a designated female health staff may examine the child. But always, who else has to be in the medical examination room? The person trusted by the child at all times. So who will give this informed consent? Who gives the consent? All of you seen the form, right? On that there is right consent. Who will give this consent? Below? Yes. Any child over the age of 12 years, thank you, can give consent for themselves. They will give consent, provided it's not a invasive. That means MTP, they cannot give consent. But they can definitely give consent for a medical examination and collection of forensic evidence. If the child is below 12 years, so sometimes we have the parents saying, do the examination, and the child says, no, I don't want it. Very often in consensual sexual activity, the parents are saying, no, do the test. We want to know what has happened. And the girl says, no. Whom should we listen to? Parents or the child? Always. For a child below 12 years, the parent or guardian will give the consent. But above 12 years, the child can give consent for themselves. You do not need the parent's consent. Suppose a child is a found child, an orphan, come from an institute. In the absence of any guardian, a hospital committee comprising of 3 or more designated staff may give consent only for life-saving or medical care. So suppose a child is found, a 10-year-old child was found at a bus station in a very bad condition, needs medical examination. You bring the child to the hospital and the police cannot give consent, right? Police cannot give consent. Even the child line or anyone else cannot give consent. So in that case, for the immediacy of the need for the child to get medical care, every hospital should have a designated committee of 3 people. The RMO, the CMO, maybe the medical superintendent, any other person or the nursing superintendent. These 3 can say, okay, this is a child who has come. I don't think the child needs to be examined, or yes, the child needs to be examined for medical care, and they will sign the consent form stating the reason why. If the child comes from a childcare institute or it is not an emergency, but suppose the child is pregnant, a 14-year-old girl is found to be pregnant at the bus stop or found abandoned somewhere. She has been put into the childcare institute. In that case, the Child Welfare Committee has to give the order for a medical examination, and that will be what the doctor will listen to. The Child Welfare Committee can also give orders for termination of pregnancy, because right now the child is pregnant, she is not wanting to continue the pregnancy, but she has no adult in her guardian with her to give consent for an invasive procedure. So the Child Welfare Committee can give the order for termination of pregnancy with the girl's consent. We do not need to go to court for that. So, as we said, who can be present for the medical examination? A person who is trusted by the child. That means any parent, guardian, anyone can be there. What do we mean by informed refusal? Is there something called informed refusal? Informed refusal is when the survivor refuses to give consent for a medical examination even after counseling. So you talk to her, you tell her it's good for her, we need to check you up. She says, no, I do not want. She's over 12 years of age and she says, I don't want it. Her whole family, the entire clan can sit on the head of the doctor and say, do it. The police can say, we need a medical report, otherwise we can't file the FIR correctly. The doctor cannot do it. There is no question of any coercion or force. It is binding on the doctor and no medical examination can be done. Because ultimately the child, otherwise what you're doing is sexual assault. You're just another assaulter. So now we come to the X person. Who is a support person under POCSO? How many of you are support persons here? Can I see your raised hands? How many support persons? Oh, wonderful, great. So can we have the mic back over there and ask them, who is a support person? Yes, anybody? I'm picking you on particularly because I think support persons are the most important person in a case. They are the most important support that the child and the family can have. You are very, very important people. Yes, one of you? Just tell me, how do you become a support person? Anybody?
A support person is a person who will help the child during the investigation and a trial stage.
Okay. What all do you have to do?
We have to give support to the child when she has to go for pre-trial and trial.
Okay. Who can become a support person?
Anyone which is the CWC will find it suitable like to be the support person, or someone where the child can be trusted. The child trusted that person, she can be a support person.
Okay, thank you. So, who are the CWC members here? Can we have your hands? Okay. So, how many support persons have you chosen, or have you got registered with you? How many support persons do you have? CWC member, yes.
Around 20.
Around 20? Okay. And how do you choose a support person?
Since I'm the member of the Child Welfare Committee of Traffic District, so
yes.
in coordination with the district transportation unit, we have got the probation officer, institutional care, probation officer in ICT, and we have got social worker, in counselors, yes, we appoint.
Very good. Thank you. Thank you for that. So, they have to be a person registered with the Child Welfare Committee or DCPO. Even if they are a person the child trusts, they cannot be considered a support. They are supporters, but they cannot be considered a support person unless the Child Welfare Committee or the DCPO has, generally the Child Welfare Committee has registered them. That means they have to give their data, they have to give certain contact details and certain things. It is good if a Child Welfare Committee, a support person has been trained in child rights, child abuse and the legal processes, because then they are able to give a lot more care to the child. A person with preferably a background in social work or law would be wonderful, but even any adult who is committed to working, but they have to be trained. They have to be trained because otherwise they may not be able to give the 100% support that the child needs. It has to be a person who is willing to commit time and effort for the child and family. Can you tell me how much time is needed by a support person? Anybody? How much time? Because your probation officers are really busy. How much time does a support person need for one child? And that is because in spite of having time bound that our cases get over earlier in 1990s and all that, it could take 10, 12, 15 years for a case of sexual assault to finally get come to a conclusion. A social support person has to spend first 4 or 5 days running around with the family and the child. They have to go to the police station, they have to go to the medical examination, they have to go to the DLSA, they have to get the lawyers, it takes 4 to 5 full working days. After that, every month it's a minimum of 3 days where you meet the family, you talk to the family. I have had my colleagues at Enfold who are support staff, 11 o'clock at night they get a call from the mother saying, I'm going to take my child and jump into the river. I can't take this anymore. The person is out on bail, he walks past my house every day. People are coming and threatening me saying, you don't care about your child's future, why did you put this case? I cannot take it anymore. So my support persons take so much time to just talk to the family, because the parents sometimes need as much support as the child. So it takes a lot of commitment. So let's look at what are the responsibilities of the support person. Spending 4 to 5 days during registration of the case, police statements under CRPC 161, medical exam, statement in front of the magistrate, they are there everywhere. Preferably, they should speak the same language as the child does. If not, you need to get a translator or an interpreter. Informing the survivor and family about legal procedures, right to refuse, compensation, and accompanying them to the court, as you have mentioned. Very important. Very often, they have families coming from distant places, you know, they will leave their wages, daily wages, to come to the court, and they find the judge is on leave, the public prosecutor is on leave, or the defense lawyer says, you know, my papers are not ready, the accused is sick. This is the way they drag on the cases. And therefore, the support person also calls up the previous day to the police station and checks that is the case going to be heard or not, and informs them. That's very, very important, because every time the family comes to the court and the hearing doesn't happen, it demoralizes them, and it is a victory for the accused. They have to also submit monthly reports to the CWC or the special court if required. They assist during the bail hearings. Very often the accused get bail, and the police are meant to inform the child and family that bail hearing is on and whether bail is granted or not. It's very important. Support persons play a very important role in that, because they keep in touch with the police officer, the IO or the writer or the head constable or the SHO or the CWO to say, please let us know whenever the hearings are, and if they are cancelled or postponed, please let us know. Reporting bail violations or threat by the accused. As I told you so many times, the accused will walk up and down past the house, bang on the doors, stare at them, try to build up community, against the child and the family. So the support person should be able to immediately inform the police, because if the police are informed that the bail violation is occurring, bail conditions are being violated, the bail is cancelled. And of course, giving emotional support to the survivor and family, which is what is one of the biggest things that these people do. Now, what are the responsibilities that we are looking at of the doctor? Can anyone, doctors? What are the responsibilities? Yes. What are your responsibilities under the POCSO Act? Anybody? What do the doctors not do? We should ask that. Yes? Anybody? What are the things you're meant to do? This is a quiz, which means you can have wrong answers. It's okay. Anybody? Who are all the doctors? Can you put your hands up, please? Yes. Can you catch one of them? Yes. Thank you.
Hello, ma'am.
Yes.
Ma'am, as a doctor, I think the most important thing we should do is the detailed history.
Yes.
Because depending on the history, we will come to know, we can make a certain decision whether the medical examination should be done or not. Because it all depends on our finding. Because nobody can force us. It depends on our finding whether we should conduct the medical examination or not, and how we should frame our report.
Yes, absolutely. Thank you. Thank you very much. Doctors, like police, have the ability to ferret out lies. You know, the patient will say, so the patient comes with a cough, and I say, do you have a cough? He says, yes, I have a cough. How long? Well, it's a few months. Okay. Do you smoke? No. Okay. Then I examine the person and all, and then I see a little bit of brown stains over here, and his teeth are little stained. I say, you used to smoke times? Yeah, sometimes. Okay. Meaning, how many per day? Just something, yeah. Maybe 2, 3. Yeah. Maybe 5, 6. Yeah, sometimes. Okay. And you smoked this morning? Yeah. Ultimately, you find out no smoking was rubbish, it was smoking all the while, right? So this is a way we have to take out without in any way blaming the person, talking to them and speaking to them, because it is their health that we are concerned about. So it's very good, thank you doctor for that, that the history, don't just listen, the police will come in and say, it's a rape case or a sexual assault case, and you just go blindly into a genital examination, examine the child, take the swabs, take the cloth packet and give it off. Please don't do that. So much more, because a doctor is a disinterested witness. So therefore your report has value. So when you write the narrative also down, there is a certain strength which comes in to the narrative which you give, that she was caught, she was given alcohol to drink, or she was made to have some medicines, and then she was assaulted. And all the things that have happened, there is in the form a narrative which is to be written in the medical form. And then your examination runs on that. So it's very, very important. So basically, the medical care of the survivor is the most important thing, because I need to look at what is happening. This girl who was 10th class pass, whose breasts were touched, I did not give her any medication. But the other girl who had come to me with a sexual assault yesterday by her boyfriend, they had both gone to a party, she had drunk too much, they ended up having sex when she did not want to have sex. He forced himself on her, she came to me. When she gave the history, the first thing I would give her is an emergency contraceptive pill to ensure that she doesn't become pregnant, because for one unprotected act of intercourse, there is an 8% risk of pregnancy. So it is very important on my part to give her that emergency contraceptive to ensure that she doesn't end up coming with a pregnancy later and then going through the entire trauma of MTP or continuation. So medical care of the survivor is very important. Then second part is your medical legal examination and documentation of injuries. As some of the police said, the medical records are not complete. Even honorable judges said the medical report is not complete. It is very important that the report is completely done, and we'll discuss that later. The collection of forensic evidence and maintaining the chain of custody is the doctor's duty. So you have to have a one-stop center, a locked cupboard, you collect the evidence and you have to dry it out, put it there, lock it, give it to the police officer with the signature on the seals. All that has to be done in a proper manner, because the defense lawyer will use it to negate all the evidence by saying it was not sealed, it was not given in a proper format, it was given after 3 days, how do we know it is of the child, it must be somebody else's. All these things are used to demolish the prosecutor's case. So it is very important that you follow due procedure. Giving testimony in court. How many of you doctors have been to court? Can you put up your hands? I promise I won't ask you what a wonderful experience it was. Okay, just one, two, just one or two of you? Really? Oh, 3, okay. And Dr. Wansmith? Many times, yes. So, it's really important to know that when you go there, you are just a witness for the prosecution, and that you are not protected by child-friendly procedures. The first question in all the 20-25 cases of POCSO I've gone to, the first question the defense lawyer would ask me was, how much money did you take? I'm like, huh? First time I was shocked. I was like so confused. I said, money? What money? I thought he meant the auto fare from home, from the hospital to the thing. I said, no, I didn't take. And he's saying, no, I submit to you. And they say these long sentences, right? I submit to you that that you have been with the child and the parents and you have connived together to have a false case and all that. And at the end of it, you don't know what you're answering, right? I realized the simple answer was, that is not true, or that is false. So you wait for the person to finish the entire sentence, and when you realize he is asking whether you took a bribe or whether you have connived with the parents to create a false case, you just have to say, it is false. That's all. You just happen to be an innocent bystander. They are trying to demolish your evidence so that they can get the accused acquitted. They don't really, they're not too worried about your character. They're not worried about, your standing in society or anything at all. They're not worried about your emotions also. They don't care. So you have to be the same way of calm, cool, answer the questions and walk out of the box. Your job is to give the evidence. You're neither there as a child activist, nor are you there to punish the accused. You are just there to give the correct narration and the evidence that you have collected. That's all. You also have to advise the family and survivor about the processes. When a patient comes to me and I have filed an FIR, I've reported to the police, they all think it will happen in 2 days. And I tell them, you will have to go here, then the police will talk to you, you have to give a statement to the police, then you have to give a statement to the magistrate, then this medical examination will take 6 weeks to 6 months to get a report. The case will be filed in the courts, it will take time. So this is important that we tell them, because it gives them more strength to manage the system. So as a doctor, I also insist on talking about compensation. I tell them, especially with the very, very poor patients, very poor families, I tell them that you get an interim compensation of 3,000 to 5,000, which will come when the special court decrees it. You will get the money, you can use it to travel up and down. This is very important because nobody else tells them. Being a role model. As a doctor, the first thing you're doing, and this is for everybody, whether you're a police officer, whether you are a support person, child welfare committee, or anybody involved with a case, you are a role model of what society has to be. So when the child comes in and says, you know, this is the problem I'm facing, or that is the problem I'm facing, the first thing I do is smile, because what happens is all of us are so upset about it, we are like, oh, like this. And the child comes and sees our face and gets even further scared. As it is, doctors are scary, then you see a scary face, because I'm upset about the child. The child doesn't care whether I'm upset about what's happened. Child wants to know, am I caring for the child? And so I smile at the child and say, I'm so glad you've come. I'm so glad your parents brought you. Because this happens to many, many people. Thank you. This happens to many, many people. But not everybody reports. I congratulate the parents. I say thank you for taking a stand for your child. You're getting into a very difficult system. It's going to take a long time. You may not always get justice, but for your child, you have stood for your child. And I honor you for that. And I say this to every child who comes to me in a POCSO case. In one place, the girl was 6 years old. She was narrating what had happened, and her mother started crying when she heard her say, you know, the man pulled out my panties and he pushed he said his pee in, and it was paining. And the child was disturbed, and the mother started crying bitterly. And the child got scared, and she looked at the mother, wondering why the mother is scared, because the child's whole world is the parents, right? And the mother, I turned to her and I said, your mother's only feeling sad because you got hurt. She's not upset with you. So don't worry. Whenever you get hurt, your mother cries. When your mother gets hurt, you cry, right? So it's okay, don't worry. And I waited for the mother to calm down, got some water for her, settled it, and then we continued with it. They need to know, because children feel I've caused trouble for my parents. They should not feel that. The only person who caused trouble for the parents is the accused, the perpetrator. And of course, all of us, if we don't take care. So that is how you are. So I'm going to stop here because I think we are going to go into a tea break. I think all of you are exhausted. Yes? Any questions, any doubts? Any questions? Any doubts? Yes, please.
Ma'am?
Yes.
Can we go back to the question number 14?
14. Yeah.
Yeah, the fourth point, I think, the third point. As it is said that in the absence of any guardian,
yes,
the hospital committee comprising of 3 or more designated staff may give the consent
for
right?
medical care.
Yeah, yeah. And in case in a place like PHC or CHC,
yes,
where the
only 2 doctors.
Yeah, one MBBS doctor and one is Ayush doctor.
Ayush doctor.
So in such a situation, how do we form a
nursing
committee,
superintendent?
Nursing
So,
superintendent also will
you don't have a senior nurse?
The supervisor will have one supervisor.
Yes.
And one MBBS doctor.
Yes.
And other than that.
So the MBBS doctor and the Ayush doctor cannot do the examination, but they can give a consent if they are within the hospital, and also the nursing supervisor. 3 of them can give consent for the child to have medical care. Can be done. But that is, you have to have, like with your DMHO, you have to have a plan. Like the DMHO has to give an order saying every PHC or CHC will have 2 doctors. PHCs of course have only 2 doctors maybe. Have these 2 doctors and this nursing supervisor to be there for any child of sexual assault or any sexual assault case, adult or child.
Okay, ma'am.
Because that has to be designated. So here in your case, it would be good to have it at your hospital, but your DMHO will probably have to give you the official letter.
Okay,
but it can be done, yeah.
Thank you.
Yeah. Okay, so we'll break for tea now. It is 11:15, is it? What is the time? 5 to 11? Yes. So how long should we give? 15 minutes? Yeah. So we will have a 15-minute break, and then we will come back for the further discussion on the MTP Act. We have completed the POXO Act. I hope all of you who had questions have some of what them answered. If not, we will send out pieces of paper and we will request you to come in. So thank you so much. See you at 11:15. Welcome back to another session. I hope you all had a couple of cups of tea and some biscuits and cutlets to get refreshed, and the sugar levels have gone up again after having slowly reduced. We will come to the next part, which is talking about the judgments, various judgments which have come in. I just want to finish that. The MTP Act of 1971 and the MTP Act Amendment of 2021, what is this about and why was it brought in? How many of you are aware that it is legal for any woman to be able to get a termination of pregnancy with just her consent if she is over 18 years of age? Will you put up your hands if you are aware that it is legal in every state and union territory of India that if a woman does not want to continue a pregnancy and she is below 20 weeks of pregnancy, she can have a termination of pregnancy on her signature alone? Are you aware of that? Yes, please put up your hands. I need to see that the tea has reached your hands. Yes. Okay. Because I was shocked in a girls' college I had gone to in Bangalore to talk about health. And I asked the girls that, is abortion legal? And they said, no, I don't think so. I said, you think abortion is illegal? They said, I think, madam, married women can get an abortion. It's legal, but unmarried women cannot get an abortion. So there are a lot of wrong notions, and most of it is primarily because of these social norms around pregnancy, where women do not have the right earlier. You know, even in the Hippocratic Oath, which was around 3000 BC, in the Hippocratic Oath it is said, you will not help a woman to have an abortion. A doctor was meant to swear to that. The doctor was also meant to swear that he will never cut a patient to remove a stone, you know, gallstones or liver. But somehow, since men suffer from gallstones and kidney stones, everybody agreed that doctors can do the operation. But somehow it took many, many, many years for women to have the right of autonomy over their own body. So we'll just quickly look at why was the MTP Act needed. On an average, women are coerced or forced into sexual activity. And unfortunately, women are not required to give consent for sexual activity after marriage. The presumption is that if she is married, her husband has the right to have sex with her whenever he wishes. The question of taking the consent of the wife somehow doesn't arise in anybody's brains. Women who do not have access to safe abortion services have two choices. Either they die or they have damage to their health through unsafe abortions. One of the first autopsies, like as a medical student, you're meant to attend 20 autopsies. One of the first autopsies I attended was the 7-month, this 34-year-old lady who was 7 months pregnant. She did not want to have the child, so she had gone for a termination, and some quack had put his a hanger, clothes hanger, opened it and pushed it into the uterus, ruptured the uterus, the baby had gone into the abdomen, both the mother and baby had died. This was in 86 or 87. So they go through. I had another child in St. John's when I was working. One night we had a call at about 2 o'clock in the morning. This 14-year-old girl had come in and she was in septic shock. Her pulse was very low, blood pressure was barely, palpable. And her abdomen was distended, her stomach was distended like this. She was almost unconscious. Apparently she and her boyfriend had had sex, she had become pregnant, they had gone to 2-3 places, taken some tablets, nothing had happened. Then he finally took her to some quack who had put some chemical inside the vagina. She started having bleeding. She came home and she kept having bleeding. And because her parents just knew that she had not had periods for 3 months and then she's bleeding, they just thought this was a painful period. And then only when she fainted that they took her to the hospital, and then they realized, they brought her to St. John's, and then we found that she had had a history of an unsafe abortion. We did an ultrasound and found that her abdomen was full of 4 liters of pus. We had to operate immediately, and I'm telling you, when we operated and that pus came out, we couldn't stand in the operation theatre. The smell was so bad. Her uterus had been torn. Whatever they had done, we don't know. Anyway, we rinsed it out, washed it out, and luckily, because she was young and generally fit, she survived. She was fine. But I don't know how her uterus will be, and I don't know whether her tubes will be patent and whether she will be able to become pregnant again, just because she was not aware that it was possible for her to have a legal abortion. So these are cases, when we talk of damage to health through unsafe abortion, it is a very real issue. And if they don't go for a termination, like in so many of the teenage pregnancies I was talking about in Meghalaya, where they don't realize they can have an abortion, or they're so scared to tell people that they only talk about it in the 7th, 8th month. So they have missed out on 7 months of antenatal care, and they are young girls, 16, 17. So they don't even have the strength. They are already anemic. They are malnourished. On top of it, they are pregnant and they end up with health issues. And the psychological effect, I think you must be aware, it came out in the papers also. About 2 months ago, there was a symposium on single mothers in Meghalaya. And there are more than, they had done a study, Martin Luther University had done a study on 2,000 single mothers across, Jaintia Hills, Khasi Hills and Garo Hills. Women who have become pregnant, had the baby, abandoned by the husband or the partner, and somehow struggling to bring up a child alone. And one of the issues they found is when a single mother brings up a child, if she has a good support system, she has a mother, sisters, brothers, people who are there to help her take care of the child, the children grow well. But if she doesn't have that support system, then there is very high chances that her children are affected. And very often single mothers' daughters end up as single mothers themselves, because they also end up, they see their mother struggling very hard to work hard to feed her children, to take care of the house. Very often they are in poor socioeconomic status, not able to see whether the child can go to school. The eldest girl is often made to help look after the younger ones, so she ends up not going to school, dropping out. And then dropping out of school is one of the highest risks of teenage sexual activity. So keeping children in school is such an important thing to prevent sexual activity, which is dangerous for the children. 56%, so this is 2017, statistics, which became worse during the pandemic, because during the pandemic, most patients could not do a pregnancy test, they could not leave, they could not get out. There was domestic violence increase during COVID. 56% of abortions in India are unsafe. That means out of every 2, at least 1 is unsafe. When every government hospital is registered as a safe MTP center, every government doctor, if he is an MBBS, can be trained to do safe termination. Nowadays we do it with medicines, not with surgery. So the surgical complications are less. Every day 10 women die of unsafe abortions in India, every day. Globally 47,000 women die annually of unsafe abortions. Meghalaya has the 2nd highest number of teenage pregnancies in the country. When a teenager becomes pregnant, she drops out of school, she ends up not being able to be financially stable. And what I found with some of the teenagers is they felt that now that they had a baby, they were spoiled. And so they ended up repeatedly having relationships, hoping to get a partner who would be with them and take care of them, and it did not happen. And so often they would have 3 or 4 children from different partners, struggling to take care of their children. None of them knew that they could have a termination of pregnancy which was available in their district hospital. There was a case, I think some time ago, must have been aware, that came out in the papers, that a doctor refused to do a termination of pregnancy. A government doctor cannot refuse to do a termination of pregnancy because the woman has only you to go to. The woman can't go to some other, she are very poor people. Richer people, perfect. Middle class, richer people, they fly to Delhi, fly to Calcutta, go to Guwahati, get an abortion done. They know whom to go to get it done. It's only the poor who suffer. The really poor families who don't have anybody, their only source of support, health care is the government hospital. And when they go there and the doctor turns around and says, I don't do abortions, it's unacceptable. It's unacceptable. You don't do it, fair enough, but find somebody who does it and refer the patient there. Don't make them run from place to place because she may die. So, teenage maternal and infant mortality is high. One of the reasons why I came to Meghalaya from Bangalore was because of the high maternal and child infant mortality, which is one of my passions to reduce. So therefore, in the MTP Act and the subsequent amendment, every woman or girl has a right to safe abortion services. Over 18 years, she can give consent for herself. She does not need anybody with her. She doesn't have to ask her partner, her parents, nobody. Under 18 years, she must give consent along with her guardian's consent because it is an invasive procedure and hence the guardians have to be brought into the state. Now, earlier the MTP was up to 20 weeks. So we used to say that according to the 1971 MTP Act, one doctor had to see a woman and up to 12 weeks they could say, okay, she can have the abortion. If it was between 12 and 20 weeks, because there was a slightly higher risk, 2 doctors had to examine her. Now, as somebody mentioned, in the PHCs, CHCs, we may not have 2 doctors, MBBS doctors, right? So where is this woman going to go around looking for a second opinion? So now the new law, MTP Amendment of 2021 says that up to 20 weeks, just one doctor, RMP or trained doctor is sufficient to examine the patient and say whether she is medically fit for termination of pregnancy. If it is 20 to 24 weeks, and that is the new amendment which came in, and I was one of the people who gave the affidavit to the Supreme Court when the lawyers fought this case out there, where we wanted to make the point of legal abortion from 20 weeks to 26 weeks. Because up to 26 weeks, it's second trimester and the risk is less to the woman. After that, the risk also increases for her. But in its Supreme Court, in its wisdom, gave it as 24 weeks. So if a woman has been sexually assaulted or she has lost her husband or gone through divorce or widowed during the stage of the pregnancy and she is unable to continue, if there is a chance that the baby has some health issues which are not compatible with life, or the mother is in a social circumstances or financial circumstances where she will not be able to take care, in that case, up to 24 weeks of gestation, she can get termination done in any government hospital or private hospital on request. There is no need for a court order. If it goes beyond 24 weeks, which sometimes happens in younger girls, 12, 13, 14, we had a case in Chandigarh about this 10-year-old girl who was molested by her uncle, who was found to be pregnant 30 weeks when it was diagnosed that she was pregnant. They went in for termination of pregnancy, but it was a very serious issue for her. So there are things that happen, so 24 weeks is still liable. But please, please move fast. When there is a question of pregnancy, move fast in the case so that at least the medical care is taken care of. The legal procedures will take their own time, but take care of this. And medication, MTPs are now done by medication. Even 24 weeks, we admit the patient, we give her tablets so that she has what is like a normal labor, but she does not have to go through these extremely traumatic vacuum evacuations. DNCs are not needed. It can be done just with medicine, but she needs to be under the care and supervision of the hospital. So refusal, as I said, of MTP services is a violation of the right of a woman to an autonomy over her own body. So I close over here with what we had done. I'm going to talk about the legal issues which have come up. So the biggest issue. Hello. Can we have this on? So I'm going to talk about 2-3 things. So the same thing came up where the POCSO Act states that if a girl is below 18 years, it has to be notified to the police and you have to arrest the person, arrest the boy. But if she had consensual sex, she became pregnant by mistake, which is the fault of our society, where we again allow pornography to run around everywhere, but we don't allow sexuality education in schools. We don't talk about sex within our families or help in protecting our children in any way. So with the result is that the MTP Act came in direct conflict with the POCSO Act. Because the MTP Act of 1971 states that complete confidentiality is mentioned if any woman or a child under 18 with her parents or with a guardian goes to a hospital. You do not even take the name of the patient. You just give an MTP registration number. You do not take the address and you do not take her phone number, no identifying factors. You admit the patient or do the medical examination which is needed to see that her health is fine to undergo the MTP. You may do an ultrasound to assess how many weeks she is, that she falls within the legal limits, and then you do the termination of pregnancy and send her home. When I started medicine in 86, 84, 86, there were around 7 lakh abortions happening every year legally in the hospitals, and there were 7 crore abortions happening which were unsafe. And as you know, with an unsafe abortion, if something goes wrong, the girl dies or there is damage and there is no control over it. So therefore, the MTP Act has been very important, but the moment POCSO comes in and says under 18 you have to report it, the whole question of confidentiality goes out the window. So I am going to read to you in the Supreme Court of India Civil Appellate Jurisdiction, where it is given Civil Appeal number 5802 of 222. I will give this to you, any copies if anybody wants. Now in this, Justice Chandrachud said, where it is determined that the continuation of the pregnancy will involve grave danger to the pregnant woman's physical and mental health, her actual or reasonably foreseeable environment may be taken into account. And it is stipulated that every woman is eligible for pregnancy up to 24 weeks, specifically for survivors of sexual assault or rape or incest. Any minor, not about sexual assault, just a minor who's pregnant. Because whether it was consensual and non-consensual, I would hope it's consensual just for the sake of the trauma, less for the child. But because sexual assault is a whole different ball game. Any minor who is pregnant can have a termination up to 24 weeks. If there is a change of marital status during the ongoing pregnancy, that means widowhood or divorce. If a woman is with severe physical disabilities, if a woman is mentally ill, or she may have mental retardation, or there is a fetal malformation, in all these cases, the woman has to be access to MTP. It is also said, presently under the MTP Act, the opinion of an RMP is decisive. Since women's right to access abortion is conditional on the approval of a doctor, the denial of services by a registered medical practitioner compels women to approach courts or seek abortions in unsafe conditions. This should not be happening. Besides this, the court has recognized the disastrous effects of unnecessary delays and lack of promptitude in the attitude of authorities when dealing with termination of pregnancy, specifically in cases of either consensual or non-consensual sex. And this has caused errors. So therefore, it says that under any circumstances, if a woman comes for termination of pregnancy, the doctor only has to inform the police station that a 15 or 16 or 17-year-old girl has come with a pregnancy less than 24 weeks. She is undergoing termination of pregnancy. She, as well as her guardian, because she's under 18, so the doctor needs the guardian's consent. She and her guardians have stated that it is consensual sexual activity, and therefore they do not want a report to be filed. This is in the 2 cases where either she wants to continue with the pregnancy, or secondly that she wants to go for termination, so that the antenatal care or the termination of pregnancy procedures cannot be stopped. Now here I was speaking to Justice, thank you, and we hope that this will come up, because these are not easy things for police or doctors to do, right, on your own. I am giving you this to show you that this has been given by Supreme Court, and Supreme Court judgments are binding to the whole country. But you will all, and now that I see there are senior police officers here, there are senior justices here, magistrates over here, people from the social welfare department, I would really, what Justice Sangma had mentioned earlier, I really would like a consolidated collaborative effort to make rules which we can give to that last person, the last policeman at the police station in some tiny place somewhere, in the PHC, the doctor in the PHC, who both of them are waiting for ways to be sensitive to the child. But unless there is orders coming from the state headquarters, it's not going to happen. You need to give it to them. So in this case, particularly the social stigma surrounding single women who are pregnant is even greater, and they often lack support from their family or partner. This leads to proliferation of persons not qualified or certified to practice abortions. In this case, we now turn to interpretation of Section 3.2 of the MTP Act and Rule 3B of the MTP rules, and the purpose of interpretation is that the name should not be revealed as long as it is consensual. Now here there is a little bit of a problem, as we all know, which used to happen earlier, is that the girl is saying it's consensual, but it could be assault. It could be she's raped by an uncle or somebody else in the family, and the family says, keep quiet, just get the MTP done. So therefore, there is need for due diligence. There is need even for the doctor, and specifically for the doctor, because they're doing the termination, to confirm that it is actually consensual and not rape. So these are what we have to do. In the Office of the Director General of Police from Tamil Nadu, this is dated December 2022, circular memorandum, the police department had the joint meeting of the Honorable Juvenile Justice Committee and the Honorable POXO Committee held at a state level consultation on POXO, discussed on the POXO cases that are registered relating to mutual romantic relationships, and the resolution that was passed, which is binding to everybody. The discussion states, statistics clearly show that 60% of POXO cases that are registered relate to mutual romantic relationships, on account of which, for the sin of falling in love with a girl below 18 years, the male is criminalized by arrest and prosecution in view of the stringent provisions of the POXO Act. This is more so in cases of youth in tribal communities in hilly areas. So Tamil Nadu has a very large, in the Nilgiri mountains, they have a very large tribal population. In several Adivasi and tribal cultures, it is not a taboo for a male to marry a girl who is less than 18 years of age. When I went to West Garo Hills and some of the other distant villages, the community people, would say, the Mahari would say, the best time for a girl to have the first child is between 15 and 18 years. So they still believe in that. So obviously the children take it on, right? So until we can start changing the community, at least our ways of reacting to this should be more kind to the child. So in this they said, the state is encouraging tribals to use the facilities in government hospitals for delivery for good reason. When a 17-year-old tribal wife goes for a delivery to a government hospital, information is sent to the police, a case under POXO Act is registered against her husband, and he is arrested. If this continues, tribal women will not go for delivery to hospitals and would instead avail the services of tribal midwives, which is happening in Meghalaya in a large content. I think 2021, our institutional deliveries was about 57%, and now last year, 22-23, it has come up to 69%, almost 70%. It's very low. 30% of women are delivering in their houses. The risk of death is so high. In Kerala, it's 4. Over here, it's so few, because there's barely 96% of them deliver in the hospitals. Barely 4%, and those 4 are, they didn't get a vehicle in time, so they ended up delivering in the gadi, or they ended up delivering at home because the labor pain started so fast in multigravida, not because of intention. So, this apart, okay. Furthermore, most of these cases end up in acquittal either on account of marriage between the survivor and the accused, or on account of the survivor turning hostile. Criminalizing youth will have a deleterious effect on their career, life and future, as they would have to live with the stigma forever. So the resolution here, and this is specifically to the police officers here, it is resolved to direct the Registrar General to address a communication to the DGP to issue a circular to investigating officers of POXO cases. A. Not to show haste in effecting arrest of the accused in mutual romantic cases. B. Instead, issue a notice under Section 41 for CRPC to the person concerned for inquiry. Record in the case diary the decision for not arresting the accused along with the reasons thereof. Resort to arrest only with the permission of the Superintendent of Police, Deputy Commissioner of Police, as the case may be. So it's given some guidance, and that has really helped. So a lot of women, tribal girls who had come in, who were being arrested, Nilgiris, they have a huge number, most of them uneducated, this was getting put. So this is where it is happening. Therefore, all commissioners of police in cities and all superintendents of police in districts are directed to ensure compliance with the above resolutions. So we have got, an example of a state which has looked at the care of their girls rather than just looking blindly at the law. So they have also given, the National Health Mission, the guidance on POCSO Act and POCSO rules have also given a large number of rules, papers which have been there, recording of a statement of a child, mandatory forms. Here they have stated every police officer when an FIR is formed for a POCSO case mentions the entitlements and rights available to the child victim, which shall be filled by the police officer who is registering the FIR and given to the victim parent guardian after registration of FIR, and the form will be in English and Tamil or whatever is the language they want. So the form should also contain the acknowledgement signed by the complainant parent guardian and submitted to the POCSO court by the IO, and the same will be verified by the POCSO judge. Yeah, so there is streamlining so that we are not just, as you mentioned, that we should not just create loopholes, that suddenly every POCSO case becomes a consensual sex and we are just saying don't arrest and it continues, because it can be definitely misused by perpetrators. But without that, we can still at least help the ones who are not sexual assault cases. Any questions so far? Any questions? Any doubts? One cutlet and a cup of tea put you all to sleep? Okay, let's continue. I just want to run through 2-3 things which is called what is the factors in child sexual abuse, and then I'm going to go to the medical examination. What are the factors in child abuse that we need to look at? So this is what is called trauma-informed care. Can anyone tell me what do we mean by trauma-informed care? It's a new buzzword. Every now and then some new buzzword will come. This is a new buzzword. Like earlier everybody said don't eat fat, it's bad for you. Now they say eat fat, don't eat sugar. So they said don't eat eggs, you'll get cholesterol. Now they're saying eat eggs, it's good for you. So like that there are buzzwords. But what does trauma-informed care mean? It is about talking to a child. So suppose you were planning, you and your partner were planning to go out on a couple's holiday, and 3-4 sets of couples were going together for this holiday. And one of your friends has lost their partner recently, they've had a breakup and they've gone away. Would you be sitting in that person's house and discussing what fun you're going to have? Would you do that? Why not? Why not? Sensitivity? Yes? Yes. So, a friend has lost her mother recently and I'm planning my mother's 80th birthday. Will I sit with her and say, come on, help me organize my mother's birthday? Shall I get a cake? Shall I get this? Shall I get that? Would I do that with her? I would have done it before if her mother hadn't passed away. But right now, I know she's in grief. I'm not going to put salt in her wounds by doing that. That's all trauma-informed care is. It just means I understand that this person is going through emotional pain and I don't want to increase the pain. As a doctor, as a police officer, as a support person, CWC, JJB, judge, you cannot guarantee justice. None of us can. But the only thing we can do is ensure that in the time that the child and her family or his family interacts with us, we should not cause them more pain. That is trauma-informed care. For that, we need to understand the circumstances in which a child comes. There was this girl who was brought to me. She was about 15 years old, tall, big-built girl, came in, sat down, very angry with me, didn't want to be checked. I don't want a checkup, she told me. I said, okay, no problem. I'm not going to do a checkup if you don't want. And the police officer came and sat down and she said, madam, please do medical examination for her. I said, well, she's not agreeing to it. Madam, I'll tell you about her. She told the girl, go sit outside. So the girl went out and sat with her mother. And the sub-inspector told me that this girl had run away 3 times from home. Every 6 months prior to that, she had run away. Another mother would come to the police station, give a complaint, they had to look for her. And she had run away with a different boy each time. This time she had come back and she said, "Madam, that mother is a single mother. She's crying over there. And this girl is saying, why should I come back with you? Who are you to, who are you to decide whether I can decide where to go and who I should go with?" And madam, I have to say, I gave her 2 tight slaps, madam. So I said, "Did that help?" She said, "No. I feel bad. But I was so angry that mother is so upset, and each time she's running around like this, that mother is a daily wage earner, it's so difficult." I said, "Sure, I understand that. But, hitting kids never works." So anyway, the girl came in after that, and I asked the police officer and the mother to sit out while the daughter came in, and I was talking to her, asking her what is happening, basically just finding out what's happening. She dropped out of school in class 4. And then I found that her father had passed away and her mother had another boyfriend who would often molest her. She was running away from that. I said, "Have you told your mother?" She said, "If I tell my mother is so sad, madam. At least she feels happy with this fellow. If I tell her, then if they fight, then he will also leave her. Then who will take care of her?" So we judge people very fast, but we don't realize what circumstances they come from. So if we look at factors in child abuse, there is a socio-cultural phenomenon around it which talks about no silence around sexuality. There is a community which has a major role to play. There are family relationships and the child. So let us look at each of these factors. In the child, what do I look for? Like when we are saying, what sort of history do I take when a child comes to me like this? An unwanted child. Who is an unwanted child? A mother who's a teenager who got pregnant. And she didn't want this child. But she didn't know you could have a termination. Or she got there too late to know. She really didn't want to have this baby. An unwanted gender. 4th boy, 5th boy. Where is my daughter? And the child knows it, right? A needy child, a preterm child, a cranky child, a child who's very weak. Recently, my cousin had a baby, not recently, 3 years ago. The child was born at 29 weeks. Because they were abroad, that child survived. The baby was 690 grams. The parents for the last 3 years have gone into a state of mental breakdown because everything is worrisome. For 4 months, the child was in the NICU. Every day you don't know whether your child is going to be alive or not. That sort of stresses you. All the pleasure of having a child just goes out of the window. So a child like that who's preterm, cranky, who falls sick a lot, is a difficult child to take care of. Very siblings close in age needing. We have 1 to 1.5 years gap between children and the mother is exhausted. She can't look after both. Any child with special needs. So if the child, it's so strange. We always think that children with disability will get more love and care. I'm sorry to say they are more likely to be abused. Because they don't go to school. They fall out of school because of physical disability. They can't walk that track up to their school. Or they have hearing problems, or they have visual problems, so they're not able to sit in class. So they ended up dropping out of school. They are alone at home. Parents have to go to work. They have to go out. And they get targeted for abuse. And especially children who are mentally retarded, who are not able to speak about what's happening, they have much higher risks. So these are things I will listen as a doctor, I will keep asking, what are the issues, what is happening? Among the parents, of course, marital discord is one of the major reasons. When 2 parents are fighting and they are deeply, bitterly upset with each other, there may or may not be violence, but they are so mentally upset that they don't have space and time to take care of the children. Children somehow are surviving in that household. So if I see sexual abuse in a child, I normally try to find out from the parents, what is the situation in the house? Of course, domestic violence is harmful. Unreal expectations. I think you're all hearing about the quota suicides, right? The 23rd child just committed suicide 1 week ago. The unreal expectations that everyone has to become a doctor or join the IIT JEE. Young parents, these teenage girls who become parents really are finding it difficult to manage the child. Substance abuse, both alcohol and drug abuse among parents. If either the father or the mother is alcoholic or having some mental disorder, the child is at higher risk. And if the parents have childhood trauma, what I have found, and this becomes what is known as intergenerational trauma, if the mother or father was sexually abused as children or badly physically abused or grew up in a household with domestic violence or with marital discord, they either have to go through a lot of therapy to become stable, mature, emotionally stable parents, or else the same trauma comes to the children. In the community, one of the problems is poverty. And poverty, as I said, is basically because you're not able to get access to health care, to a good school, to education. When you have some of the schools I've been to, there's a cow sitting in the place where the food is to be cooked. The benches are in a bad condition. The teachers may or may not come. Children will drop out. And when children drop out of school, the first thing that happens is risky behavior, either drug abuse, substance abuse, or risky sexual behaviors. We have an acceptance of domestic violence. Bangalore, I had gone to a school once where the children were from a poorer socioeconomic background. It was a girls' school, class 9. I was talking to these girls in class 9. And I told them, we were talking about, so I asked, what do your mothers do? Do your mothers work? So out of the 50 girls, only 3 girls put up their hands. They said, my mother works. I said, what does your mother do? So one's mother was a bank clerk. Another mother, she would help her father in the shop. They owned a shop, so she and the father would take turns. And the third was housekeeping staff in a bank. I said, oh, so the rest of you, your mothers don't work, right? So they said, no. So I said, oh, so your mother sit at home, put on nail polish, watch TV, relax. They said, no. I said, no. What does your mother do? She gets up at 5 o'clock in the morning, she washes the doorstep, she puts rangoli, she cooks breakfast, she cooks lunch, she packs up breakfast, packs up food, then she goes, she looks after my grandmother, she goes to the market, she drops my brother to school, she comes back, she takes lunch for my father, she does this, she cooks the food, she washes the vessels, she cleans the house, and then she sleeps. I said, you told me your mother doesn't work. So then I asked, how many of your mothers work? Everybody's hands went up. There is a gender discrimination, and so therefore what happened with these girls, I asked them, sometimes fathers hit mothers, right? And they said, yeah. Is it okay? No, it's not okay. But it happens. It happens. Okay. And do sometimes mothers hit fathers? They were so amused, they started laughing. Because even the concept was amazing. It's not that domestic violence doesn't happen against men, it does happen. But the percentage is very small. But we accept domestic violence against women. And we hide domestic violence against men. It is one of the reasons, social norms, which encourages sexual abuse. There are inadequate referral facilities. As you said, if the person has to go to the district hospital every time there's a sexual assault from 150 kilometers on a road which takes 4 hours in a pickup truck, it's going to be very difficult for them to get help. They'll just say it's not worth going. There are easy availability of drugs. It's amazing, we don't have medical medicines at one far off place, but you will have Lay's chips, you will have Coke, and you will have drugs. So traffic does happen, right? I'm always amazed at that. Migration of population, the moment you have migrant population, and we have some districts in the state where there are more migrant population, there is again risk because the families are not local, so they don't have anybody to go to, they don't speak the local language, so the chance of getting assaulted for the children is much more. Plus their children, if they come with them, are out of school. Poor police and legal effectiveness. Even the police's hand is tied sometimes as to what to do. And that is why it's important to give very clear guidelines to the last person on the list. Social factors, social and cultural norms that glorify violence. If you've seen all the latest movies coming out, whole idea is take a AK-47 and shoot everybody. Life is perfect. Demand rigid gender roles. So men have to be strong, tough, and women also have to be subservient. That diminish the status of the child. You remember that Amitabh Bachchan one ki mera baap chor hai business. So you have a problem with the father, you beat up the child. Those that uphold family honor. And so these are the various issues that we have to look at when we take it. Now, if you look at the effects of child abuse, short term and long term, and we'll discuss that in little detail. On the family, you have dysfunctional families. The family gets broken down. One of the biggest issues we found, and this happened just last year, one of the cases which my team was working with in Bangalore, the child, so they were a migrant family in Bangalore. The father used to work as a security guard in the factory, and the mother used to do domestic work in 2-3 houses. They had 2 daughters, a 5-year-old and a 3-year-old. The 5-year-old was abused by another security guard who used to live in the shed next to them. So when they went to complain to the police came, the factory owner said, I don't want all this police nonsense here, get out. So suddenly they were left out on the road, so the father had lost his job. They had to go and stay in a shed somewhere else. They had no money to pay the rent. Here they were staying rent-free. And the woman lost her job because where she stayed now was very difficult for her to come to the work in the domestic places where she was working. Somehow they continued, struggled through it. Our team sort of helped. We have a sort of rehab fund where we try to support the families with food and things like that. During the pandemic also we tried to do that. So we worked on it, tried to support them, worked through. But finally the mother and the father split up. The father left and went back to the hometown. The mother wanted to continue staying here. Because the children were in school, she didn't want to take the kids out to a village school back again. And the children were now studying Kannada and English and back there in their hometown. They would not have been able to go back into school. So she stayed on, struggled, tried to work, did a beautician course, kept working. But she would keep breaking down, and my support persons would talk to her and settle, try and build her up. And then one day we got a call saying that she was admitted in hospital with an overdose of medicines and she died. She had committed suicide. The elder one was about 16 or 17 years old and the younger one was about 14 or 15. They were both staying in a small room. So what we tried to do, we went there to help out and we tried to put the kids into hostel. The older one could go into hostel. She was in 12th. So we said, we'll put you into college. And the younger one we'll put into a school hostel. And she said, no, my sister has nobody but me. I'm not going to be separated from my sister. So I will stay in this house here only. And I will take care of her until she goes into college with me. I'm not going to leave her. So now those 2 girls are staying on their own. They're staying, in a tenement where there are small rooms. And the neighbors are very kind who have seen the children grow up. So they are helping and taking care. But we don't know. It's so tough. So there are so many other things which happen to the families when a child gets abused. So children who have been abused when they grow up are very hyper parents. One of my patients delivered and she had a baby girl, and then I had told her that when you're 6 months or when you're planning to go back to work, come and talk to me because I'll tell you, how to breastfeed the baby and go to work and things like that. She came back when the baby was 9 months old and she said, I said, oh, how are you? When are you going back to work? She said, ma'am, I'm not going to work. I said, oh, why? So she said, ma'am, actually, I'll tell you, when I was about 5 years old, I was abused by the neighbor, my father's good friend. So I'm so scared this will happen to my daughter. And she's a girl child, no? So I've decided I'll not go back to work. Now this sort of anxiety you'll see in some parents, don't go out here, don't go out there, don't go. What will happen? That kid will run away with somebody because they can't handle that sort. But they make poor parents. There are intergenerational trauma effects. On society, obviously you will start getting antisocial behavior, you will have juvenile offences, substance abuse will increase, and people who have faced sexual assault, like this girl who kept running away, she would steal money from her mother's thing to get out. It happens because somewhere they have lost their sense of self-worth. Now, why does this happen to the child? David Finkelkov was a psychiatrist who's spoken about it, called the traumagenic model, in which he said traumatic sexualization is the first thing. Now, sexual activity is something everybody looks forward to. Oh, it's something very exciting. And after seeing all these movies, you're like, oh, it's going to be great fun. So for a lot of you, it might be a disappointment. For some of you, it was great. But unfortunately, for a child who has been sexually abused, the first sexual experience they've had is painful, distressing, and scary. This affects their life. There's a deep sense of helplessness that they feel, there is a sense of betrayal because children are brought up thinking, listen to your elders, respect your elders, and they will take care of you. And there is a stigmatization which comes up. If they dare to speak about it, they are stigmatized, and if they don't speak about it, in their internal heart, they always know this has happened to them, but they don't dare speak because of the fear of stigmatization. And that's why it's important to speak about it. I remember I was talking to the Academy of Pediatricians at Delhi. There was a huge seminar on POXO. And this pediatrician who was the vice president of the IAP, he came and he stood there and he said, when I was 5, I had to go to school, so my father would get me dressed and he would drop me at the shopkeeper's house at the end of the road where the bus could come, because he had to leave early for work, and my mother had a small baby at home. And the van would come and pick me up from the shop and go and drop me back, and my father would say, stay with uncle. And that uncle in the shop used to abuse me. And at 5, I didn't know what he was doing, and I didn't know whom to tell. But I knew that I shouldn't tell my father, I don't know why. Now I think I should have. And I would tell my father, the house is just there, no, I'll walk home, it's okay, it's just so close. And my father would say, no, it's dangerous. You don't know, strangers are there, bad people around. You wait in the shop. With uncle, I'll pick you up on the way back. And he said I could never tell him that this uncle with whom he thought I was safe was more dangerous than any stranger on the road. And when he shared that in this open forum, we were all moved because of that. Another psychiatrist, adult psychiatrist from Nimhans, in one of these sessions, she spoke about the abuse she had faced as a child. And I think that's important, that we speak about it, to bring it out, to know that it happens, that it is common, but it can be stopped. Why do children keep quiet? Basically, because they fear being disbelieved, fear of being blamed, fear of breaking up the family, threats by the abuser, and confusion and ignorance. They didn't even know what was happening. Later on at 12, 15, they suddenly realized I was being abused, because now they understood what sex is. Earlier they didn't know. So the process of disclosure, which is what we are looking at how to talk to a child, we have to look at it is a process. What will help the child to speak? And that is confidence in people around. And one of the things that we talk to parents in schools is that please do not punish your children. Because when you punish, particularly hitting children, you are telling your child that if you make a mistake, you will be hit. And they don't know that sexual abuse is not their mistake. So when you hit your child, you are actually creating a foundation for sexual abuse. Physical punishment of children never works. Usually the children will say, no, nothing's happened. These girls, teenagers, no, nothing's happened, nothing happened. They deny it. But if you persist, they will tentatively say, maybe, something sort of happened. And then the reaction they look at. If the reaction is, oh my God, really, what happened? It's a problem. If the reaction is, I'm so glad you're telling me, we will get help, we will get it stopped, it's not your fault, then they will actively speak to you. But once they hit the criminal justice system, they end up retracting. And the case gets dropped. All of you are aware, the witnesses turn hostile because they face such a negative backlash from everybody. So as I had mentioned, trauma-informed care is looking at these factors to work on it. So, any questions so far? Any questions? Okay, so we'll quickly go to the medical examination, which I would like you to look at. The medical examination is basically for the doctors, but everybody, whether you're police, whether you're judiciary, judicial officers, public prosecutors, CWC, JJB, support persons, you need to know what a medical examination looks like, is like, to ensure that it is being done correctly and you can guide the people correctly. Plus, earlier, now it's changed a lot with the POXO special courts which have come up. But previously, judges would just look at hymen is torn, 2-finger test. We now know this is all wiped out. We look at mostly the testimony of the victim, because very often there are no injuries, very often there is no evidence, because they take time. I think one of the things in earlier cases would be, why did the child take 1 year to report it, 6 months? So definitely it's a false case. This used to be said. But now we've understood much more from the trauma-informed lens that it takes a lot of time for a child or a woman or man or transgender person to be able to have the courage to come and speak about it because of the fear of stigmatization. So this is a sort of, I won't call it a kit exactly, because every doctor has all this stuff in their basic PHC also. Nothing is rocket science over here.
Can I have this mic on, please? Can I have this mic on?
Yes. So, we are following here the Ministry of Health and Family Welfare guidelines, okay, which has been given. It is now all over India, and in a way it's good because it helps in ensuring that there is uniformity. The file is around 12 pages. 12 pages long. So the moment any doctor sees this, no, they start getting palpitations and high blood pressure and all that. But believe me, it's an extremely detailed form, which if we fill, takes around, so now what happens is whenever I get a case of sexual assault and I have trained my postgraduates and all to do it, it takes not more than 20 minutes to fill this whole form. But it is so complete that both for the doctor when they go to give testimony in court, plus for the police officer, the IO for filing the case, it becomes very, very easy. Now let's look at it. In the first page is basically all the details of the case, of the person, child's address, phone number, etc., and the consent form. The consent form is right there, where the consent form is given and the signatory of who are the witnesses, everything is done in the same file. Most important is marks of identification. There are 2 marks of identification which all doctors are meant to write down. If it's not written down, please send it back to them to write it. Because it's very important. In Karnataka, in North Karnataka, around in 2002-03, there was this mass marriage. And then some NGO went and found out that a lot of the girls were 16 years old. So they said, how did these girls get married? So they went out to catch them. So when they went, they found that the school certificate was, the medical certificate had been given as 18, as an adult. So they went to the doctor to catch the doctor. And the doctor looked at this lady girl who came in and said, this is not the girl I saw. So what happened is the family wanted the girl to get married. So the elder sister, who was 22 years old, went and she said, I am Saraswati. So the doctor saw her and wrote down that she is this thing, Saraswati, age so-and-so, she's 22 years old. And in medical examination, she was an adult, so wrote down is an adult and went off. And did not write identifying marks. So when this other girl came in who was 16 years old, the doctor said, I've never seen this girl. But he said, you've given a certificate, she's Saraswati. And then he saw the sister and said, no, I saw her. She says, that's Anasuya, she's 22. So please write identifying marks. It's just simpler. Then all the history over here, particularly over here, the history of when was the last period, then the history of the sexual violence, how many times. Now when we take history of sexual violence, especially if it has happened multiple times, the child can't remember what happened every time. So you ask what happened the last time, when was that? That is relevant for us to collect evidence. So within 96 hours if it was there, then the medical examination becomes important. And when was the first time the sexual assault occurred? Because that for the child's memory stays longer. So these 2 you can take, and then in between, where was it, how was it, all that. These are all histories that can be taken. Next thing, there is a detail, there is just blank space, which is the narrative. And that is what, as the doctor had mentioned, the narrative of what exactly in the child's own words. Now in this case, it's not easy for children to speak about it. So this is what I use. When you ask a child of 6 or 7, when you ask a child of 6, 7, 8 years, they really don't know body parts. They call it chichi, pee-pee, susu, you don't know what they're saying. So I show them these pictures and I say, if it was a male perpetrator with a female child, I will show these. If it is a male perpetrator, male child, I will show 2 pictures of male. And I will just say, what are the parts of the body, can you just show me? And they will say, this is the PP, this is this. Even a 3-4-year-old child has an understanding. And then we just ask, where did the person touch you? And on this, I will write the FIR number, I will write the date, and I will give a copy of this to the police, because anatomic diagrams are acceptable as evidence, because a 6 or 7-year-old child can indicate that the person with the perpetrator with this part of his body touched this part of my body, that sort of thing can be written down. Plus the back also is there, as in some boys where there is a question of sodomy, they will show the buttocks. So these are things that we can use, anatomic charts, diagrams, which can be used. They are also acceptable in court, because I have gone to court 2-3 times and these anatomic diagrams were part of the case sheet. So we can use that. Then also importance of looking at physical violence, whether any drugs were given, what happened exactly, all the details are given. So it's very important, the details of the sexual violence, what was used for penetration, what was done, was there drugs given, was there alcohol, was there violence used, was there threats of death, was a knife used, all these things help in talking about aggravated to not aggravated. Then post the incident, has the survivor had a bath, washed, vomited, cleaned, all that becomes very important, because very often from FSL we will get no evidence seen, no sperm seen. Why was that? Because the person has bathed so many times, has had it. Even for the clothes, in detail we'll write down, are the clothes the child is wearing or the survivor is wearing the same as that was worn during the time of the assault. If it is, they will be collected, but if it is not, you write it down. And then you tell the police person. They are saying they took the clothes and threw it in one corner of the house. So very definitely with the mazhar, the police can go and find those clothes. Then the full general examination. For a child, don't make them feel that this genitals is something horrible. So a child expects a doctor to see their eyes and nose. So we make the child sit on the chair. So with the child, when I talk to the for the medical exam, I will say, I'm going to ask you to have a medical examination. Your mother, father, grandmother will hold your hand right through. If at any time you want me to stop, please tell me and I will stop. And I use a sheet to cover the child every time. So when the child is lying down, I will use a sheet. I will ask the child to take off their top themselves, or ask the mother or aunt to help, rather than someone, a medical or the nurse, roughly pulling it out. So we ask them to take it off, check the top, then put the sheet, cover the child from the upper part and examine the lower part. So the child feels that your whole person is of importance, and that I am interested in your medical care for every part of you. It's not just whether you were sexually assaulted or not. There are pictures, very beautiful pictures given, so please use these pictures for diagrams, mark it. Obviously, a Chinese saying is that the palest ink is better than the strongest memory. So when you go to court 1 year, 2 years later, to remember where were the bruises and all, if you mark it over here, especially on the back, if a child has been sexually assaulted and they have fallen on the ground, there will be marks of injuries on the back. So please see that you see both sides, front and back. Then each part of the body is also seen, and they have given diagrams again. There are diagrams again of the genital parts. So the entire body and the genitals are there, so you can mark any injuries which are there. As we all know, the 2-finger test is not valid anymore. It makes no sense. And the hymen is not mentioned at all, because the presence or absence of a hymen has nothing to do with whether assault occurred. We just look at injuries, scratch marks, bruises, bleeding, and then we look at what is the trauma which is there. There may be healed injuries which may be there. Then there is a nice paper or sheet on what is collected. So even there, I don't have to strain my brain. Everything is there. Stains, whether semen stains, vaginal swab, vulval swab, rectal swab, oral swab, everything is written. I just have to tick them. It actually makes, for the doctors, makes life very, very easy. And then finally, provisional medical report. You have to give a provisional medical report when the child first comes. And this is the MOHFW forms. At the base it is written, this pro forma contains 4 copies of each sheet. Sheets are to be distributed as follows: pink for the patient, yellow for the police, blue for FSL, and white for the hospital. You have to give 1 copy of the medical report to the patient, to the child survivor. Most doctors say, why do I have to give it? So what happens is when you give the medical report and all the details of FSL go in the charge sheet, and the defense lawyer will get the whole amount, the accused will get it, and they can sit piece by piece to refute every point. Whereas a child, the survivor, has not got the report, so they don't know what is given. So what you're basically doing is helping the accused. You're not creating a level battlefield. So you must give, because you have examined the patient, and the patient, the survivor, has given you permission, consented for you to examine her or him. It is your duty bound to give a copy of the medical report to the family. It's important. And finally, what is your treatment that you're given? Emergency contraceptive pill. If she is post-menarche, that means she's already started her periods, she could become pregnant, please give her that. Give her antibiotics, antifungals, painkillers, whatever is needed for her to be stabilized. Generally, if the accused has been caught, the accused examination is done. If there is HIV or hepatitis B, you need to give the girl prophylaxis to prevent her from getting these infections. And it's very important to do HIV, hepatitis B if it's an older girl and there was gang rape, or the accused was a person with known sexual irregular behavior. Then it is better to do the test, but also do it after 6 weeks. Because if she was assaulted yesterday, day before, doing HIV, hepatitis B today will not give you a positive. It only becomes positive after 2 weeks to 6 weeks. So after 6 weeks, we have to do a follow-up checkup. And of course for pregnancy also, because though we give the emergency contraceptive, it's not 100% sure, it's 60% effective. They should not. And then final opinion. Please do not give a medical report saying, final report will be given when the FSL report arrives. Please don't do that. Write down all the details. Your physical findings are not going to change after FSL comes in. So please write down all details. Even if you have found no injuries, please write. No physical injuries seen. Please do not say no rape has occurred. Unless you were actually standing over there watching what was happening, you cannot say it. You can only say sexual assault cannot be ruled out. Please write that. Rape is a legal term. Doctors cannot use it. You have to only say penetrative sexual assault seen, evidence of penetrative assault, or you will say no evidence of penetrative assault, but sexual assault cannot be ruled out. Because by the new POXO Act, even the touching of that area with the penis or the finger is considered a sexual assault. It could be non-penetrative. It's not necessary. They will leave injuries. And as we know, in Australia, they had done a study on 100 women who had been raped, and they found that only 36% had any injury marks. The remaining 74 had no injury marks, though it was definite that they had all been raped. So to understand that that part also heals faster, because childbirth occurs from there, that area has the ability to heal fast, with tears also. And that is one of the reasons we may not get injuries if the child comes to us after 2-3 months. It's very important. And the final report, please to give it. Estimation of age does not need to be done unless the court requests it, because it's always better, rather than putting the child through x-rays, it's better to let the certificates, which the police will handle. Only if they're needed, police will get a court order, in which case you will do the x-ray examination of the child. And finally, requisition for the lab. For the FSL, please write it in detail what you have collected, what you want it for. In one case, an underwear was given, in which it was written underwear sent for semen, and they forgot there was a blood stain there, and they forgot to mention it. So FSL just sent back saying semen not there. But they did not check about the blood. So please take a little care to write down everything that you want done so that it comes in from you. I'll just show you this quickly. So this is part of it. The questionnaire was one, the whole questionnaire. My anatomic charts for especially younger children, even older ones who are scared. Now in my kit, I have something, I won't call it a kit, let's just call it a trolley, like we have an emergency trolley or a suturing trolley or an anesthesia drugs trolley, similarly. So I have sterile gloves, which you will use when you use it. I have a comb to comb the pubic hair if there is, because we know when two bodies come in contact with each other, there will be a crossover of tissue can occur. So the comb. I have a forceps and if the person says so if there's any hair or any other things on the body which can be picked up with the forceps, I would. I have the best thing, if the person says I scratch the person, then with the toothpick, we just scrape the under part of the nails and we collect that in a paper and we fold it and put it in. Scissors, measuring tape, please measure any injuries or anything which is there, because it's better to measure and write it down. So sometimes the swabs are dry, so I have swabs also. I have sterile swabs which are collected. Now these are swabs which we open out, they are sterile. Whether I want to take oral mucosal swabs, whether I want to take vaginal swabs, vulval swabs, anal swab if it's a case of sodomy, I will use this. If it was on the body, I see some stains on the inner thighs which look as if there could be semen or thing, then they are dry. So I will use distilled water, put a few drops, wet it and scrape it and then collect it. Don't send this directly to FSL. By the time it reaches, it will have so much fungus you can't even recognize it. Keep it out, let it dry. Oh, okay, it's not, they can't hear me? Okay, yeah, all right, yeah. Yes, so sorry, thank you. So you will dry this and put it in. This is the swabs that you will use. You also have a syringe. All this is, everything is there in one's OPD. You have blotting paper. If you find saliva stains, so the person, one child who had come to me, the man had bitten her on the breast. So there were saliva stains, you can collect DNA from saliva. Again, I took a few drops of distilled water, dropped it on that area, around the breast, and put the blotting paper and wiped it up. And this is given, you just mark it like this and write what it is there. These are done. Then you have syringe and blood. We collect urine for pregnancy test or urine infection. We have a plain bulb for blood grouping. We have EDTA bulb for DNA checking. And we have a sodium fluoride bulb which is for alcohol or if the person has been given any drugs, any history of drugs. So these are the three we would collect in case there is such a history which is there. If the girl is pregnant, then I would do blood tests for HIV, hepatitis B, hemoglobin and her blood group for her health care. That's all that is needed. Other than that, there are slides. I have a set of slides, so when I take a swab, I just put it onto the slide, let it dry and put it inside. Each of these items has to go into a separate envelope. Each of these are separate envelopes. Always use paper envelopes, not plastic, because the plastic causes steam inside. So paper, dry the sample, and each one has to be put into a separate one. You have to label each one of them. I have made these labels as a demo only because these are like, in our school books we used to put these labels. It's so much simpler because it has everything, the patient name, the FIR number, everything is there, date of collection and all that. But you can always just do it with a normal paper. Then everything is put into a cloth-lined bag. So biochemical ones are separate and body collection. So if you have any clothes which you have collected, each cloth has to be air-dried in the room. Have it air-dried, fold it and put it into different envelopes and pack the whole thing. Once you finish, the police normally come with luck and you have a seal. You put a seal on it, you will sign across the seal. And the police officer will also sign across it. Whoever's taking it, the police person who is taking the thing will sign for chain of custody. It should be written in your medical report. And the FSL sheet, it is there, one of which says the hospital as to what all you have collected. If it's very late at night and the police is not going to be able to take it to the FSL, it has to be kept in a safe place, locked, under lock and key till the police come and collect it the next time. For medical termination of pregnancy in a case of sexual assault where the products of conception are part of your evidence. So you will do the termination of pregnancy. One of the two problems I had once was a girl who was about 14 years old who was 2 months pregnant. So we had given her the tablets, she went to the bathroom and she delivered in the bathroom and she flushed it. I'm like, okay, now I'm going to jail because I've lost the evidence. So luckily the case, I think the boy ran away or something like that. So the case is still pending somewhere. But whenever they come, they're probably going to catch me. But the point is we normally use a diaper with girls who are like that, who are having the tablets which we are giving the MTP kit. We give them a diaper so that the products of conception comes out in the diaper. And so that we can collect it from there and save it for police evidence. It does not need much tissue. Suppose there is a fetus, 2-3 weeks, 2-3 months, 5 months, even just a piece from the this thing, what you call it, from the thigh, a piece of tissue from the thigh is sufficient for DNA. You don't have to take the full fetus. But when the fetus delivers, you have to write down the weight of the fetus, the gender of the fetus, and anything else abnormalities you may see in the fetus has to be noted down in your case sheet. So that is very clear. Products of conception, how do we send it? You take a small, any bottle, masala bottle or something like a plastic one, see that it's washed properly, and then you fill it with salt, normal table salt. You put in the products of conception, pour the salt over it till it's completely covered, and then you seal it, and that's sufficient. That is similar to a hyperosmolar salt solution, and it'll last for whatever 6 weeks, 8 weeks, 10 weeks till it reaches FSL and comes back to you. Any other questions? Any questions? Yes. Please.
Is there anybody from Negrims Hospital?
Anyone from Negrims here? No. What are the problems
the thing
you're
is
facing?
that when samples are collected, they do not sign the seizure list. And when we send to FSL, the exhibits come back because there is no seizure list.
Right.
So that has been a problem. At the hospital, they don't sign the seizure list. They give some form. They said, we have given you this form, we won't sign the seizure list. But when it is sent to FSL, it comes back.
Yeah.
Because there is no seizure list.
Correct. Chain of custody is broken.
Yes. And then there is another case where a 13-year-old girl hanged herself. And in the post-mortem report, there was, they had mentioned about sexual abuse. So now the accused is unknown. The victim is dead. So it will take some time to find out the accused.
Yes.
So we thought that if we keep the exhibits till the accused is arrested, then it will degenerate. So we had sent only those samples collected from the victim to FSL. We thought maybe we'll get that DNA profiling and all that.
Yes.
So when we get the accused, then we can send for comparison.
Yes.
But that also returned from FSL.
Why?
I don't know, because there's nothing sent for comparison.
So
these are the problems the IOs faced.
Absolutely valid problems, I can see that. For Negrims, maybe if you want, we can ask the Director of Health Services to speak to them, Dr. Wansit, would that be possible? We can request them, and if needed, we can do a training for them. I think that's not an issue. Definitely, because if they don't sign, your chain of custody is broken, and your FSL will not take it. And the signing it should not be an issue, because whoever's the doctor who would come to court at whatever time, they would have to sign anyway. So that can definitely be done. Regarding the second case, in terms of how long can we keep, so basically our problem is, as per the Evidence Act, we cannot destroy evidence. It has to be stored, and mostly it will be stored in FSL, because you can't keep it in your police station. So FSL will have to keep it, but they will have to do the DNA, because DNA, by the way, is just a matching. It's not that I will see the DNA and say that person is the accused. So DNA means I have got a set of genetic material from this person. I get a genetic, so in this person's body, I see her genetic composition, and I put it against this, and I say, oh, this one is not the same as this. That means this is probably the assailant's, maybe. Then once at some time the assailant is caught, that assailant's DNA is matched against this one, and out of those 16 points, at least 8 should match. Sometimes it may be 16 on 16 match. So it's always, as you said, a comparison. So until you get even a possible assailant, you will not be able to match it. We cannot destroy it. So here, it will have to be a policy of your police station, and that you will need your seniors to say, do we keep the DNA, they have it on a paper, they have the DNA print of the child, or whatever swabs were taken will be on a certain picture. That can be saved in the police station, in the case sheet, and the case is kept open, or does FSL store it and keep it? That will have to be done, but they should not send it back. Thank you. That was very relevant questions. Anybody else? Any other questions? Yes. Sorry, just a thing. Yes.
I just want to ask whether all registered medical practitioner can do MTP.
So actually, registered medical practitioners and MBBS, so they have already done in their internship, they should have done 3 months in a gynecology ward. The RMP, any medical officer, registered medical practitioner who's a MBBS doctor, if they have assisted 25 MTPs during their internship, or if they have done 6 months in an OB-GYN ward, or if they have, of course, a diploma OB-GYN, then they can do MTPs, yes.
But in the state, we are having this comprehensive abortion care
Yes,
course of
yes.
2 weeks.
Yes, so if that is done, that is the same as guidance for, because that is for lesser pregnancies, so that gives them the right to do it. And all government hospitals anyway are registered MTP centers, so they can do it if they've completed the CAC training, yes.
Thank you.
The only thing is, you need to have to do MTPs less than 9 weeks, just the tablets are sufficient. We give the MTP kit and they can take it at home. But if it is more than 10 weeks, because of the risk of bleeding, and if the patient stays far away where it's difficult to come, it is better to do it in the hospital, admit the hospital, give her the tablets, let her deliver or expel the products in the hospital and then send her home. That's better. What I find with a lot of patients is, they don't want to go to the PHC because the PHC is in their village and people know them, like other patients will see them. So that's why they prefer to go to the district hospital where they may not be known, or they like to go to a different district, which is a concern. That is a concern that we are not able to maintain confidentiality in the hospital. To be very particular. Any other questions? Yes.
Ma'am, regarding MTP, like us, we are a medical practitioner, registered medical practitioner, but then we have not received that comprehensive training regarding MTP. And working in the PAC or CAC, where there are certain patients, they don't want to go to the district hospital.
Yes.
So since we have not received training, but we have the knowledge to undergo with the MTP, so in that case, can we do or?
So as per the latest guidelines for MTP Act, any RMP can do it if they have been trained. So the training only means that if you have done the CAC, it would be better to get the CAC done just in terms of patient care. So if you can do the 2 weeks training, and if it is an issue, then you can let us know and then we will complete the CAC training. CAC training is done for all MOs, Dr. Monswar? It is done, no? I think it will be done. It is better to give it done actually for the MTP tablets. The patient takes it by themselves. But the only thing we require is we need to do an ultrasound, because the only issue is if it is an ectopic pregnancy, it can be ruptured and that can cause risk to the woman. So basically, while RMPs are doing it, I would just suggest get the CAC done, because then you are on a strong legal background. Or otherwise, the other option is you call the gynecologist. Now we are going to have CMOC doctors. Some new CMOC doctors have come in. FRUs are coming up. So you can call the CMOC doctor and under their supervision say, I am giving these medicines to this patient. This is a scan. This is it. And you can write, discussed with Dr. So-and-so, and with their, supervision, you are doing it. That would be work fine. Yeah.
Okay. In case we have not undergone the training and the patient happens to come before that, then how to go about it?
You're walking a dangerous line.
Because there are certain patients,
yes.
they prefer to go to the quacks.
No, I totally agree. I would say yes, please do it. But if you get into trouble, I don't want to be blamed saying I told you can do it. It's not fair. It's not fair on you. And also, the training of 2 weeks helps us understand what are the problems. Because I have seen so many patients in Bangalore who come to me, 4 grams hemoglobin, because they just went to the pharmacy and took tablets. And nobody catches the pharmacist. Or they'll go over here, but I found one case which was in Vagesi and towards North Garo Hills. They go to Assam and they pick up the tablets from there and they take it, because here you have to have a prescription. So they take the tablets and they get into health issues. I would definitely prefer them to have it under supervision of the MO, because you're an MBBS doctor, which means you can do deliveries also, right?
Yes, ma'am.
But the problem is, if it has a problem, if the patient dies or becomes serious, then the question will arise. So while it may not happen very often, Murphy's Law generally means that some things will go wrong when we don't have our paperwork in order. I would suggest get it.
So ma'am, in that case, if the patient doesn't go to the district hospital and if we don't give them the treatment and then they prefer to go to the quack, so in that case
I'm not happy about it. I would just like you to do the CAC. Tell your DMHO, I want to go for the CAC tomorrow when I come back from Shillong. I want it immediately. Just do it.
Okay, ma'am. Thank you, ma'am.
Welcome. Any other questions? Yes. Can we have a mic there, please? Yeah.
Good afternoon, ma'am. Ma'am, I just wanted to inquire about that form which you have shown. It's very detailed form which you have shown. We have never seen such form. So how to implement this form now?
So this is actually, you can download it from the internet. Ministry of Health and Family Welfare Guidelines has it. What we have, like in Ganesh Das and what the others have, is a small, ma'am, do you have that form with you? Same one, no? So Ganesh Das also has the same form. The only thing is the medical report is written on a sheet of paper with the Ganesh Das thing, but this is being used everywhere. So if it's not there, you can ask the doctors, like suppose there is a particular hospital you're going to, just tell doctors, keep 10 sets of this in your hospital. Just keep 10 sets over there. When you come to 9 sets, print it again. It should definitely be used.
Then they will ask for the circular, that we haven't got the circular, so we are not following this format.
Tell me which hospital, I'll see that they get the forms.
Till now, we have not seen this report being given.
Right, okay. So we are continuing the training and we will ensure that this is done, yes. This is what we are doing with the training for doctors.
Ma'am, which I want to ask is, from police side we have to push, or from the health department side, it has to be, means to make it mandatory that each and every medical legal report which is being given has to be in this form. So from which department it has to push?
Directorate of Health Services. So if your DGIGP writes to them and say that we would like this form to be, and we would like medical reports to come in this format, because it just makes our life so much easier, and it also gives justice to the child, right? We're talking about that ultimately. We're not talking of creating paperwork for people. We're saying if this form gets filled, there is more accurate reporting, there is more accurate collection of evidence. Definitely it will work.
And one more point, ma'am. In this form, it is written what needs to be tested, what needs to be preserved.
Yes.
This has to be done by the doctor without the requisition of the police?
Yes.
Because sometimes they, means our doctor friends also, they wait for the requisition.
Yes.
Suppose sometimes our IO also miss some of the important points. Then they don't preserve that, which is very important evidence.
So you remember earlier, before POXO came in, we used to have this funny sheet which said, is the person, has sexual intercourse occurred? Is this person habituated to sexual intercourse? You remember it was a very absurd thing which we used to use earlier. And now we have become more sensitive and more efficient also. So I definitely feel the doctor should not wait for a requisition, because the doctor is getting the most important history. Like as a police officer, you may get a lot of history of the assault and everything. But in terms of the actual nitty-gritty of what happens, which will guide the medical examination and the collection of, like if they say it happened 2 months ago, I would not expect the doctor to collect anything. Whereas the IO may just say, collect all clothes and collect all swabs required. Correct? But the doctor will be able to write down in detail, and everything has to be documented. So I do not think the doctors should wait for the IO's requisition unless there is something additional that the IO is asking, which the doctor can ask. I really feel one of the important things is collaboration. Working between where I come there, where the policeman is not my sworn enemy, and the doctor is not, because you know the police earlier on would say things like, I'll put you in jail if you don't do this. And the doctor saying, patient is refusing examination, and the police is saying, do it, you know. So I think that understanding is growing with POXO, that we can work together, and convergence is always better.
Okay. Thank you.
Thank you. Any other questions? Yes. And we are going to break for lunch after the next 2 questions. Yes.
Good afternoon, madam.
I'll just finish with her. I think she's waiting for the mobile. Yeah, go ahead. After that, we'll come back to her.
Madam, we have heard about responsibility of the different persons. Then we also heard about the compensation also.
Yes.
Sir, madam, we want to know more about the compensation. Who are the eligible people? Then where to go about, and what are documents or what are things they have to do, madam, please.
So under the POXO Act, POXO rules, there is a compensation given which has already been given very specifically, but in between there is an interim compensation. So when a case comes into the special court, the court gives an order for the compensation. It may be either be given by DLSA or it is given by the Women and Child Department, one of the two. We'll have to find out who gives it. Normally it is 3,000 or 5,000 rupees up to 10,000, which is given as an interim compensation for the families who live far away and who are in poverty. This is where the support person helps, and the CWC also gives a report saying they are coming from financial difficulty areas. The parents will lose a daily wage every time to travel up and down, and you know it's expensive to travel from the villages to the courts. So that is given. In case there is an acquittal, then the compensation often is paid back, has to be paid back. That is the interim compensation. At the end, if there is a conviction, if it is a rape, it is 3 lakhs. If it is certain others, there are 1 lakh, 1.5, 50,000 depending on injuries. There is a, I don't remember it exactly, but there is a definite gradation of what injury to what amount of compensation. It is given in the POCSO rules. That is given. But I feel the interim, what my NGO works with, is often helping them with the interim compensation, because we have always worked with people, I mean families where we know that it was sexual assault, you know, it definitely occurred. So though we may not be sure about the acquittal, at least the 3,500 in Karnataka is given by the DLSA, the Legal Services Authority, so that is given to the family. And it has to be given immediately, because as soon as the charge sheet comes into the special court, the court gives an order for the interim compensation. Any other? Yes, you had a question.
Ma'am, I'd like to ask like 2 questions. One question is, how do maybe doctors or any interviewer collect narration from a child who is mentally or intellectually disabled?
Yes.
Especially when speech impairment is quite prominent.
Mm-hmm.
Like how do narration is, you know?
So with doctors, so the DCPU has to have a list of interpreters for different languages as well as special educators. Also sign language experts. So you should have a list. The DCPU has to have a list of interpreters of different languages, which is commonly found in your particular district. A special educator who can talk especially to a child who is, say, autistic or has mental disability. And thirdly, sign language. If the child is deaf and not able to, you know, articulate, then for these 3, you have to have that, who will assist you in the. They also assist the magistrate in the 164 statement. So therefore, they will assist the doctor.
In case now, ma'am, if the child is not able to respond to sign language,
yes,
like what can be the option, you know, for that?
So usually, if the child has been brought, either somebody has seen the assault occurring, or they have given the history. The child was found crying, there was bleeding from the genitals, something has happened. Otherwise, why would the child be brought, right? So taking that history, you write it as informant is mother or informant is sister or so and so, and the history what they have given, that I found the child lying on the side, you know, crying, and the clothes had been removed and there was bleeding from here, there. So when that is written, you just take that narration and you write down. The child, sometimes the child is in shock, deep shock, so the child is not able to respond. Child is autistic, child has hearing disability, child is blind, so cannot speak. Then you just do the head-to-toe examination of the child, and you're looking both for the health reasons as well as the other.
All right. And another question, ma'am, I would like to ask is, suppose a child is unable to narrate the incident.
Yes.
Okay, because she is, you know, again disabled intellectually.
Yes.
And does the child has to go to hearings like over and over, especially when the child is being certified already?
So that is where, in fact, we don't want the child, even for a POCSO, a child who is perfectly normative, who does not have any special needs or disability, is also not meant to come to the courts, and that is for the judges to say that the child will come in once for a checkup. The child cannot come and then the defense attorney says, oh, I don't have my papers, or I'm not ready for the cross, and I'm not ready for this, and that cannot be done. So that way the support person is very useful. And also the support person can give a report to the judge or talk to the CWC, who will send a social audit report to the judge saying that the child has come 3 times and the case was cancelled and things like that, or the hearing was cancelled, it is causing distress to the child. And there a special interpreter is asked to come in. So sometimes the child is just upset or anxious and all that, but they have to see the child. Unfortunately, our systems are such. Earlier we could have a video, you know, earlier during COVID we were having video interviews. But the special educator and the guardian or the person who the child trusts will be there in the courtroom with the child. That's the maximum which can be done right now under POCSO.
Thank you, ma'am.
There's 1 or 2 cases, we have Nimhans in Bangalore. So there the child was 5 or 6 years old, very small, had a lot of autism and other issues. So there the doctor gave a very detailed history of the child, psychological issues, this, that, and also showed that during play therapy, this was shown that this had occurred, and the rest had to be through circumstantial evidence.
Okay, but what I want to know, like in more detail, is especially after being certified, okay, that the child is mentally or moderately intellectual disabled, but the child is being asked to come again and again. That is traumatizing enough for the child to keep, seeing the courtroom or the, people who would ask, questions, especially when she's unable to answer to questions. She could not relate any experiences. So, like,
that is why POCSO wants it to be time bound. And that is where the judge has to make a decision whether, because that is how perpetrators, accused get away. They keep on harassing them, coming again and again and again, then finishing half the cross and saying we haven't done it, let's do it again, another date, hoping that the child forgets. And the child may say one thing now, next time make a confusion, so they immediately pick up on that point. This is basically ploys by the accused to ensure that the accused gets away. So this is something that only the honorable judges can rule if they feel that there is unfair tactics being used, delayed tactics. I think I had gone once for a medical thing where they called me 3 times. Third time they called me, and third time the defense lawyer said, oh, I didn't bring my file, I didn't know the doctor was going to come. I got a summons, okay, for that. And so the judge said that if you do not cross-examine her today, this is the third time she's come, she cannot leave her OPD every time. I will consider that her examination is over and you will not get a chance to do it. So they pulled out the file suddenly and cross-examined me. So that way having a tough judge also works.
Thank you, ma'am.
Any other questions? Oops, yes, last.
Actually, ma'am, I just wanted to ask regarding examination, because after the DNA test has already been done, but when the test comes out, it comes out negative, whether that affects the case or not, because we've had several cases like that. So how will this pan out if
so that is why in the doctor's report it's very important to say that the child had bathed very often, cleaned, washed, done all this, douched, because when only they do that, then we expect that there may not be DNA. And ultimately Supreme Court has said that the testimony of the prosecutrix is your ultimate importance. If it can be trusted, that is the best and only thing that the judgment needs to depend on, provided circumstantial evidence does not go against it.
Ma'am, actually the DNA test is of a child who has already given birth to a baby. The DNA test is of the baby.
Correct, but it doesn't match with the
accused, yes, ma'am.
But the girl says that's the accused?
Yes.
So what they call it is many a slip between the cup and the lip. And for that we need to look at the whole chain of custody. That's why chain of custody is very, very important. It's very not difficult to mix up slides. Okay, that's about all I'm going to put my foot into. Okay, that's it. Yeah, thank you so much. Let's get back to lunch. Yes.
Madam, I have one question.
Okay.
Like post sexual assault, suppose it happened more than 72 hours, how crucial is sample collection important for that particular case?
After 72 hours, it's pretty much not going to happen. You have to only look at injuries and physical injuries and things like that. The chance of getting evidence is less, but the Health and Family Welfare Guidelines says 96 hours. But you have to write in detail. That is why documentation is very important, where you write child has bathed, washed, cleaned, all these things. So that also explains why the DNA may not match or the DNA may be absent.
And ma'am, recently there was a case where a 1-year-old child, a baby girl, was brought to the hospital and along with her parents and her grandmother. And the thing was that the parents were a little bit anxious regarding what happened to their daughter, because the next morning they noticed that there were some blood stains on the bed sheets. But then they weren't able to rule out whether there was any act of sexual intercourse or any foul play.
Yeah.
But even then, I cross-examined and I did take a proper history from the parents and the grandmother also. And they did insist that there was no act of any sexual activity. And the child was playful and seems to be fit. So in the history, I just mentioned that after proper and careful examination, the child seems to be physically and mentally healthy, and there's no signs of any foul play noticed.
We can't say no signs of foul play. We can only say no injury seen.
Yeah.
Because foul play, we don't know. They could have been foul play with abuse occurring, but no bruises or no thing. The person may have been more careful not to ensure, but there was bleeding also. It could have been an insect bite or a mosquito bite. We don't know.
Yeah.
These are always cases where I am also left in a quandary, 1 year, 2 year old, where they find the child with bleeding. They're not sure. Parents come, you say, parents have come with suspicion of abuse, but not sure. No assailancy, nobody has seen anything, but they have a doubt. We can just examine the child and give the parents what is called anticipatory guidance, in the sense that watch who comes to your house, see who's coming and going, and as the child grows, you may get an idea of somebody who the child is shrinking from, scared of. Recurrent urinary tract infections, recurrent vaginal infections or infections around the lower part of the body. I have had a 2-year-old child with complete perineal warts, which is a human papilloma virus infection which is sexually transmitted in a 2-year-old child. So obviously someone has abused her, but they're not able to say who it could be. And since they don't have any suspicion, we cannot catch anyone, and there's no DNA or anything that I can take up. So here these cases are complicated, and we always end up with a question. We can file an FIR, tell the parents to talk about it, so that everybody, if the assailant is there, knows that they are being watched. And also, if there's an assailant in the house or in the neighborhood, they attack many kids. So talking about, saying my child had this problem, I don't know what's happening, I hope everybody is fine, is any other child having these problems? You are creating a public space to talk about it, so that a person has to be more careful or avoid doing it because they know that people are watching out for it. That's all we can do. I've had cases where a girl has come with a tear. She says she fell from the stool and she fell on the stool and it cut her. She fell on the side of the stool fell and she fell like this. But I felt it was quite deep. But I asked her question. She said no. There was nobody else in the house. I'm always left in confusion. But I just gave her anticipatory guidance that if anyone's troubling you, you are always welcome to come and talk to me. We will prevent it from happening again, and that's all we can do.
Okay, sure. Yeah. Thank you, ma'am.
Okay, thank you so much. Let's head for lunch. It is 1:05. We're late. And we will come back at 1:30. Oh my goodness, the line is so long. Please go ahead, have lunch and come back soon. 1:40, I think we shall have to settle in. I will reduce the cases. Let's give them a decent lunch. Thank you for waiting so patiently. Go ahead.
We have now come to the fourth session of this workshop. It is a panel discussion, and we have our esteemed panelists here. May I invite Shri Davis N.R. Marak, IPS, Deputy Inspector General of Police, Eastern Range, Meghalaya, Shillong, to the dais. Shri F.S. Sangma, Special Judge POCSO, Ribhoi District. May I invite Sir to the dais. Dr. N. Wansmet, Consultant, Obstetrician and Gynecologist and POCSO Trainer. Ms. Jill Malbanian, Center Manager, cum Protection Officer, One Stop Center, Shillong. Ms. Mimiolan Konghat, Protection Officer, Institutional Care Support Person, East Khasi Hills. Ms. Clarabelle Malnyang, Legal cum Probation Officer, DCPU Shillong. Ms. D.P. Shadab, Scientific Officer, FSL, retired. And ma'am, yes, we can start the session. Without you, the session will not happen.
Good afternoon, welcome back after lunch. That lunch was really lovely and tasty, and if any of you sleep, you are all forgiven. Only request is don't snore loudly because that will affect your neighbors. Let us start. I would like to thank all the panelists. Thank you so much for having agreed to be part of this panel, and we have great hopes for the panel to bring about changes not just in the terms of training for POCSO but in policy changes, and that is what we look forward to. What I will be doing is reading out certain cases which have occurred over here, and I will be requesting the panelists to give their views on what would be their responsibility or their function in that sort of a case. I also request those of you who came in to give your, if you would like to ask questions from the panelists, you're very welcome to do so. The first case, a 14-year-old girl, a student of class 9 in a private school, was a little weak in mathematics and physics. Her teacher would insist that she stays back for extra classes to help her in her studies, and he would touch her all over her body inappropriately. The girl tried to avoid him, but he would comment on her risk of failing in her exams and that she was being ungrateful when he was helping her for free. Finally, she told her mother, who discussed with the family and then went to the Senkinthai. Along with them, she went to the school to complain to the principal. The teacher was suspended for a few days, and while a case has been filed at the police station, no one is aware of the status. So in this case, I would like to talk to first the support persons to find out what do you think would be your job or your responsibility in this case?
Yes, good afternoon everyone. Regarding this one, as we know, it's supposed that when the case is already filed in the police station, and it will go accordingly where the police will intimate the CWC, and the CWC will appoint the support person accordingly. And it will be the duty on the part of the support person to go and ask from the police regarding the status of the case. And after knowing the status of the case, the support person will be able to give the information to the family and to let them know about the status of the case and where it has reached, where they have to go, what they have to do, all those things where the family need to know about it.
Where would they have to go?
Pardon me, where did they have to go? You said you'll guide them now to the next step. So the mother has come to you. They've gone to the police station, but they don't know what next, what happens now. Like I said, the support person itself will go and ask from the IO regarding the status of the case. And after knowing the status of the case, then the support person will inform the family about the status of the case, where it has reached, what is the next step has to be done. Right, thank you. Mr. Davis, could I ask you, what will the police do in this case?
Yeah, thank you, ma'am. Very good afternoon to everyone. The first thing, as far as I can see from this scenario, the case has already been registered, and it seems the police officer has not done his duty. The first thing that needs to be done is when a POCSO case is registered. In the POCSO Act, there are certain elections, and at the end, there is something called Form A. And in Form A here, it talks about entitlement of children who have suffered from sexual abuse to receive information and services. And the first entitlement for the family member and the members and the victim is that they are entitled to receive the copy of the FIR. They are supposed to receive adequate security and protection from police. They are supposed to receive immediate and free medical examination by civil hospital, PHC, etc., to receive counseling and consultation, etc. In other words, this form is supposed to be signed and given to the victim, and this has to be explained by the Child Welfare Protection Officer, Child Welfare Police Officer in the police station. In each and every police station in Meghalaya, child welfare police officers have been appointed. In the absence of the child welfare police officer, the officer in charge of the police station, he or she should mandatorily give this entitlements free of cost as per Form A, and it should be signed by that officer, and it has to be received by the victim or his or her family members. So, having said that, all the forms will be given, and necessary counseling is to be given to the victim, and they will also be told as to what to do next as far as the case is concerned. So here it seems from the case study, it seems the police has not done its job, has not told the victim or briefed the victim of his or her entitlements, and I would see that there is a failure on the part of the police.
Thank you. Yes, I think, sometimes the police are so busy that a small case like this sort of gets lost in it. So I really think it's important that for that family there is a feedback to them and constant connection as to what is happening. Thank you. Now you mentioned medical examination. Dr. Wamswamy, what were the medical findings in this case? What would the doctor look for?
Good afternoon, everyone. As far as the examination in this case is, definitely if this case had come to us for either by herself or as through the maybe, of course, the police requisition, the IO requisition did not come to us. But if this girl was brought to us, we need to, from our first perspective, as such, it looks like from the history there will be not an emergency, she will be needing an emergency treatment. So definitely we'll go for registration of the case, then we'll go for the, after that we will explain things to her, because definitely we'll ask why she come. Then after that we would go ahead after the registration for taking the details, then we would go ahead to take her consent. Because as such we have to take the informed consent, whereby we will explain to her whether she wants to have a medical examination and treatment only, whether she would like us to perform a medical legal examination, and whether she would want for us to collect evidence. So actually we would from there onwards we would go ask her accordingly what her consent would be. If she wants to, and again for informing the police, that's another part of the informed consent which we would do, and depending on what will be her consent, then accordingly we will proceed. Now if she will consent really, because she have gone and filed along with the support person, gone to the police to file, definitely maybe we can presume that she wants a medical legal examination and collection of evidence. Then we will proceed to take a full history, a detailed history, because we know that history also has evidential, we take that it has an evidential value in the when we go to court. So definitely, because this case, in such a scenario, everything would depend more on the history. And then we would proceed for your examination, and definitely here we would go do a full physical examination and see for any evidence of any any evidence of trauma physically, and we would document as such. And as far as going ahead with the genital examination, maybe we will do it as we have to examine from head to toe, but definitely we don't know. So if I tell you that the girl said that the teacher would make her sit on his lap and he would just kiss her and touch her on her upper body, but he has not really touched her in her genital area. Well, in that case, if that is the history, then we don't need to proceed as such up to that part, the genital examination part and the collection evidence. But definitely, I think for this case, more we would dwell on the history, and in the physical examination, we would dwell more to look for the health consequences of what might have arisen from that. And definitely in this case, we expect that she'll have some amount of mental health consequences, which we will need going to refer to the appropriate. Thank you. Thank you very much for mentioning that, because it's not just the physical health, it is the emotional and mental health which is going to be a problem. Dr. Sharma, in this case, what would you suggest would be the forensic evidence collection? Because the last time we touched her was about 1 week before we had come to the hospital, and she says very clearly that he has not touched her below the waist. Good afternoon. In this case, madam, I think we should, if the physical evidences has not been collected by the doctors, then forensic science has nothing to do with it. But is there anything that you feel forensic would want from this case? Considering the history? Again, as what doctor said, that if there are any substantial evidences that they should collect, I feel that if it is, I would stress here if they would be like touch on the vaginal or penetration. So I think that will be very effective for examination. There has been. So this is me going to ask you, when the case comes to court, what are the things you would look for in this case? Because there is no forensic evidence, just the girl's testimony, her own statement, and yes.
Thank you, ma'am, and good afternoon, everyone. I hope I don't make you feel more sleepy, but okay, so anyway, the interesting thing about this is as the scenario that is narrated, it says that it has disappeared, the case. So what I gather from the situation is first that probably the person was not arrested. Because the interesting thing about the POCSO Act is excepting for Section 3 and the rest that comes up to Section 6, which is falls under the category of heinous offence defined in the JJ Act. The rest of them, the punishment is not more than 7 years. So it comes under the category which is covered by the Avinash Kumar's judgment, which says that only arrest when it is absolutely necessary, and the reasons have to be given. So perhaps in this case, as the scenario is given, the person has not been arrested. But the first thing is that I can see that the case has been registered. So So when the case is registered, the prosecuting inspector, which is the liaison between the police department and the court, so places the FIR. Places the FIR in front of the magistrate. But in case of POXO cases here on the state, they normally place it directly with the POXO judge. So now there is an interesting provision that has come in 2013 in section 164. So it is subsection 5A. It says in cases punishable under section 354, 354A, 354B. Now the interesting thing is that these offences of section 7, which involves touch. So inevitably it can come under 354 because there is use of force to outrage the modesty of a woman. Or say gestures under 354A also, which is of a sexual nature, sexual harassment. Then 354B, if there is unclothing and so on and so forth, but this comes under 5A. So what it says that the judicial magistrate shall record in cases under these sections, the judicial magistrate shall record the statement of the person whom such offence has been committed in the manner prescribed in subsection 5 as soon as the commission of the offence is brought to the notice of the police. That means the moment an FIR is filed, the statement must be recorded.
The 164 statement.
So yes, so normally for the judge who is sitting where the FIR is placed would probably pass an order immediately endorsing the recording of the statement to a particular judicial magistrate. If it is a normal case which goes to the chief judicial magistrate, they will probably do it. And if in case it is a POXO case, then the POXO judge will probably do it on the first day itself. When the order is passed.
What is the importance of the 164? Why is it insisted on in most POXO cases?
Yes. So see, there are many reasons for it, but one of the reasons which I had seen is dissociative amnesia. Now, dissociative amnesia is something where to deal with the trauma, people forget over time. Or the other thing is the concept of false memories. So false memories, what happens is, supposing I am a victim of trauma. So I will relive that moment in my mind, thinking, oh, if I had done this, then this would not have happened. If I had done this, this would not have happened. Now, a very interesting thing about the human mind is that when you start thinking something repetitively, then you may create false memories, one, on your own. Second is, you may discuss it with someone. Then when you discuss it with someone also, that discussion may again create false memories. And this may happen over time. So the idea is that immediately after the incident, when the child is still, or the victim is still able to remember much of what has happened, then we should try to record it. Because over time, sometimes, unfortunately of course, the cases come up for trial after 2-3 years, and the statement of the survivor or the victim is recorded, and much of it is already forgotten. But again here is a very interesting provision which many of us we overlook as well. The copies that are provided to the accused under 207 in POXO cases are provided to the survivor also. So it's a very interesting thing because the 164 statement, they have access to it. But of course, again, it would be a controversial topic for the defense counsels by saying that no, the victim is being allowed to, take the help of the 164 statement. But this is what the law is. So this is the initial stage, and the other thing that I can see over here is, supposing this child, because of this reason, if she loses her education, or she is unable to go to school because of this trauma, I think she will be eligible to receive the interim compensation as well. Now, even this interim compensation, there are many ways. I'm sorry I'm taking a little time. But there are many ways in which it can come to the, it can be granted to the survivor or the victim. The first is so motu by the court. So when it says so motu by the court, means the court has the power, again, on the very first day to ask for the medical examination report, the socio-economic reports from the DCPU or from the SDPU to be provided so that they can make an assessment on whether it is necessary. Amount, of course, will be decided by the District Legal Services Authority. But again, here the interesting point is for interim compensation, the court can also stipulate a certain amount because it is actually not a recommendation. The final order is a recommendation, but the interim compensation is not a recommendation. That's the first. Second thing is that they can approach the legal services. They can approach the legal services directly and file for application, for interim compensation. Legal services would ask for the records from the court or from the police at that point of time, and then they can decide on it. And the third way is also to approach the court while filing an application. So in the initial stage, when these children will come into the system, so the support bases which are required are already there. We just need to implement it. So once they have the information, and many times most of these survivors or victims are from the rural areas. They don't have the money, they don't have the knowledge, they don't have the time, in fact, even to do these. So the support person the other thing is that the moment the support person is provided to a survivor, it must be done within 24 hours. So if the police determines, the officer determines that this person requires a support person, they have to get the support person appointed immediately. And that has to be intimated to the court as well, that this is the support person who has been assigned to this particular case. And these support persons are the persons who would again inform these victims and the family that you can take the help of legal aid counsels.
Right.
Now it is not just that you have to take a long circuitous route of going through the legal services authority. Now every district we have a chief legal aid counsel as well.
Where are they based?
They are there in the court premises, and there is one in every district now.
Okay.
So there is a chief legal aid counsel whom they can seek help from.
They're not part of the district legal services.
They are part. Not as in the legal services authority, but then they are the empaneled legal aid counsels. And from amongst them, one chief legal aid counsel has been appointed.
Okay, that's wonderful to know. That's great. So that you know that in the districts you have chief legal aid, you said. That is really important. And I'm very happy to know that the court is willing to grant interim compensation for travel up and down. And what sometimes we found, especially when this happens in the school, the child drops out of the school because of the whole, furor over there. And then sometimes the parents are not able to pay the money required to get it into another school or shift to another school, buy the books and things, especially if they're a poorer socioeconomic status. So the interim compensation actually would help the child to stay in school and still continue, probably get into a new school where nobody knows about what's happened and can continue their studies. Because one of the things we find is the children dropping out of school, which is a concern. Is there anything you would like to add, Committee?
Just like to brief about the one-stop center. Actually, we have got a very limited role when it comes to POCSO cases, because the ministry has designed the one-stop center in such a way that we have to cater only to cases of women who face violence. So when we receive such cases of POCSO, the first thing that we do is we coordinate with the hospital, especially for facilitating the medical assistance, and as well as we do refer such cases that we receive to the concerned child welfare committees. So that's actually.
Thank you. What is the legal status of the school, Conclara? What is their responsibility and what is the action which can be taken against them?
Good afternoon, everyone. Actually, out here, the complaint has come to the principal of the school. So, as I can say that according to as per the RTE, but out here the child is 14 years old. So actually, since it's a private school, if the child at all has to drop out from the school, the principal or through the education department, the SDSEO or DSEO can refer the child for continuing her education.
Okay, so they can support that.
Yeah.
And can the school just escape with suspending the teacher?
No, not at all.
What has to be done?
The role of the school out here would be to
at least keep the confidentiality of the identity of the child. That is the utmost importance. And moreover, regarding the teacher of the school, he should not only be suspended.
Right, because very often what happens with teachers is they get suspended, they promptly go to another school and join over there and continue to abuse children. In the US, they found that any convicted offender, particularly teachers and coaches, had abused nothing less than 500 children. Because every time they would abuse, they would continue to abuse, and some child somewhere would report it, and they were so scared that their institution would get a bad name that they would immediately discharge the person, send them off, get rid of them, and that person would go to another school and get a job over there because they would not have anything written on their character certificate and would continue to do this. And obviously the confidence of the person keeps building when he realizes that nobody is going to take action against him. So I do believe that when this case occurs in a school, it's important for the school principal and their faculty to understand that their responsibility is to support the child. They are not responsible for the behavior of the teacher, but they are responsible for their behavior towards support for the child. That's important. Thank you so much. I'm going to the next case. A 12-year-old girl stayed with her maternal grandmother, her mother having passed away in childbirth when she was 7 years old. Her father works in Shillong and would come home during the weekend to stay with his 3 children at his wife's home. This girl kept falling sick, sometimes with fever, sometimes with loose motion, sometimes with abdominal pain. One day when she was home from school, she told her grandmother that her maternal uncle was repeatedly sexually assaulting her whenever he caught her alone. When the grandmother confronted him, he started shouting and getting aggressive. Ultimately, a police complaint was given by the father and the grandmother. There were arguments in the family about who was telling the truth. The perpetrator got bail. He stays in the same compound and continues to harass and intimidate the girl whenever he saw her. So here I would like to ask the police, what do you feel the police could do in this case and differently or supportively?
Ma'am, I think first thing is here, since this case, the first thing is, like I said, Form A and Form B will have to be filled up and given to the concerned court also, and asking for certain, and in this report also, for the medical requisition also, it will be very, very specific. Like for instance, here, it is said that she is complaining of some stomach ache and all that. So there is a possibility that there is a penetrative sexual assault. So in such a case, that needs to be determined by the medical practitioner. So a very specific requisition will be given to the medical practitioner as to whether there was any such kind of penetrative sexual assault. And accordingly, it is also sometimes what we have found is that when the police give such kind of requisition, sometimes from some of our medical practitioners, they don't give a very clear answer. In fact, from the police headquarters, we noticed this kind of anomaly, and from the police headquarters, we had issued one instruction to all the SPs that they shall have some meeting, joint meeting with the medical practitioners, and impress upon them to give their views, because their views will be treated as an expert opinion under the provisions of Section 164 A2. So, and Section 164 A3 CRPC clearly says that the medical report shall state precise the reasons for each conclusion arrived at. Now the problem is, because sometimes when we give a requisition to the medical practitioner, this kind of reports does not come. They say like, the opinion shall be given on receipt of FSL report.
Yes, exactly, which is not adequate at all.
Which is not adequate. Then it hampers the investigation, because we are constrained as to what should be the next step that the police will take.
Okay.
So that is where we had instructed all the SPs to have a discussion with the district medical officers to impress upon this point that whenever in POCSO cases a medical requisition is given, they should give a very precise opinion about what they found. Because if it is referred later and we await the FSL report, then FSL report may be conclusive, may not be conclusive. Right. But we feel because the moment this kind of cases come, then the medical practitioner who examines the child will be one of the first persons to actually see the situation or the condition of the child, and will be able to arrive at a certain conclusion, and which is very important for us in our investigation.
Right. Thank you. Dr. Shadab, could you tell me what would be the sort of forensic evidence that could be collected in this case?
Madam, in this case, since it is a sexual assault, then the police, they request for the physical evidences from the victim. The doctors, they collect them, they preserve them. After preservation, if they are well preserved, I am sure
what would they collect?
They will be collecting. In this case, we do instruct the police officers that they should get vaginal swab, blood sample, pubic hair, head hair of the victim. So if these swabs are well preserved, which with the blood sample it becomes very easy, they can preserve, we can do blood grouping because it is well preserved. But in the case of vaginal swabs or penile swabs, if they are not well preserved from this source, that means from the medical, that is the source from where we collect. If they're not well preserved, that means even if it is positive, we don't get a result. Right. But if they're well preserved, they're positive or negative, we do get results.
So in this case, the last assault had occurred maybe 4 or 5 days before they went to the hospital for a checkup. Why would you need pubic hair and head hair?
Madam, in this case, we need pubic hair, head hair as control samples. The known samples are called control samples. Say at the place of incident where this has occurred, the place of occurrence, when we collect, we ask the investigating officers to collect all the material evidence, physical evidences. So if they find a strand of hair or if they find any physical evidence, so basically we're looking for hairs, because hairs are very common at all crime places.
Shed easily.
So, because we shed hair easily. So why we ask them to collect pubic hair and head hair? Because at the end of the day, these are control samples which we can keep, and we can compare with the evidences that the physical evidences collected from the crime scene or the place of occurrence. Right. So we need these. So and if we don't have, if we don't get them from the place of occurrence, the pubic hair and the head hair will still remain as it is, and it is called the control sample. But we don't take chances, because if we don't collect at that time, again they have to go to court, again take an order that they have to collect this after they have searched the place.
Right. Normally they used to say pluck the hair. How do you collect this hair?
See, plucked hairs is it's ideal. Plucked hairs for control samples. But supposing at the place of occurrence, we don't know whether it is a plucked hair or it is a fallen hair, which has shed by itself. So for control samples, we can call them plucked hairs. We don't collect cut hairs. Because a time may come when we will need the root for a DNA
So
examination.
isn't that painful?
I don't know, ma'am. I can't answer.
No, I'm just asking because I do know that there was a concern with once some medical doctors had asked, because they always say pluck the hair, which is like pulling it out.
Yes.
And that is painful in terms of, because you need the root also.
Yes.
So, but you are specifically stating it has to be plucked because the root is required.
Yes, when we get the root, it will be very good for future examination.
Right. Okay. Just wanted to clarify that. Thank you. Okay. I could ask the court, why would the person get bail? What are the reasons why a person who's getting bail, and how come he is now sitting and harassing and intimidating the child?
Okay, that's a very interesting question. Now, the first thing is, as I said, excepting for those penetrative sexual assault, the other cases are generally the ones which fall under Arnesh Kumar judgment. Now, if we look at the scenario that's given, now initially when you just say sexual assault, for POCSO when you say sexual assault, we're not talking about penetrative sexual assault. So initial suspicion is that maybe in the FIR it is registered as a section 7, section 9,
11.
10. And so what happens is that you go to 167 first. That is how long you can keep a person in custody. But that will come later. Of course, in this particular case, I think the IO would inevitably arrest because the alleged perpetrator is a family member residing in the same compound. Now, when I talk about 167, the interesting thing is that if supposing a person is alleged to have committed an offence which is not punishable with imprisonment for life or death, then the investigation period, if it is not completed in 24 hours, is maximum of 60 days. After which, if the investigation is not completed, the person would get default bail, statutory bail. Now, the second thing is that supposing after the person, the investigating officer investigates the case and finds out that yes, there was penetrative sexual assault or there was a suspicion, say medical evidence is positive in that way. So then the investigating officer would inevitably file a petition saying that we want to add these sections, and so they would probably be added. Now this is in addition to whatever I had said earlier about recording and so on and so forth. Now the interesting thing is that again for these cases which fall under 376, 376A, A, B, B, so these are the ones that fall under section 3 and 5 in the POCSO Act. So there, after the amendment again, the time period is not 90 days.
Right.
So they have to complete the investigation in 2 months from the date when it is reported. So because this comes in section 173, the amendment is 1A. So then what the legislature has done effectively is try to prevent these particular persons who are alleged to commit these offences of rape from getting bail. That's the whole idea behind it, because you see then 167 doesn't come in, 90 days doesn't come in because you finish the investigation in 60 days.
So one of the things the police often mention is that because there's a delay in the FSL report, they delay the charge sheet, and that's why it goes beyond 60 days and the person gets statutory bail.
See, this is another interesting thing, because in cases not only under the POCSO Act, but if in case of 376 rape, so as you have rightly mentioned earlier, the statement of the prosecutor itself is sufficient for prima facie conclusion at that point of time to presume that a particular offence has been committed. Because for the cognizance to be taken at that point of time, we just have to see whether there is enough material to presume, not prima facie also, to presume that the accused has committed these particular offences. So even if they have not received the FSL report, if they feel that they have adequate evidence at that point of time, maybe sole testimony is reliable because of the circumstances, or maybe they have an eyewitness, or maybe they have a strong corroborating evidence, as in the witnesses said that no, immediately after she came and told us she was in this particular condition, her clothes were so and so, or maybe the medical is also corroborating the statement of the version of the survivor, then they can easily file the charge sheet, and subsequently what they can do is they can file the supplementary charge sheet. The only requirement which I had mentioned earlier, I had seen, is that they were not actually filing it in the form. The requirement is that it must be filed in the same final form as you would file a charge sheet. Many a time we found that they would just file a supplementary case diary.
Additional.
Normally a case diary doesn't come to the court. It remains with the prosecution, but of course during the trial we can use it. But the main thing is that that was the only technical problem. Now, second thing is that when we said this person has secured bail, he is out and he is in his particular compound again.
Child.
Now, in this situation, again, the support person is very, very important, because the moment this kind of reports are there, the support person can immediately inform the court. The support person can take the help of the legal aid counsel who may be appointed to the survivor or the family, and immediately inform the court, raise the objections so that bail can be cancelled.
Cancelled, yeah.
So these are the effective measures which can be taken in a scenario
Wonderful.
like this.
Thank you. So that's for the doctors also to understand that if you just say medical report pending FSL, the police are not able to move ahead. And while FSL does try hard, I think in POXO cases and sexual assault, they do try to push their, timeline so that they can give the report earlier. If you can give a medical report, authentic report, showing that there are injuries and there is evidence of penetrative sexual assault, it does help the police in giving a charge sheet earlier, because if it waits more than 2 months, the person gets out on bail and they can harass. And of course, very, very important for the support persons here, that if the person on bail, one of the conditions is that he does not accost the child, does not try to in any way harass, intimidate or coerce the person. So if he is doing that, that can be definitely reported to the legal services and the bail can be cancelled. We'll go ahead with the next one. A 17-year-old girl was walking from her mother's house to her aunt's house to help her to take care of her babies, the aunt's babies. It was 31st December, and a gang of 3 drunk boys from her neighborhood attacked her, took her to a shed and repeatedly raped her. She was in severe pain and terror and fainted during the attacks. Her mother thought she was at her aunt's house and her aunt thought she had decided not to come. In the early hours of the morning, when the boys were in a drunken stupor, she managed to escape and come home. Immediately after she told her parents, they spoke to the Gaon Bura. The boys were caught and brought to the village council, and she had to speak in front of everyone about what had happened and explain about exactly what happened. The girl was feeling sick and weak and fainted again and again during the meeting. After the council, the girl was taken to a health center where the doctor administered some first aid, gave antibiotics and painkillers. The doctor refused to conduct a forensic examination. The girl was told that it is better to go to a private hospital when the doctor asked for a police order, and when it was not given, the patient had to return home. No police complaint was filed as the parents of the boys were arguing with the girl's family, refusing to accept that their sons had done this. Finally, an NGO was informed. They took the girl and her mother to the government hospital. There, the doctor said it would be better to give general anesthesia and then examine the girl, as it might be painful. But after some discussion, the girl agreed to the medical and forensic examination, but it was already 3 days or 72 hours since the assault. Now there has been a severe backlash from the community because the parents filed a police case, the boys are out on bail, and the girl is scared to go out of the house. The case is still in the courts. I think I would like to probably ask our legal expert, Dr. Konklara, what do you think has been wrongly handled in this case? What could have been done differently and better?
The first instance, ma'am, was the public humiliation of the child when she was asked to narrate everything. Even in her weak state, she was asked to narrate in front of the village council. So that was a violation of her right. And even the doctors also here, when she was referred to them, they did not ask the case history and everything regarding her, her health status, but they just administered antibiotics and painkillers instead. So that also was another medical violation on their part. And also refusing to conduct examination, but that on the forensic part. And also the suggestions by the doctor that she has to go to a private hospital, which as per the POXO Act, as you had already explained earlier, it's not supposed to be like that. Each and every hospital has to do a proper examination or take the case history of the child. And the complaint was also not given by the parents due to all the things that is happening in the, as it has been already discussed in the public domain. And already lastly, the NGO also was involved here, who did not know how to handle the case. And the especially here, the girl has been given general anesthesia.
She wasn't given it. She was suggested it, but finally she decided not to take it.
And in spite of all this, through all these discussions, there was a huge delay in reporting the matter. That also after 3 days or 72 hours after the assault. So all the involvement of all these people who could have been the bridge for the child to get the immediate help for when she was required to get the help in time, it did not happen at all. So that also the case was filed before the police after the severe backlash from the community. So many violations has happened against the child.
Correct. Dr. Wansett, why do you feel the doctor at the first health center and the subsequent doctors kept refusing and delaying the examination?
Probably, I think what is seen here is that they are not aware about the POCSO Act.
Absolutely. So, because when there is a lack of knowledge about it, doctors are scared. Doctors are scared of touching a case which they are not sure they can handle. And as you saw with the medical examination, it is a very, very simple process. We are not trying to create evidence. You're not trying to create a case. You're just asking a complete narration, taking the history, and always supporting. Even for the first health center, which is a government health center, if the doctor had said, I am not sure how to collect evidence, I may do a wrong job, let me refer you to the district hospital or to a proper hospital. And small things like calling the district hospital, finding out if a senior doctor is there who is trained in POCSO and saying, I am sending this child there just now. Can you please take care of her because she is in pain, she has been through a very severe assault and she needs care. These are small steps that people can do which makes the life of the person easier and would have prevented this delay of 3 days in getting the forensic examination done. So in this case, one of the other issues is the way the whole community and family and everybody else got involved. So from the police, what could be done to mitigate this sort of an issue? What could the police have done?
Ma'am, the scenario which was presented, I feel that there has been a lot of mismanagement. Number one is it seems that there has been a severe backlash from the community because the parents filed the police case. The boys are out on bail and the girl is scared to come out of the house. Now, from this scenario, it appears that the police indeed has filed the case, but probably they have filed the case under wrong sections. Otherwise, in such a scenario, the perpetrators should not be out on bail.
Absolutely.
Because it is a case of gang rape.
Yes.
So, in addition to POCSO, 376 AB or whichever is applicable to gang rape should have been added in addition to POCSO. Secondly, there is a provision under section 439 CRPC also, which says that when a bail application is moved, the victim or his or her parents or family members shall be compulsorily informed of the bail when the bail is being moved, bail application is being moved in the court, and they shall be present and they can object to the bail objections. So probably these provisions was not adhered to. So then the police could have informed the family members and the victim also, who could have opposed, because in that case, then they would not have got bail, and in such a scenario, they would not have come back to the same village and could have intimidated the girl child. Secondly, it appears that here the entire Dorbar would also be liable, because when it was reported to them, firstly, it was not proper for them to ask this kind of questions in front of the whole Darbar, where it becomes very humiliating for the victim child also. And secondly is when the Darbar has been informed, they have failed in their duty of not reporting it to the police, and a case is not being registered. Hence, they will also be liable under the POCSO Act. The same goes even for the other stakeholders here. Like, for instance, even the doctors, when it was reported to them, they saw, probably they were scared, but they have not reported or escalated it further, in which case they may also be liable under the provisions of the POCSO Act.
So the POCSO Act gives a lot of punishments to people who don't report and things like that. But the intention is not so much to punish people, but to push people to report. Like, the doctor doesn't have to fear the court so much as should not have to fear the act, but work on the side of the victim. Similarly with the police, or whether it's with the Darbar, and the importance of community knowledge about POCSO and what are the basis, and the fact that this sort of an open space where a girl has to talk about what she has undergone is extremely damaging and, you know, psychologically affecting for her. And I believe this case is still going on. These are all actual cases. Is there anything else anyone of you would like to add?
Yes, madam. Thank you. The interesting thing over here, as from the discussion we can make out, is that probably the case is filed only against the alleged perpetrators. So they would probably be in the criminal system. But as has been stated, a number of offences have been committed, offences defined in the statutes, disclosing identities and not reporting the matters, and not giving timely medical attention to the survivor. And now, the courts are not really powerless. A very interesting thing about courts is that at 2 stages they can bring in any co-accused. One is before the stage of evidence, they can bring in the co-accused if there is enough material to see that they have committed certain offences. Second thing is after the trial commences under 319 of the CRPC. There, once the evidence is recorded, what initially may not have been available. So the difference is, supposing during the investigation, here first scenario, I will presume that during the investigation it was already available that these other people had committed these particular offences. So if in that case, then there is a constitutional bench judgment of the Supreme Court which allows you to bring in these people to stand trial. Second thing is that, as I said, initially maybe it was not disclosed. Say the survivor didn't say anything, the witnesses didn't say anything. So the evidence is being recorded, and once the evidence is being recorded, then they say that this is what happened. We had been called to the Darbar, and this is this. We had gone to the to the doctors, and we had done these things. So at that point of time, also the court can bring in these co-accused. And earlier, as I had already mentioned, for the bail, one is probably they might not have secured it if that 2-month period thing was adhered to. Yes. Second thing is, yes, it's very correctly pointed out that now the situation is that if in these cases bail is moved, you have to inform the survivor or the complainant through the SJPU. You can do that or through the CWC or support person if it is available, and they have every right to be heard and oppose this bail plea. So that's
great. Thank you. Thank you. So these are cases where there is a lot of, where the child has fallen through the gaps. And I think it's really important for all of us to understand how damaging it is. And somewhere also, whether it's the police or whether the DCPUs go and take, after the fact, let it be, talk to the community, talk to the Darbar and explain that POCSO is sufficient to take care and there is no need, and there is in fact violation of the identity and giving up of the rights of the child, and of course the public humiliation, as you were speaking, of the child to speak in a place like this when we are trying so hard to have an in-camera court and then to have people like this saying it. So this is not at all acceptable. Another case, in a particular boys' school, there is a bunch of older students who try to bully and harass the younger boys. They poke them from the back on their buttocks with sticks and rulers and pencils and sometimes with their hands. The younger boys are too scared to report the boys out of a fear of retaliation. The teachers turn a blind eye to the students' actions. I think I'd ask the legal luminary, what do you feel would be
effective in this case? There's no reporting as such. Nobody's reporting. But you have found out from some of the children's parents that, the boys are being harassed a little bit. Though the boys actually don't really tell how much they are being bullied or harassed.
Ma'am, in this instance, if the case has been reported to parents of the boys, then
it's not reported. This is not come into reporting. You just have an idea that it's happening.
Yeah, ma'am. So if at all the matter came through someone or the other who is present in the school, then the first intervention in this matter would be inform the Child Welfare Committee regarding this matter, so that the school in question will also come into the fray, so that they'll be asked to appear before the committee and also to appoint someone to conduct an SIR or to investigate into the matter.
Right, thank you. So I would like Kong Mimi to tell me, what do you think you could do in this case? Would you be doing the SIR? No, what would you do in this case if someone spoke to you and said this is what's happening in this school? What do you think you could do in this case?
As a support person?
Yeah.
As a support person, if it's already reported to the CWC and it's come to the knowledge of the CWC, obviously, like Kong Clara has mentioned, they will appoint someone to do the inquiry, and through the inquiry, maybe we get to talk with the child. Obviously, we cannot go and talk directly to the child. We will arrange like a counseling, and then through a counselor, we will get to know what is happening with the child. If this is happening and we get through the inquiry that this is happening, then the person who conduct the inquiry, they can give a report to the CWC, and the CWC can ask the principal or the teacher to come before the CWC, so that they can get to talk with the child who's doing all this behavior with the other child, and so that they can give a counseling to the other child also, to get to know why they are doing this to the other child, because maybe it's something happened to the other child also, that they are trying to commit this type of behavior to the other one.
Thank you. So the reason I brought this up is this is all pervasive. This sort of bullying occurs in schools, particularly in boys' schools, but also with mixed schools, co-educational schools, where there is a lot of physical intimidation and bullying which occurs of boys particularly. And most often it is done by senior students, not by teachers or by the staff. One of the things that, because there's nobody, if you go actually to ask, no child will accept something has happened. And the parents also do not want to get involved, so they'll be like, no, we don't want to get into trouble over this. So what has been done in Bangalore is, in December, they have what is called as Crime Prevention Month. So police officers go to different schools in their jurisdiction, particularly class 7 onwards, particularly boys' schools, and they take short sessions on bullying, teasing, on POXO and what entails POXO and what are the consequences of it. What it seems to boys, because this is like ragging. In medical college we had terrible ragging, where if your senior ragged you when you came in, it was your right to rag the next one. It never struck anyone that I was so scared I should stop ragging. It's a sort of intergenerational continuation. So what they did over there was the police officers would go and just speak for a couple of hours. And the thing is, when I go to schools talking to students, a lot of them often say, what do you want to be? I want to be a police officer. There is a lot of respect for a police official who comes to the school and talks about it. Much more as compared to just teachers saying, don't bully, don't do this. So sometimes we found that this particularly helps in that 14, 16, 18-year age group, where the risk of running away with POXO issues come up. And so understanding that, you may love a girl as much as you want, but if she's under 18, you're in trouble. And also that this sort of bullying, which may seem just fun, just having maja, is not. And it can cause deep harm to others. So that is something, I don't know whether, it's something that the police could look into as a sort of way, particularly when you know of schools where you find boys more into like drugs, there's a little more of violence, boys who are underage driving motorcycles, things like that. You know that the school has this sort of a age group of children. That might be works. Next one. A young boy of 13 in class 8 behaves a little differently. He has a gentle nature, and when he is bullied or his teacher scolds him, he cries easily. He likes to sit with the girls in his class and take part in their activities like sewing and knitting. He dislikes playing with the boys in the field. They realize that he is different and deliberately hit him with a ball or trip him or bang into him so that he falls and gets hurt. Some senior boys try to go into the bathroom with him, remove his pants, or force him to pee in front of them. He is scared and has started making excuses not to go to the school. So here I would like to ask Dr. Wanswet, what do you think is the problem over here with this? Is the boy having a problem? And why is he getting targeted?
Yeah, in this case, maybe by his, genetic, we call it, as you know, like asexual. I mean, our orientation is determined by the genetic material in our body. So probably this child is having some sort of that, which can be easily explained, like sometimes, as you understand, I may not go into the detail, outwardly they may be manifested as boys, but inwardly the genetic functions can be otherwise. So, with the XY, XX, all these genes are there. So maybe there is something actually with that, which maybe if you want to go on the medical term, he needs to be evaluated in that line. So maybe these can lead to these, behaviors which are not confirmatory to his sexual appearance.
So if this case comes up and is reported to the police saying that the children in the school are harassing this child, what action could be taken?
Ma'am, this is a very interesting situation because like what doctor has just mentioned, it could be because of some genetic issues, and it could be also now in the police we are experiencing a lot of sensitization, especially on gender sensitization, needs to be done. And here, he may outwardly be a boy, but inwardly what he is feeling, that we don't understand. Emotionally, we don't understand. And in such a case, if it is reported to a police, then firstly that I feel we have the special juvenile police unit in all the police stations. It will be taken over by the special juvenile police units. And in each police station, we have the CWPOs, Child Welfare Police Officers. They shall then, because this will be a case, it is not mentioned here that the seniors, how old they are, but I presume that they are minors.
Yes.
And they are below 18. So the CWPOs will have to refer it to the JJP. And from there, further action will be taken.
Thank you. So I want to bring this to your notice because 10% of our population is an alternate sexuality. They are not the usual cis-het, what we call as cisgender and heterosexual. 10% of populations are either homosexual, bisexual, they could have transgender, or just different orientation like agender, asexual. There are many different types, and we all know that these are genetic, not as a genetic problem, but just like if I'm female, it's genetic, and you're male, it's genetic, it's not an issue. Similarly, being a homosexual is a genetic proclivity. Being asexual, bisexual is genetic, it is not a fault. But in our traditional social norms of behavior, where men have to be masculine and girls have to be feminine, the moment there is this damage, they are being attacked and they are being harassed or bullied. And so in this case, much before it should have come to the police, it's wonderful if the SJPU can come, or the CWPO can come and talk to the school and talk about what sexuality education is. If you look at sexuality education, it is actually about understanding what the human beings can be and what bullying is not acceptable. and how it need not happen. And that is where, a lot of understanding sexuality education, often people think it's just about distributing condoms to kids on how to have safe sex. That's not it. Sexuality is actually about acceptance of differences and a refusal to bully or use violence against somebody just because they think differently or behave differently from you. So this is really important. Particularly the other issue is where a lot of schools, especially Bangalore, you would have heard there were so many school cases. So over there they started putting CCTVs all over the school. The point is you can't keep CCTVs in the bathroom. And that's where most of the abuse occurs. Older students to younger students, normally it occurs in the bathrooms. So there are now schools which have started having bathrooms where the doors can be seen from outside. Like instead of have a door which goes in with a lobby and the loos over there, they have the doors in such a way that you can walk into a bathroom, it's a single bathroom. Like you walk into the bathroom, use it and you come out. There is no lobby space and you can immediately make out if two children have gone into the bathroom together. In this way, trying to make more of unisex bathrooms and more of bathrooms which are visible to the open eye, and yet the person has privacy inside the bathroom but another person cannot go inside, is now what is happening in a lot of institutions and particularly schools and hostels in Bangalore to reduce the risk of senior to junior abuse. The next case is a 16-year-old girl has run away with a 22-year-old man. The parents had given a complaint to the police. The couple has been found living in another city and have been brought to the police station. The police require a medical examination before filing the FIR, but the girl is refusing to visit the hospital and have an examination. So I would like the support person to tell me, how would you want to support this girl?
Okay. As a support person, she will try, like we already know about the situation, we'll try to give the counseling to the child. Since there's, as it said here, the child refused to do the examination. Here we can say maybe the girl could not understand why she has to give the medical examination. Maybe in here we can understand there's a consent sex regarding this one. So maybe the child could not understand because she might say that why should I do the medical examination when I give a consent to the boy and we have a love affair, so we don't need to do it. But as a child, she might not understand what is consent. Example, suppose we have to teach the child what is consent, because if we see consent, it doesn't mean the child herself give in, but then it's where we used to see, in this kind of cases where the boy might lure the child. He might say that I love you, all those things, and if you don't give me this, shows like you don't love me. So maybe the child might think that, oh, if I do this, maybe the boy he love me, so I think I should do it. So that is what we call consent. So we have to make the child understand that consent, what does that mean by consent. So after knowing that, then maybe after giving the counseling and telling the child what is consent, maybe she could understand and she could say that this is not what she wants. Maybe she will be understand that consent doesn't mean it should be that she is being forced to give a consent, not but she has to be understand that consent should be given from her side itself. So after giving that, maybe we can say she can understand and she was willing to give do the medical examination.
Dr. Wanswet, how would you handle this girl who's refusing medical examination?
Okay, as I have said before, definitely we will go for the, we have to first take the consent, so informed consent, where we would explain to her, and at the same time, before we even if she doesn't, refuse to go for medical legal examination and collection of evidence, maybe we would talk to her, try to, get her, build a rapport with her, so that we get, at least to get to the root, as a support person Kong have said, that probably because she did not understand about the meaning of consensual. Maybe they have they love each other and all that, because she's still a teenager where we can understand that their emotional status, their understanding, it is still, very much labile. So the first thing here is to build a rapport with the girl herself, to get to know how much she understands and what are her exact desires and what she really understands about this and what she really wants. The objective of it is to determine that it's really a consensual, or that it is actually she has been forced into it, she has said. So accordingly, we will have to go with that.
Thank you, Dr. Mansett. I think. So, could we just finish one more case and then we'll be closed for that? Thank you, sir. Thank you. So, how would the police manage this case?
Ma'am, regarding this case, excuse me, since the girl is just 16 years old and the man is 22-year old, and the parents had given a complaint to the police. So, as per the Honorable Supreme Court judgment in Bachpan Bachao Andolan versus the Union of India, the moment a missing report is filed to the police, they have to mandatorily register the FIR, either as a case of, with the presumption of either that the girl has been abducted, or it is a case of human trafficking. So, those sections will already be incorporated. Then the second aspect here, that it says that the police require a medical examination before filing an FIR. I think it does not arise, because the case will already be registered. However, as to the investigation part, that medical report, if it is there, then it will be beneficial. However, we cannot force, if the girl herself is not willing to undergo medical examination, then we will not be in a position to force her for this medical examination. However, in the case of, during the course of investigation, if it is found, though the police may register the case either as a case of abduction or a human trafficking, but later, when it is found that it is a case of POCSO, then the relevant sections can be added and charge sheeted accordingly.
Thank you. So one of the things one has to look at this is the fact is that you cannot under any circumstances force any child to undergo a medical examination. You can give anticipatory guidance, you can talk to them and you can discuss it with them, but you cannot do anything further because it is not allowed. So whether the POCSO Act may not even be included because you have no medical examination findings, but it will just have to be on kidnapping or abduction and things like that, that it would go ahead on. What do you think would be the role of a counselor in this case, a psychologist? Do you think? Like, would you refer to, because you have a girl who's refusing medical examination, doctors and the support person have not been able to shake her resolve, would you refer to or suggest to the parents to refer to a psychologist to discuss further?
Definitely, I feel a lot of counseling will be required as far as her mental state is concerned. And secondly, with regards to the legal aspects as well. So that sort of counseling definitely needs to be given to the girl.
Thank you. Thank you. So we'll go on to the 8th one. The 17-year-old girl is brought at 7 months of pregnancy.
Her mother kept asking her about any problem since the last 3 months, but she insisted there was nothing wrong. Now that her pregnancy can't be hidden, the mother has come along with the Asha to the health center for a checkup. Dr. Wanswet, what should the doctor do?
The first thing is this teenage girl, 17-year-old, had come at 7 months of pregnancy. So our first role is to give her the necessary medical care, antenatal care, which we call. We will accordingly, like the investigations which are needed, whatever are needed, and the treatment, of course. Then secondarily, after that will come like the explanation about that, taking that she is still within the POCSO Act. So we will proceed with taking the consent, explaining everything, and take the informed consent. And from there on, we will proceed as necessary. So it will depend on actually what consent she gave. If she consent only for the medical examination and treatment, that is where we will dwell it. But definitely the mandatory reporting will be done from our side.
So Dr. Shadab, what is the role? Is there any role for forensic evidence collection in this case?
In this case, actually, since she is pregnant, so it's a live child, we cannot do any forensic examination.
She's still pregnant. So
Yes.
there is no need to do swabs, there is no need to do an examination.
Here, nothing is mentioned about her getting raped or sexually assaulted.
She is refusing to say anything about it. She is refusing to name the person, and she is refusing to say whether it's consensual or not. She keeps denying actually she's pregnant. It's just that she's forcefully been told that she's pregnant.
No, regarding swabs and all, as per this case history, I think it does not arise.
Thank you. So one of the things for doctors also is that if there is a pregnancy, it definitely proves sexual activity. So unless you have a doubt about infection, HIV, hepatitis B, which is all for the maternal care, or a sexually transmitted disease, there is no need to do anything other than an antenatal care examination for her. There is no need to collect swabs or do anything other than file an FIR or inform the police regarding the same. Now, if she does not give the name of the perpetrator or the person who's involved, what would the police do?
Like you said, ma'am, the FIR will have to be filed, and we will have to register the case and investigate into it. If it appears that since she may not be willing to cooperate with the police, so we will have to use other means to find out who, the alleged suspect is. He or she, he may be either be a minor or again he may be a major. So again, if it is a minor, then we have to take other steps, like for instance referring it to JJB. If the suspect is a major, then we'll have to take other action as well. Having said that, we would probably try to investigate this case, trying to find out from her friends as to who probably she was going around with, and maybe narrow down the suspects and all that. Then further, we may further have to investigate and try to find out from other sources, like maybe her mobile phone, her social media profiles, and all that, and maybe connect to come to a certain conclusion that maybe that person with whom she is interacting is the suspect. And finally, we may have to interact with all the family members, and wherever it's possible, we may also have to review certain places may have CCTVs, etc., where certain they may have been seen together and all that. So this is how we would try to prove the case.
Thank you. I think I'm going to close now. We have had a lovely panel discussion, and I thank all the panelists. Thank you for spending the time here and giving your valuable information. Does anybody in the audience have any questions? Anything specific? Sir.
What are the facilities for conducting a DNA test in this case, and how long does it take?
Dr. Shadab.
Sir, actually the DNA facility is not yet ready here in Meghalaya. But actually it should not take time, that much time, maybe within a week, in those fully fledged.
So where do you send it to Guwahati or elsewhere?
we are advising all the police officers to send all the DNA exhibits to Guwahati CFSL or Calcutta CFSL.
And how long does it take for the results to be obtained?
I think it should take within 3 months, sir.
Because the answer to your last question, sir, was obviously a DNA test.
Sir.
Because everything else would be circumstantial. Conducting a DNA test on the suspect and the child would confirm the paternity. And that would lead to, identifying the suspect. That is the easiest. But if the facilities are not there and if it takes 3 months, then it's quite a problem. We need to have this because now in many cases, DNA is conclusive and even to eliminate, because we've got to, think of both the rights of the victim and the rights of the accused. The accused may have nothing to do with it, and a simple DNA test would, kind of indicate that. But, the matter proceeds against the person without a DNA test. So we've got to expedite that. So whoever are the appropriate authorities, we'll try and ensure that we have those facilities over here. We must. It's basic now.
Thank you. Thank you.
No other questions, audience?
Yes. Any other questions from the audience? Yes, please. Mic to him, please.
Suppose in a POCSO case, there are 2 different dates of births from the school certificate and the original birth certificate from the medical department. So, which date is to be taken into account?
I think, can I give this to you?
Yes. So for this, we had the judgment of the Jarnail Singh judgment passed by the Honorable Supreme Court of India. So according to that judgment, we have to follow the procedure that is followed in the Juvenile Justice Act. So for the new one, we have Section 94. In the old one, it was Rule 12 in the rules. So there is a set of documents which is given. The first is your matriculation certificate, or certificate given by, matriculation, school certificate. And the second, if in case you do not have that, then only you go to the next. Next is the registered birth certificate. Now, if you don't have these 2, then only the investigating officer would probably make a prayer that a board be constituted for ossification and dental test. If you have that first document, that will take primacy. In case that is not there, the second will take primacy. But having said that also, this is also not really conclusive. If in case the defense is able to present contradictory evidence, that may also not be accepted.
Okay, sir.
I think one of the biggest issues we find also with, even if you have contradicting certificates like this, and therefore there is a court order to get the the age seen. If it is between 18, no doctor can actually say this is over 18 or under 18. They always give a 2-year sort of expansion. So they'll say 17 to 19. Now in this case, usually as per the POCSO Act as well as also Juvenile Justice Act, you always take the lower age because you want the person to get all the advantages of being a child. So the child-friendly procedures and all will come in if you take it as 17 rather than 19. Similarly with accused, if the accused is 17 to 19 is what is given, we take it as 17 rather than 19 so that they are treated, they get all the resources of the state to support them as children rather than as an adult. I think any other, would you like to mention anything, Clara, on this in terms of certificates?
Yes, ma'am, because there have been several instances where such situation has arisen. So in most cases, but the age of the child is, the lower age has been always considered.
Always consider the lower age because it gives the protection of POCSO, of the Juvenile Justice Acts to the child and supports the child. So the child gets much more support from the systems as compared to if the child was considered 19, and that is what we look at. Any other questions? Yes. Behind you.
Good afternoon, everyone. This question is for Sir F.S. Amma. Hello, sir. Sir, during the interaction, you have mentioned about the judgment which are applicable for us, Anish Kumar. you have stated that in respect of the offense from 3 to 6, where the rest of the offense that Anish Kumar is applicable. That's as per your point of view. But as per my understanding, sir, I may be wrong. I'm so sorry for this. I may be wrong. But what I feel is that this act is particularly used for protection of child who's below 18 years of age. And the child, and this act is specially empowered with a special code. And I feel that, as per my understanding, is this act is particularly, it is a special act, and special judge is there, special PP is there. And what I feel is that Anish Kumar versus State of Bihar will not be applicable in this, in the other cases, in the respect of other offense like sexual assault, sexual harassment, for the offense which are up to 7 years. So can you explain for me, sir? Because from my point of view, of my understanding, that Anish Kumar versus State of Bihar is not applicable in POCSO Act.
Yes, interesting question, if I may answer. So the first thing is that Anish Kumar rose out of 498A cases.
Yes.
So generally in those cases it was found that maybe the complaints may not always be true, and a lot of harassment did occur to people who were against whom cases were filed under those sections. In the same case, however, the Honorable Supreme Court added that this particular finding about not immediately arresting a person will apply to those cases where the punishment, the offences for commission of which the punishment does not exceed 7 years. Now, if you look at the POCSO Act, Section 3 defines, you have your 5 also definition, Section 4 and 6. Now, these are two sections where the punishment is not less than 10 years and 20 years. Now, in the other sections, if you look at Section 10 or 12 and so on and so forth, now in Section 10, this is the one which you will say the next highest. The maximum punishment is 7 years. Now, when we say that this category of cases, because it is a special act, POCSO, will not come into the ambit of that particular judgment, there may not be a adequate legal argument until and unless it is again stated by the Honorable Supreme Court that these cases would be exempt. Now, second thing is that this particular act, now the crime and the nature of the crime itself, many times I've seen that we've been stressing on the survivor, the victim. Now, the interesting thing about this particular act, when you look at it from the mind of a perpetrator, it is a predatory crime, primarily. Because it may be, and immediately predatory instincts may come in, but it may be that the predator has been observing the prey for a long period of time. That is why you will find that in most of these cases, the perpetrators are either somebody immediately next to the survivor, because they're family members, or within the vicinity and neighborhood, or even, say for example, in institutions where you see where they have been observing. So now, Anish Kumar judgment per se does not preclude the power of the investigating agency to arrest the accused. They can arrest the accused, they just need to give a reason why. Now, say for example, as I said, the scenario is that somebody who is a maternal uncle, or somebody who is the brother, in fact, who has perpetrated, who are alleged to be perpetrated these crimes. So what will happen is that the investigating officer will cite these circumstances, that if we do not arrest this person, or if I had not arrested this person, it poses a danger to the safety of the survivor, or that he or she may influence the particular survivor so as to not allow the case to proceed. So these circumstances will be put before the court, and the court will exercise its judgment to see whether the investigating officer was justified in arresting the accused. So my take on it is this. I hope it satisfies your question.
Yeah, I'm satisfied, sir. I think so. The simple answer is that the police officer should prepare a checklist for this and should maintain the reason why arrest is necessary. That is simple as that. Thank you, sir.
I wish life was so simple. Thank you. Thank you all. Any other questions? Any other questions?
Ma'am, there are quite a few cases where the victim is mentally challenged. That is in our district and also from other districts where my colleagues also have also mentioned. So when we have a mentally challenged victim, we don't have 161, we don't have 164 statement. So what other steps can we take up that will strengthen this case? Because the accused also will be unknown. So what can you suggest, ma'am, to strengthen these cases, such cases?
So it's very specifically given in the guidelines that if there is a child who is in any way mentally disabled, they have to be referred to a child development expert, and a special educator has to be brought in to help in the questioning. So during the interview, both 161, 164, the special educator will come in. Even before that, if to assess the mental age of the person, suppose she's 16 years old, but actually she is referred to a psychologist, child psychologist, who says her mental age is 5. We treat her as a 5-year-old actually. So in that case, we have to look at, the special educator will have to do the questioning, because none of us in terms of police or even the average doctor, MO, have the ability to take a history from this child. In these cases, the history doesn't come out so easily. What we've seen with NIMHANS and all is, they have a period where the child comes again and again to meet the psychologist. They use a lot of play therapy, they use a lot of different artifacts to see. It is possible that the child may not be able to speak at all and say anything about it, in which case we have nothing other than what had been mentioned earlier in terms of CCTV and other ways of any other eyewitnesses or any other corroborative evidence that we can get. And in case the child, very unfortunately, is pregnant, then the DNA of the fetus can be utilized for assessing the identity of the accused. But otherwise, there is actually, it comes to a dead end. The only thing we do, because you're saying there are a lot of cases of mental retardation in your district, would be probably to have sessions for parents to understand how to keep their children safe. Because very often these children don't go to school, they stay at home, and there are much more chances of getting targeted for abuse.
Thank you, ma'am. Ma'am, another problem.
Sure. No, I'm really happy for the problems you're giving. They're very practical and very sensible.
When a victim is taken, like in the outskirts, when the victim is taken to PHCs, so there they give a few statements and then they are forwarded to gynecologist in Ganesh Das. Then sometimes it happens that in Ganesh Das also they say they have already been checked up in PHCs. Then we don't get any opinion. So it becomes difficult for the IO.
Yes.
From there they have referred here, and from here they said they have been checked there. So that is also another problem for IOs, ma'am.
Yes. Actually, the PHC doctor should sufficiently give the report. There is no need to send them again and again. They should not be examined. I think one of the things is that the POXO, Dr. Wanswet is the POXO trainer, that we are training all our MOs at the PHC and the CHC level to be able to do a complete medical examination and give the report. Because as you all saw, it's not rocket science. It's a very simple, basic history-taking examination which is targeted and collection of evidence. It's nothing to be scared. Doctors are scared of it basically, and it takes time for them to get used to it to be able to handle it properly. But you are justified that you should not have to take the child from PHC to Ganesh Das and up and down like that. That's not right. And it is not necessary to have a gynecologist. I'm sorry. Right? Yeah. So, shall we close? Any more questions? Yes. Go ahead. I'm sorry, sir.
Ma'am, actually there is a practical question. In case I happen to encounter one ANC case, okay, and she's not aware about the POXO Act, then when she comes to the PHC or CAC for ANC checkup, and then she looks very young. Okay, she doesn't look to be more than 18. She looks like 14, 15. Okay, and then after inquiring about her age, then she says she is more than 18. But when we ask about the documents, related documents, there is no documents that can prove she is 18. She doesn't have a EPIC card. She doesn't have a PAN card. She doesn't go to school, so she doesn't have a school certificate, and she doesn't have a birth certificate also. So in that case, my question is, since she looks very young, she might not be more than 18. So since we cannot confirm her age, so should we inform the police in that case or not for verification of age or not?
So as I mentioned earlier, but we're looking at the pregnancies, teenage pregnancies, we've seen a sudden drastic drop in 17, 18-year-olds, 16-year-olds. Everybody is writing their age as 18 and 19.
because the families have also understood that this is unsafe to write it as less than 18. Your job primarily is to take care of the patient. She is a teenager, even if she's 19, she's still a teenager, and taking care of her pregnancy. Usually if a patient comes to a doctor, like if they say they're 65 or 42, I don't really check to see their documents. So unless I feel the girl is at risk and therefore she requires some sort of support, so that is where it's important that I take a detailed history, who's living, who she's staying with, who are her support systems, who's she working with, and ensuring that her antenatal care is given in a proper manner. I'm not going to really go and ask for her certificates and put her into trouble. If I have a doubt that this was a sexual assault case, in that case it would be important to talk to the parents or whoever have come with the children, or look at it and then see whether definitely it needs to be registered as a case.
Ma'am, adding to that same point, because generally in the village, far-flung village, people initially they don't know about the POCSO Act, okay, and then later on they comes to know, and then there are certain people who wants to take advantage of the other guy, because when they come to know that they are getting some money, so they take advantage of that. So what they do, what can happen is that they can find fault and they can file against that guy. They can file a case against that guy, and later on the problem with the medical practitioner is that because since they have come for ANC checkup, that time why not we inform the police? Maybe at that point of time the parent might say that she is 16.
So this is always going to be the condition, because what happens is if you report one person, there will be 6 other teenage girls who are not going to come for a checkup. And they are going to end up like I saw as maternal deaths or infant deaths. So we have to balance the rights of the patient to health care and not scare them off. And that is why this was my request was that we have to look at the similar thing which Tamil Nadu government has done, where they are looking at saying that the case is to be registered, the case procedure will continue, but the girl's antenatal care and health will continue, and if she wishes to name the perpetrator, she may, and then you can look at it. If you feel, see, as a doctor, the basic thing is if you know for sure she's under 18, you have to report it. There's no question about it. You don't have a choice, because you will be punished. Under the Act, it is a punishment for you not to report it. Now you have to decide what you want to do. If you have no documentary proof, you decide. Also the issue is if you don't report it, and tomorrow somebody from the community comes to create trouble and says actually she's under 16, 17, and it is proved that you knew it, you are in trouble.
That is my question, ma'am.
Yes.
Because later on if someone files a case, then since she has come to me, and why not, if I had a doubt at that time, why not send for a age verification?
You can do
right?
that. You can do that. It's only Justice Chandrachud's judgment only comes in when a girl comes under 18 who says it was consensual and in the presence of her parents, she wants a termination of pregnancy. In that case, you just inform the police without the name of the child and continue the medical termination procedures. For antenatal care, it will depend on you. If you feel and suspect that she is under 18 or you have documentary proof, you have to report it.
No, the problem in that case, we don't have the documentary proof that she's 16 or 18.
Suspecting something, you have to decide whether you want to put them into it, because the problem is that she will leave her antenatal care. And her health is already dicey because she is come in at a later stage. We know the teenage pregnancy is coming late. So she may be anemic, she may have high blood pressure, and if we create any situation where she is scared to come to the hospital, her risk of dying and the risk of her baby dying is much higher.
Ma'am, I want a clarification is that in case in that situation I don't report to the police, later on the case is filed, then we are not in trouble, right?
You're not in trouble if you did not know or have not seen any document which shows she's under 18. If she has shown you an Aadhaar card or a birth certificate or any paper, EPIC card which shows she's under 18, you have knowledge of it, then you can't deny that.
Okay, that is the only clarification I want, ma'am. Thank you.
Thank you. Yes, I think, thank you. Yes.
One more question, ma'am.
Yes.
With respect to the Act, like in the court we have special room for the children, and like the police and police thana they have special room. I just want to know, as for my knowledge, and if not, I'm put into practice, maybe in the future we can put for the hospital, whether they have any room for the child who's being sexually assaulted, because she'll be taken to the hospital. And what I feel that, personally, what I feel that, coming to a hospital and you have to wait for a doctor to be examined, is there any room for a child to wait for a doctor? Because it is very important that since the act is already enacted, that we have to have special room for a child.
Yes.
Whether is there any room in any hospital for a child to wait for a particular doctor who's on duty for her to be examined? That is the first question. If not, kindly all the hospital please take initiative into this question and try to set up as soon as possible. Yes.
Okay.
Yeah, and my second question is that there are so many complaints. I'll not point out which hospital or which police officer, which anyone. I'll not point out. I'm not here to point out any question or to doubt anyone. There are some hospital. I'll just put into that when the victim have come to hospital, they have to wait for 2-3 hours, and sometimes the police have to drop the victim and the family members late night, 2 o'clock, 2 in the morning. The reason why, because there is no doctor in the hospital, and the victim who's being sexually assaulted have to wait 3, 4, 6 hours for her to be medically examined. This is not a crime we committed. No doubt, accused person have been punished, he have been arrested. But the most important thing is that the doctor who is on duty, is supposed to be on duty to attend the child as soon as she was brought into the hospital. So if there is no such cases, maybe we'll try to see that this should not happen, but in certain area where this type of cases arises, to kindly take initiatives so this in the future, this will not happen. Thank you.
Thank you. So just 2 questions. All district hospitals are meant to have a one-stop center. The one-stop center is not just one room, but maybe 2, where there is privacy for any person who has come either for sexual assault, it may be man, woman or child, and it is also for any case of domestic violence. So there is a privacy, so they're not looked at in the casualty or in the OPD or in the emergency department. That is there for all the district hospitals. In the PHCs and CHCs, when we give a training to the doctors on POCSO, we always inform them, please do not see the child in an open place. Let them be placed in a place where there is a bathroom, there is drinking water, and a pleasant environment, not say in a labor room. Earlier on, people used to examine children in a labor room with screaming women in labor around that, which was terribly traumatic. So now they have understood that and have it in a room. Regarding doctors not being there on duty, it's outside my pay grade. Thank you. Any other questions? Thank you so much. Thank you, panelists, for your kind information and your inputs. I'm very grateful for you to have spared this time here. Thank you.
Thank you, Dr. Saldana and your team, and all the panel members. We've had a very interactive panel discussion, and we look forward to many more programs of this nature. We're happy that in our midst here we have the Honorable Judges, our Honorable Chief Justice, Justice Sanjeev Banerjee, sir. We also have Justice Thankyou, who was here with us in the morning and has joined us again. We thank you. We would like also to extend our gratitude to Justice W. Dingdo, who's here with us. And yes, of course, Justice Biswadeep Bhattacharjee. Your Lordships, I would like to express a brief note about today's program. We've had a very interactive 4 sessions. Dr. Saldana has done a very good job. We've had case studies. We've also got the chance to hear the challenges which the different departments are facing when it comes to cases under the POCSO Act. And we've also had few suggestions which I feel we can all take away. May I mention that this program also has come to place because of the instrumental support that we have received from the Honorable Chief Justice. And we understand that the topic on the protection of children against sexual offences is not only a topic that is to be discussed, but it is an area that deserves action. We are thankful to Your Lordship, and we are happy that you are here with us to address this gathering in this very last session. I extend a warm welcome to you, sir, and I hand over the session to you.
Good afternoon, and with your permission, I'll sit and do it because it's going to be quite tedious to stand for about an hour. I'll start with a brief introduction and of what I intend to do. You've heard it from various other perspectives, but I will try and confine myself to the actual work in court, though there are certain other features that I must refer to. You see, first and foremost, after hearing some of the questions and the answers, we must remember that in a POCSO matter, apart from those who are on the fringe, who may be the parents, who may be well-wishers, relatives, social organizations, it is basically, you see, I'm too loud for the mic. Yeah. It is basically the accused and the survivor who are the principal dramatis personae, so to say. And in the act of justicing that all of us endeavor to do, beginning when the complaint is received and the investigation conducted by the police, to the trial being conducted by the special court and the appeal being heard out, the interest of both the accused and the survivor are important. Why I stress on this is that subsequent to the Nirbhaya incident which happened in December of 2012 in Delhi, there was a knee-jerk reaction, and it was felt that these people should be killed, they should be hanged from the nearest lamppost. And in sometimes approaching the matter with that kind of a vigor of vengeance, we miss the wood for the trees. Yes, the offender has to be punished. Yes, the offender has to be kept away for reformation, if that is our policy, because there is a lot of confusion in our penology as to whether it's punitive, retributive, or reformative. It's probably a punch of this and that and the other. But first and foremost, we must identify the accused to have committed the offense before the rest of the process can be started. In several cases, because of the enormity of the offense, because of the trauma that the child goes through, and because of the empathy, whether it's the police, whether it's a judge, because of the empathy for the survivor, the rights of the accused are sometimes lost sight of. As much as a survivor needs a closure and for the perpetrator of the offense to be brought to book, the accused also has a right to be dealt with appropriately and in accordance with law and without prejudice and upon material that prove his culpability beyond reasonable doubt. In several cases, we have seen very emotional outbursts, and presiding over the appellate court, I found that in several of the judgments passed by trial court, very, very emotional outbursts. But that is not really our job. It's much more forensic. It has to be much more by the book. Because if we get far too involved and passionately involved, so to say, then, there are certain obvious things that we miss out. So I begin with the caveat, with this caveat that sometimes the accused does not get the kind of fair deal that he is entitled to. Secondly, there were certain questions about arrest and some answers about bail. The considerations are completely different. Unfortunately, because in the system that we live in, trials take a long time. Thankfully in Meghalaya it doesn't take as long as elsewhere, because in the middle of 2023 we've disposed of half of the 2023 criminal appeals that have been filed in the High Court. But because trials take so long, because the end result comes at such a late date, sometimes bail is not granted for reasons that may not always be in accordance with law. Bail generally, which the Supreme Court is trying to reiterate over the last couple of years after seeing how difficult it is to obtain bail now, bail is generally the rule, jail is the exception. Jail comes in, or as we call it, correctional homes, they come in post-conviction. Ordinarily, a person is presumed to be not guilty till proven guilty. And that act of proof comes only at the conclusion of the trial, not before that. There are certain circumstances which ought to weigh with judges while considering bail, and I deem it my duty to repeat them because of, whether it's the pressure of the police or whether it's, a separate sense of, duty of the judges in the district judiciary. Conditions for bail have been made much stricter than they actually are. You deny bail when you see that the accused may tamper with the evidence, when you see that the accused may influence the witnesses, when you see that the accused may intimidate witnesses or the victim, or when there is material evidence to prima facie believe that the accused committed the crime, the enormity of the crime is such that the accused would be a threat to society if left at large. These are the basic principles. And in an ordinary everyday case, most of these principles, if appropriately applied, would lead you to granting bail. Of course, I must not be misunderstood to say that grant bail all the time. No. But apply the tests, answer the questions to yourself, and then write the order. we are given to writing orders, which are, pre-typed or almost cyclo-styled. And yes or no, we sign the yes form, we sign the no form. But every individual case has a different set of circumstances which require a fresh consideration. Now, in a POCSO case, I won't grant. Similarly, in NDPS, where we have no choice, the statute says it cannot be granted. In case of offences pertaining to castes, that act also says that, there is no provision for granting bail. But in other matters, you have to take these into consideration. So this is the caveat that I begin with. Second, and most important, that in criminal law, even though that is my last slide, there is very little room for discretion. Why? Because the test that you have to meet is beyond reasonable doubt. It's not a test of preponderance of probabilities. Once the test is beyond reasonable doubt, you have to see whether the act complained of was an offence as described in a statute. Human intervention has no place. If so, conviction. If not, no. Secondly, when a punishment is prescribed, an offence is an act which by law is defined to be an offence. Nothing else is an offence in criminal law. Similarly, when a punishment is provided for, no disingenuous judge can think of a separate form of punishment. The punishment is as per the law by which you assess. Yes, at times the punishment gives you a bandwidth. For instance, for murder, and even in several cases under the POCSO, the punishment can be death. But as we know, death now has become very rare, and the Supreme Court and all constitutional courts say that since death is irreversible, it must be granted in the rarest of rare cases. Otherwise, it's life. And there is the new aspect of life sentence which has now been coined, which is there, which has been introduced in the penal code and also in the POCSO Act. Life means life until the natural life, till the end of the natural life of the convict. So there also you have a discretion. It was previously thought, quite mistakenly, that a life sentence is actually 14 years. In fact, even when this expression life until the end of the natural life of the convict was introduced in our jurisprudence, life meant life. However, in certain cases, the executive has the authority to consider whether, on grounds which are not relevant to judges, at the end of 14 years or at the end of the stipulated period in accordance with law, whether it can be commuted, remitted, or the convict may be discharged. That is the domain of the executive and not. But that did not mean that the executive had to, in every case, at the end of 14 years, let a convict go. No, it was subject to certain conditions. That is now clarified, that life means life, but when the sentence permitted is life till the end of the natural life, it is what you are giving alternative to death, then you can also indicate the bandwidth. In fact, your High Court has recently defined that, I think for the first time, when a district judge passed a sentence in a POCSO matter, sentencing the person to 25 years in prison. Now, 25 years in prison would never have been heard of in our jurisprudence. The man was, it was a high-profile case. The man was aged about 50 or so at the time of conviction. So, natural expectancy was about 75 or more. So, instead of giving life till the end of the natural life sentence was given, but it was stipulated 25 years, which is permissible because it is within the bandwidth. So if the person dies, if the convict dies before attaining 75, end of the story. If the convict survives 75, then he would have to serve only till 75. Beyond that, he would be able to walk free. So this is the new thing which is introduced and is there in several sections. But the first, I will go into the definition of rape. The definition of rape, particularly in its explanations, is somewhat different from the definition of penetrative sexual assault or aggravated assault under the POCSO. If the charge is under the POCSO, then we have to regard it under the POCSO itself. And here comes the second point that I wish to make. In criminal jurisprudence, if it is the policy of the state to define who will be regarded as a child, and if an act committed on a person who falls within the definition of child amounts to an offence under the act, the court has no discretion to tweak anything. If it is an offence, an act amounts to an offence when committed on a person defined as a child, then the consequence follows. Conviction has to be there, and upon conviction, if there is a bandwidth, the discretion lies whether the quantum of punishment will be at the lower end or the higher end or somewhere down the middle, but there is no other discretion that the court can exercise. Until, of course, the validity of the provision is challenged, which a constitutional court can always take up. The definition of rape has been altered recently in the penal code. It's been made more specific, but in making it more specific, there have been certain things which have been excluded. I don't want to give ideas to the criminal mind as to what have been excluded and what would have amounted to rape under the old definition but may not amount to rape under the new definition. But there are certain aspects which will require, when those matters come up and the accused says that no, technically this is not rape within the meaning of 375, then those aspects would have to be considered. However, the definition under the POCSO yes, is, this definition now is the same definition as in 375 for penetrative sexual assault. And for aggravative penetrative sexual assault, it's the kind of person who has a fiduciary relationship, so to say, with the survivor, or who takes advantage of her mental or physical disability or a deadly weapon or the like, that's aggravated penetrative assault. However, there are two clauses which I have highlighted over here, L and M. Whoever commits penetrative sexual assault on the child more than once or repeatedly is really redundant, more than once would have done, or whoever commits penetrative sexual assault on a child below 12 years. These are important. Then ipso facto, the act complained of becomes aggravated penetrative sexual assault, warranting a larger punishment than in case of ordinary penetrative sexual assault. These are the various, the relationship in position of guardian, staff of any institution, position of trust, fiduciary relationship, as I said, on a pregnant child, attempts to murder in course of communal or sectarian violence, previous offender under the act, or makes the child to strip or parade naked. There is also punishment for sexual assault and aggravated sexual assault. Is just the structure that I indicate before. This is not functioning. And also sexual harassment, which is also defined, and there is a further provision as to pornography. Moreover, there is abetment to an offence and abetment to commit an offence. So these are additional features which have been introduced, which were not there in the penal code really, at least expressly. With imagination and section 34 and use of other provisions, you could go towards it, but these are specific now. Now, why all these measures? You must understand that rape was not necessarily historically an offence of lust. Rape was primarily an offence of power. But when a child undergoes a trauma of rape or any kind of sexual assault or harassment, it leaves an indelible mark which haunts her, or him for that matter, for the rest of his life, for the rest of her life. Which is why these special provisions have come in, and which is why, as the good doctor was explaining to us, there are these special measures that we ought to take both at the time of investigation and at the time of trial. In our courts today, we have special features. 2 special features are there in almost every court now. One is for POXO victims, the other is for vulnerable witnesses. And the Act provides the manner in which these trials must be conducted, and that the survivor must never come into contact with the accused at any stage. One of the most difficult things, and this is as a general rule, and more so in POXO, one of the most difficult things in POXO matters is that you rarely have any ocular evidence. In the rare case, you may have someone seeing at or about, someone seeing before, someone seeing after. But you must understand that it is not human nature to indulge in sex in the middle of the road it is general human nature that you commit the act or do the act, even if it is legal, in some degree of privacy. So more often than not, almost in all cases, you'll get allegations of the girl child or the survivor. We've stopped calling them victims. It's more politically correct to call them survivors, as Brother Dingdo corrected me in one of my first judgments, that the survivor would say that he or she was dragged into a forest, away from the road, into a quiet part of the house, into an abandoned hut, and then she would describe, oftentimes because of the age and because of not being familiar with the act, they would be describing it in approximation. They would not use forensic words that we would want, and they would tell you that he committed something bad on me or he touched me here, there, and yet they will not give you the exact word. It is in such circumstances that both the investigating agency and the court, particularly the trial court, has to do justice to both the survivor and to the accused. In most cases, more than 80% of the cases, it is the unilateral statement of the survivor against the stubborn denial of the accused. And these are the areas that I will speak on because that is our area of expertise. The law as established tells us that however young the survivor may be, if the account rendered by the survivor appears to be credible, and if no motive is attributed or ascribed to the survivor, or no motive is apparent to the trial judge, then there is no reason to disbelieve the survivor. In a sense, to all those with law degrees and also to our police officials who should be aware that in the Evidence Act, there are certain things which have to be proved, there are certain things which require to be disproved, there are certain things which may be presumed, there are certain other things which shall be presumed. Now, all these are forensic ways of describing how a fact, when asserted, has to be accepted by the court. When a fact is asserted and it appears to have been done credibly, and by the time the matter goes to the trial court, you would have had the benefit of at least 3 or 4 previous statements by the accused, by the survivor. So the trial court at that stage has the benefit of at least 2 or 3 previous statements and the testimony of the survivor. And on a meaningful reading of the previous statements, together with the testimony of the survivor at the trial, if it is found to be credible, then it is the duty of the trial court to accept it till it is dislodged, which is till it is disproved. How may it be disproved? It may be disproved very simply by an alibi. I was not there. However, merely saying I was not there will not do. I was not there, and evidence that you are not there has to be provided. If that is convincing, then of course it wouldn't have been, the commission of the offence wouldn't have been proved beyond reasonable doubt. Well, alibi does not work. Then next is that she has an axe to grind, she has a motive. Ordinarily, young children, there are precocious exceptions, young children would be very difficult, it would be very difficult to tutor young children to make them consistently recount the same story over a period of time. So if a child has been tutored, and sometimes these are actual harsh realities, because we face, there's a land dispute between the two sets of parents, and the children in one family, the child in one family accuses the adult in another family of sexual assault. Now, in that situation, you would have to ascertain the credibility of the accounts through the various stages. There's one account which you'll find in the FIR or the complaint, which is never of the survivor, but the survivor having narrated it to someone, that someone goes and complains. So there is a initial version of that. Of course, it is trite law that the FIR does not have to be the encyclopedia of the entire case. It only needs to indicate the commission of an offence and the ingredients of an offence, nothing else. It may sometimes be the father. In fact, more often than not over here, and it's very heartening to see, it's the headman who's coming to lodge the complaint. Because when incidents like this happen, the parents go to the village elders, and it is very heartening to see that the village elders in this state are coming forward to lodge the complaint and not hushing it up. As we've had several of the panelists tell you, and as the Act itself indicates, that more often than not, it's a person who is in a position of trust or who has a fiduciary relationship with the survivor who perpetrates the act. There is always a degree of pressure, particularly in the Indian psyche. The Indian family psyche is such that let's hush up this matter, let it not come out in the public. And of course, all the time, it's the girl child who's made to feel guilty. The girl child is made to feel guilty because of her body. You'll have educated persons saying that why does she dress in that manner? You wouldn't find anyone talking of men in that tone. Or because they considered, the family prestige or something to be beyond, they don't want it to be sullied, so they would discourage or they would keep it down. Thankfully, we are getting more and more cases of complaint in this state. People are coming out, and elsewhere where these complaints are less, it does not mean that this is not happening. It's just that people are not coming out to complain or are being discouraged to come out, or matters are being hushed up. Anyway, coming back to the part of justicing, you would also find that there is maybe a 164 statement of the survivor which is recorded. And here I must make a digression, because we have the advantage of so many high-ranking police officials over here. You must know that there is a change in law in Section 164. Section 164 requires videographing now. it must be videographed, particularly confessional statements. Otherwise, they may not have any value. So please ensure that at your police stations or elsewhere, there are videography facilities that you can videograph them. It's simply done on the mobile phones, but the state must ensure that 164 statements are videographed. Secondly, while on 164, while a statement recorded under 164 has to be by oath, when it comes to a confession, that cannot be under oath, because that goes against the constitutional principle of rule against self-incrimination. So if a confessional statement is being made by an accused, and not every statement made by an accused is a confessional statement, that distinction you must also be able to make out. But if a confession is being made by the accused, then that confession cannot be recorded under oath. While on this subject, every police officer involved in investigation should be aware of the simple several provisions from section 154 or thereabouts to 178. It's not too many, but you must be aware of these, and you must also be aware of sections 24 to 27 of the Evidence Act. In essence, section 24 says, or 25 in particular says, that any confession made to a police official will not be taken cognizance of. However, there is section 27 which says that even if a confession made to a police official cannot be taken cognizance of, any discovery made as a consequence of any statement made by an accused, even in police custody, can be seen to the extent of the discovery. Say, an accused tells you that he's committed a murder. The fact that he tells you that he's committed a murder, if you were a police official, that confession would not stick in a court of law. But then if he tells you that he's committed the murder and the weapon has been hidden in the top drawer of a locker at a particular place, and you take independent witnesses along with you and let the accused lead you the way, and the weapon is discovered from there, the fact that the accused was aware of where the weapon was would be relevant for the purpose of ascertaining the guilt of the accused, even if the confession made to you as a police official is disregarded. There are other material like this, but you must remember this. I have the experience of a matter, again digressing because we are talking of, I am concentrating more on how the trial is conducted and what is material at the trial. We had a case of a man in a fit of rage having beheaded his wife. He carried the head of the wife to the police station, confessed, and then indicated where the murder weapon was. The investigating officer thought that that was the end of the story, nothing else was required. But the confession made to the police officer was not cognizable. You could not take that into account in a court of law. And the fact that he had told him where the murder weapon was, but there was no evidence that he had told him, and he did not lead him to that, did not comply with the conditions of section 27. It was an open and shut case, but when that defense was taken, it was an open and shut case also, because neither fact could be taken account of. which is what I stress on, because even though with more and more forensic tests conducted in the forensic laboratories, DNA tests, fingerprints, sometimes the resources available to our investigating agency are not adequate for them to deal with the modern techniques used by criminals. Though it is not the trial court's work to supplement what the investigating agency may have done, but the trial court also has to be alive to the practicalities of the matter. Next, I come to the conduct of the trial in a POCSO matter. There may be several witnesses, and this is a matter like in every other trial where what are we doing? What is the object of the exercise? Let us sometimes not miss the wood for the trees. The object of the exercise is to try and take in the relevant facts from the several accounts, to imagine yourself as being a fly on the wall as if you witnessed the incident. And if the details that you get are good enough to convince you that you can see the thing happening, that is when it would have been proved beyond reasonable doubt. There are many rules in such regard. One of those that we disregard is the principle of res geste, is the conduct of the accused. Sometimes we say that the accused ran away. Merely because the accused ran away does not prove his guilt or does not indicate his guilt. Because an accused, why? Even I will run away from the Indian police. So, no one wants to come up as a witness. No one wants to volunteer information. Because, I'm not blaming the police. They also have, limited resources. But sometimes the measures that they resort to are not very agreeable. And I also blame us. Because a witness who comes to give evidence in court is never sure that the matter would be over that day. Imagine a daily wage earner has come 200 kilometers to give evidence. He's lost his day's wages. And the amount that you give him, the daily expense that the court gives him, is a pittance. He might feel responsible come the first time, but he will refuse to come the second time, the third time. And for want of evidence, you will not be able to decide the matter appropriately. There are many difficulties we face. One of the questions put to Madam was that we should have separate rooms in hospitals. Yes, of course. We should have 5-star facilities in our hospitals. But unfortunately, in this country and even in this state, you can go miles without seeing a rudimentary medical facility. Yes, we should improve. Yes, we should improve today. Not even wait till tomorrow. But it's a matter of resources. It's a matter of a huge population that has to be attended to. And we are still, a developing country struggling for resources. Considering all that, we've made leaps and bounds, both in juvenile justice and in protection of children against sexual offences. There is also duty that the trial court has at the end of the trial. A completely separate duty under section 311 for the ends of justice upon giving due notice to the accused. There are times that we see the judge feels that enough material may not have been produced. The judge calls for fresh evidence or calls for new material. And oftentimes at this stage, a very simple mistake is made of not giving an opportunity to the accused to cross-examine or an opportunity to deal with the materials that have come on record, and that leads to what in American terms is known as a mistrial. And over here, it amounts to complete breach of the principles of natural justice, for which such additional material may be completely discarded by the appellate court or a fresh trial may be required. And finally, more so in POCSO cases than any other, the role that a trial judge has at the 313th stage cannot be overemphasized. First and foremost, 313 is not meant to read the evidence and then say, what do you have to say? 313 is for the purpose of making the accused understand, because more often than not in this country, the accused would be poor, would be uneducated. Because as we are rightly accused of, we punish our poor. Our rich rarely get to the end of the trial of the 313th stage. So the duty of the court is to indicate what is the incriminating material brought against the accused qua the commission of the offence by a particular witness and elicit the response. Again, I think it's a very poor defense strategy by Indian lawyers to advise their clients to say, I have nothing to say, or I do not know, or this is not the truth. But I think it's a safe bet, because if they say to this you have to answer that, to this you have to answer that, the uneducated accused may mix it up and may say the wrong thing at the wrong time. So the trial court has to take care of several things. Not only will the trial court try to ensure that the truth comes out at the end of the trial, but the trial court also has to be alive to the fact that the accused may not have been able to afford adequate legal assistance, that the legal services authority lawyer allowed to the accused may not have had the acumen, may not have had the enthusiasm. Indeed, in one of the matters we found that had happened, the matter criminal trial had taken place before a district thing court, the tribal court, district council court, and it was a matter where a person was guilty of killing a parent and two siblings in the same evening. So the first thought that came to our mind in the appeal court was any psychiatric test conducted? Because it's very difficult to imagine, a person killing three. You have, the stonemen and serial killers, but you don't get people killing two of your own blood or three of your own blood. And we were told that there was something, but it's not of great importance. And it was later discovered that there was a study by Negrim saying that he was not mentally fit to stand trial and that he had some bipolar syndrome. Despite that, a purported confessional statement recorded under 164 was used as the only material, and the District Council Court convicted him, and in the presence of Legal Services Authority counsel appearing for the accused. If a person does not have the sense to understand the importance of a trial or what is about to happen to him, no criminal jurisprudence requires a trial to be conducted. And here, the District Council Court, or any trial court for that matter, has to be especially guarded to see that the rights of the accused are also preserved and maintained and protected. There are certain provisions that I need to specifically refer to. Reporting of offences, as Madam said, there is no choice you have in the matter. If you perceive that an offence has been committed under the Act, when as a medical practitioner or in other courts, line of duty, it comes to your notice, it is your obligation under the Act to report the matter. When you report the matter, you are not proving it. Proof is the result of the investigation and the trial that follows it. But it's your obligation to report the matter. When it comes to pregnancy, I sympathize with what Madam said, that if you are going to be too officious, people are not going to come, which will result in teenage pregnancy deaths or even the death of the child. But I respectfully disagree with her answer that you have to use your discretion. No. You are obliged to report whatever may be the consequence. There will be 10 deaths today, but the message that goes out will act as a deterrent in future. There are also other excuses we hear. Religious excuses, historical excuses, that it's the custom and tradition that people get married at the age of 15, that women after puberty are ready to give birth and are of marriageable age. That is not for the police or the officials who are obliged to report or for the court to see. That is the policy of the state in enacting the law. The state has said that sexual intercourse with anyone below the age of 18 is an offense, period. We do not question the philosophy. That's not our work, that's not our job. Not the police, not the court, not anybody else who's liable to report. There are defenses taken. It was consensual, I'm married. Very well. Serve out your sentence, come and live happily married thereafter. You cannot say that just because they are married, I let them go. No. Offense has been committed. The consequence of the offense is prescribed. Unless and until that law gives your discretion in certain circumstances to disregard or to acquit, we do not have the authority to do so, whatever may have been the custom, whatever may have been the religious practice. It's the larger malaise which is sought to be addressed of the girl child being used as a chattel and of the girl child being subjected to sex upon marriage or whatever at an age where she is susceptible and vulnerable. If 18 years is considered to be the age for consent, if 18 years is the age where you have been given the right to choose, the right to contract, the right to vote, then it's in keeping with the general ethos that a child is defined to be someone who's below the age of 18. And there is no reason why police, other officials, social activists or judges should find excuses to bring about a change in what is the policy of the parliament. No one has challenged the definition of child and said no, child in certain circumstances should be below 14, in other circumstances it can be below 18. So these are needless innuendos that we get into. They are completely irrelevant in the context. In this country, if anyone has sex with a person who's below 18, and sex as defined, sexual assault, harassment, penetrative, aggravated, the consequences follow. There is no choice. I have wandered a bit because there are certain areas that I thought required attention. There's one last section that I would refer to. You know the other ones which are, how the recording of a statement would be made. Madam also emphasized on that. And recording of statement of a child by magistrate. There's some, it is 42A, if I can get to that. Yes, no, before that. Section 29 is of paramount importance. Where a person is prosecuted for committing or abetting or attempting to commit any offense under these provisions, the larger provisions, they end at aggravated penetrative sexual assault. The special court shall presume to discharge that burden, then the defense does not have to do anything, it's gone. The defense is won. But when it comes to a matter of POCSO, then upon the prosecution discharging the initial burden, and what is that initial burden? That this act was committed by this man, prima facie, and that the survivor in this case is a child. These two, the survivor in this case is a child, has to be proved beyond reasonable doubt. Otherwise, it won't be an offense under the act itself. But once the survivor is shown to have been a child, and there is prima facie material against the accused, then the court shall presume. Shall presume is may presume and shall presume. In may presume, the court has a discretion. In shall presume, the court has no discretion. And this shall presume will happen unless the contrary is proved, which means that the accused has to disprove, which is why I started by saying alibi or something else, motive, not only by confusing or raising a doubt, but by affirmatively establishing the alibi and affirmatively establishing the motive. In a normal case, if you raise the doubt and yet do not establish, it would suffice. But because of the wording of this section, unless the contrary is proved, that contrary has to be affirmatively established. I was not there will not do. I was not there because this is my passport which shows that I left India the previous night and I returned to India 7 days later, which is conclusive proof. Nothing else has to be done. I was not there because here is the record, I remained arrested in Bombay during those 7 days. I could not have been in Shillong at that point of time. That's the degree which is required. It's of paramount importance. However, please do not mix up section 29 to think that the age of the child may be kept, flexible. Age of the child has to be proved beyond reasonable doubt to be below 18, or else the rigors of the provision would not apply. There are two things, and I make a distinction from what Madam said. The one thing is that for the purpose of giving the survivor all the protection under the Act, she will be treated as someone whose age is below 18, even if the approximations by the ossification test indicate a bandwidth above. The survivor will be given all the protection, meaning she will make statements in a special manner, she will go to a POCSO court, she will enjoy all those facilities. However, when it comes to conviction, unless it is proved beyond reasonable doubt that the child was a child, that the survivor was a child at the time of commission of the offence, it is not proved. And as our brother Judge Sangma indicated, paragraph 94 of the amended Juvenile Justice Act now is of paramount importance as to how the age of the survivor would be determined. It would be determined just as the age of the juvenile in conflict with law. First and foremost is the matriculation certificate. Secondly, it would be the birth register. Thirdly, it would be some other, including account by the mother or by the parents. But if you get the first, you don't go to the second. If you get the second, you don't go to the third, and likewise. But you've got the first, and the first is proved to be false, then of course the first does not stick. You go to the second, and the second is proven to be false, which is disproved in technical terms, then of course the second doesn't stick. So there is no latitude as far as the aspect of conviction is concerned as to the age of the survivor. But as to the special treatment to the survivor, she will be given the benefit as if she were a minor. That is the distinction that I want to make here. And finally, I'll come to the last provision that I need to emphasize on is 42A. 42A says that the provisions of this Act shall be in addition to and not in derogation of the provisions of any other law for the time being in force, and in case of any inconsistency, the provisions of this Act shall have overriding effect on the provisions of any such law to the extent of the inconsistency. And that is why I started with Section 375. Section 375, in the manner in which it defines rape and carves out certain exceptions, is somewhat at variance with what amounts to penetrative sexual assault within the definition in Section 3. And therefore, if a charge is levelled under POCSO and simultaneously a charge is levelled under Section 376, then it is the definition of penetrative sexual assault without the benefit of the exceptions under the explanations to 375, which will attract. It is not in derogation of, not only that, it also has overriding effect. And so if an offence under the penal code provides for a lesser sentence, but if the same offence is found to have been committed under POCSO, it's the greater sentence under POCSO which will be applicable and not the lesser sentence under the penal code. Unfortunately, there's a matter on which we wanted to, clarify this, but there may not be time before I retire to take up the matter, because both the state and the appellant in that matter are on the same page and do not want the matter to get disposed of right now. Otherwise, we could have, that's why I said that this 42A is of great importance. Finally, I know most of you are very tired after the entire day, but if you have any questions, any kind, on POCSO or any other matter which you would think you would draw my attention to, if it helps, then please go ahead. Anyone? Yes? Sit down and do it. Sit down and do it.
Sir, in special laws, where presumption of guilt is there, so can benefit of doubt be given?
You have to identify whether you are asking me as a police officer or as a judge.
No, as a judge, sir.
As a judge, look, in most cases, it's decided on the basis of circumstantial evidence. Circumstantial evidence is like a chain of events. And the fundamental rule of circumstantial evidence for conviction is that there is no theory within the circumstances which can lead to the probable non-commission of the act by the accused. As you know, a chain, like in any chain, is as good as its weakest link. It can be very strong in all the 24 links, but if in the last link, if it is weak, the chain is no stronger than the last link. So, if there are circumstances which inevitably point to the guilt, for instance, there can be last seen, there are many other. These are rules of evidence, and rules of evidence are not rules which have been got from outer space. These rules are fundamental principles considering human conduct. I'll give you an example. A and B are inside a room. There are people outside, but only A and B are inside the room. And A walks out and says B is dead. If B is found not to have died of natural causes, A has to have an explanation how B came to meet with the unnatural cause. And if A cannot provide that explanation, there is an inference of guilt against A. You see, an elderly man walks with a young girl towards the jungle at 6 o'clock in the evening. The girl is reported missing. Someone says, I've seen that man with the girl. And they go and at 10 o'clock at night find the body of the girl. Now, once it is established, now you must be very sure that the circumstantial evidence part that you see, that cannot be doubtful. If you are convinced that yes, the girl was last seen with this man walking towards that jungle at 6 o'clock. The girl was not seen or heard of thereafter, and the girl's body is discovered, lifeless body is discovered there. The man owes an explanation. In the absence of an explanation, this is enough material against him. But he can demonstrate otherwise. He can say that I took her, but afterwards I took a shortcut. There was a motorcycle waiting, and I rode pillion with that friend, and he shows you photograph or CCTV coverage elsewhere. Then the effect of the circumstantial evidence of the last scene is destroyed. But these are the pitfalls, of trial, because what we are trying to do is, we are trying to reconstruct a scene where we were not present. We are trying to close our eyes and imagine what the situation may have been by hearing the accounts, looking at the demeanor of the witnesses, assessing with our normal intelligence and the bit of expertise that we develop through experience, the manner in which they speak, the manner in which they testify, as to whether they are credible or not. And one of the rules of the game is that if over a period of time you see the verbatim same thing being repeated, then that kind of consistency has to be doubted. Because even if I tell you a story, and unless I'm telling the story every day that I, do the same words all the time, even the same story, if I tell you 10 days apart, 20 days apart, there will be slight inflections here and there. I will concentrate a bit on this and concentrate a bit less on that. There might be some contradictions, some inconsistencies. And human nature is such that with passage of time, your recollection will not be picture perfect. So these are the tests that we, use. If, everything has been said, at 2 o'clock he went there, at 5 past 2 he did this, at 7 past 2 he did that, at 9 past 2 he turned right, at 14 past 2 he did this, you start to worry. Is this a practice thing that is being enacted before me? But if someone says that, I saw dark colored car, and the victim was possibly inside the car, and then the other side questions, was it dark green or dark blue? Was it dark grey or, dark something else? And, even if the answer is inconsistent, even if the car is produced and the shade is inconsistent with the answer of the witness, that may not be the only ground to disbelieve the witness. Because when we are noticing something, we notice the totality of it. I notice you sitting there. 10 minutes later, if you ask me, what was the color of the chair on which you were sitting, I will have no recollection. But if I particularly look at the color of your chair, try to remember all of this, that's not human conduct. When I'm looking at an incident, or when, I have no control over the incident and it happens, I'm not looking at it that, day after tomorrow I'll be a witness and therefore let me look at this, under which people tree this happened, let me see what was the nearest animal, what was the nearest landmark. So you've got to understand human conduct, human nature, imperfect recollection. So little bit of inconsistency adds credibility rather than detracts. And too much of consistency may probably be a kind of rehearsed, practiced statement rather than natural, normal or credible. But all of that depends. We have a virtual world now. COVID has taught us. We have virtual appearances. We have, people don't run from the end of the world to another for having meetings, you can do it virtually now. But one of the most difficult things for a judge is to gauge the submission of a lawyer on the virtual platform. Because, you know, as a human being, communication is something that, you know, we are used to. Communication is not only what you say, it's the manner in which you say, the posture, the intonation, the gestures, everything, all of that together. You know, I can say no and mean yes. No, and I may mean yes. And I may say yes and may mean no, because the manner in which I say yes is a disgusted yes. As human persons, used to ordinary human conduct, most of us will be able to understand that. But on a virtual mode, when you see it in 2 dimensions, and you do not understand the gestures, the postures, the intonation so much, you know, as it comes through a medium, sometimes what is being communicated becomes difficult to comprehend. Because experienced judges know when the lawyer is fibbing. Because that's his job. His job is to convince you. And your job is to find out, you know, what is the truth. It's not an act of deceit. So these are things, you know, which happen, and that's the more elongated answer to your very simple question. But as a police investigator, without being harsh, it's none of your business to assume or guilt or innocence. It's your business to get material and then present the material. Of course, as human beings, you will be, on the basis of the material that you discover, you will be, you know, believing or not believing in the culpability of the person who is the accused. And that will come out ultimately in your investigation. Yes. Any students here? Yes, madam. Any questions? Any corrections?
Oh, no, none at all. It's just that POCSO will a lot more work for you to be able to.
Yeah, absolutely, absolutely. And, you know, it is something which is very good. The developments, all that have happened, are very good to protect, because women and children are the most vulnerable in society. We still do not give enough respect to our women. We still don't treat them as they ought to be. Gender justice is only, you know, almost in form and not in real true spirit. We must strive towards that. And at legal awareness camps, wherever I go, you know, I've told them that you must come out and complain. That does not mean that we will take your husband or your son or whoever mistreats you to task, but we will be able to counsel them. Because for centuries, what we have been doing to our women, you know, unless you're the father of a girl child, you will never understand the tough road that a girl child takes to become a woman, and the tougher road that she takes to survive as a woman. So, you know, all the men folk, we should be more sensitive. I'm told that in public transport, there's not been a woman who's got into a public transport and not been, you know, touched. Now, we respect our mothers, we care for our sisters, we love our daughters. Why can't we have that for another man's brother, another man's mother, or another man's daughter, sister, or wife? One can understand, you know, in those years where you have raging hormones, you do a few wrong things. All of us have done it. But, you know, if we stand up and protest, if we object, then it makes life slightly more easier for women. And we have a long way to go, before we actually give equality to our women in this country. And POCSO, in some measure, has come in to protect children. We've got cases in Meghalaya which are not confined only to girl children. We have matters in which the survivors have been young boys, and those also have to be taken care of. Any other questions? Any comment? Yes, Justice Bhattacharya does not agree with me. Brother Bodenov? What do we do? That's the end? Can I have the last word?
No. I know women love to have the last word, but I should continue.
No. At home I never have the last word. Not even the first.
I just wanted to thank everybody for being a wonderful audience. They have been extremely interactive since morning, and I really hope and pray I haven't bored you too much, but it was very delightful. And I also look forward to all of you working together, as I had mentioned, that at the district level to work together in collaboration so that we make cases of POCSO more just and more sensitive, both to the child and to the accused.
There's one aspect I missed out, and that is for all trial judges. You must be very careful when a survivor is being cross-examined. That is something I forgot. We have to be very sensitive and we have to be very alive, because they are intimidated with questions. They are asked embarrassing questions. They are asked, in an insensitive manner, and therefore sometimes that confusion is kind of introduced to get a wrong answer. And you must be extremely careful and protect the survivor from such intimidation during cross-examination. That's an area that, in several cases we find that in cross-examination, the answers are as a result of, shrinking, feeling afraid. The court must instill that confidence and must, put the lawyer, keep the lawyer in check. That's something of great importance. Thank you. Things like these are boring, but some of the boring details have to be gone through. Have you organized something for them at the end? Is there a tea or something?
Yes.
Sit for 1 minute.
Thank you, sir, for that very strong and insightful session. We hope that all the participants will go back with this very strong message that there are no compromises when it comes to matters pertaining to the POCSO Act. And I'm very happy that we have representatives from all the districts, the BDOs, from the Deputy Commissioner's offices, from all the districts, superintendents of police, and the other officers of the other departments. We hope that you will carry this message to your districts as well. We will extend this similar kind of program to the other districts. And as a token of appreciation to your Lordship, we have a small token to give you.
But there are more worthier.
So we have a token for the panel members as well. Kindly allow me to give them.
I already got mine in the beginning before.
You deserve a second one.
No, it's Chancellor, I did that speech on, so it's better to.
So we have come to the end of this program. A big thank you to each and every one of you. We hope to see you again. We will be conducting further refresher programs on this topic, and we wish you a very pleasant evening. Thank you.